Good morning. Good morning. It's 9:30, so we'll resume the inquiry. So today we have the appellant's evidence on planning, Mr. Jones. Is there anything before we start?
I think Mr. Mohammed and I had discussed just the running order today, and we wondered whether it would be worth just dealing with the Section 106 first. I think I indicated yesterday that it's Mr. Humphreys dealing with it for the council today. And he's come down. He's had quite a long journey, and obviously we're very keen to kind of just get that session done. So we thought it might just make sense to deal with it first off.
That's fine with me.
He can then go off and start his long journey back, and then we could carry on. So I think the parties are in agreement, but obviously it's a matter for you whether you were kind of wanting to carry on with the evidence and deal with that later. I don't know.
I'm happy to do the 106 now.
Okay.
Yeah.
Thank you.
Just one other small thing whilst we set that up. We're very keen to finish this week, and I've spoken to my learner friend about that, and I think it's only fair to give her a bit of time after the evidence today, so not to close tomorrow, but we're very keen to finish on Friday. That works for us, and it works for my learned friend. We're just going to check whether that works for you.
Yeah, that's fine.
We could do that remotely as well.
Yeah, that's fine. So will the council set up, the link? Yes, okay, thank you. Okay, yeah, that's great. Yeah, just make a note of that Friday. What time should we do that?
Relatively relaxed. Do you have a preference on timings?
What do we think? 1?
In the middle of lunch?
Earlier, later? I don't know. I mean, we don't want to... I know we'd said about an hour each, hadn't we?
Yeah, I might be a bit longer.
Yes, exactly. That's what I'm thinking, because you were longer in your opening. So, so what we don't want to do is start at 2 and then find that we're pushing on to 5.
I'm happy to start in the morning.
Yeah. Okay. I think I prefer the afternoon, but as to exactly what time, I don't know.
I'm fine with that, but I mean, basically from my part, after 3 o'clock, my house will get rowdy with small children.
Yeah.
And we talked about the cats as well last week, so I don't know if you're going to have similar problems. But, I mean, let's see.
11 then?
Why don't we start at 11 and then see how we go?
I'll put 11 a.m. on Friday. Right, thank you. All right, I'll just get the documents up for the...
CD 511, I think, is the latest version.
Okay, right. I hope that's the one I've been looking at, because I had one emailed to me. I think it was just before the inquiry started. So, yeah, there's a big fly there.
Yeah, it seems to be very attractive to me for some reason. I don't know what that says. Do I actually have that?
Do you want me to forward? Yeah. What had happened, Madam Inspector, was that the solicitor for the developer circulated something on Friday, which I believe you've had sight of, which had 2 final minor amendments, I believe, to clause 7.2 and to the trigger points in relation to open space at Schedules 4 and Schedules 9.
Okay,
which was like the final sticking point, if you like.
Right. Okay, so I can't remember when it came to me. It was the second version anyway. I think I got it, oh no. I don't know, I can't tell when I downloaded it. If that one that's on the core document list, then that's the one I've got.
I believe the one on the core documents list, Madam, at 5.11 is a slightly earlier draft. That was the draft I believe was circulated around the 14th. That's gone up as core document 511. That was subsequently modified, as Mr. Humphreys just explained, and circulated by the appellant's solicitor, Mr. Martin, I believe, last Friday. So I think that's the copy you have.
Okay.
And that copy is yet to be uploaded. So if you'd like us to, we can upload that as an ID document today, so that that's on.
Yeah, you could just replace, oh, I don't know. I mean, it might be more straightforward just to replace the one that's in the core documents with the latest one, because it can get confusing.
Yeah,
We should give it an ID then.
yeah. I think we're all in agreement. And that's probably the best for transparency purposes for the public who might be interested.
Yes.
We can arrange for that to be uploaded. I think the next ID document number is 11, possibly,
Okay.
from recollection. But if you're happy, we can put that on.
Do we need it as an ID document? I don't think we do. I think just have it as a core document and just substitute the one that's out of date. I think would be the best thing to do.
Okay.
I think. I mean,
Well,
I
either
don't know
that, or
whether,
we could just put it as the next number in
Yes,
that
you
relevant
could do that,
section and just
yeah.
call it updated and put the date so that
yes,
there's a reference to it.
actually, yeah, and then I can't
Okay.
imagine that many people will be looking at it, but just in case, yes. Yeah.
I think, and in light of the Isle of Wight case recently as well, in terms of public consultation on the 106 and things in draft form,
Oh,
we just
right,
need to be
okay.
mindful that people might want to look at it.
Fair enough.
I'm not sure that
Yes.
people generally do. Mr. Mohammed's laughing. They're not the most entertaining of reads, but
Yeah, I agree.
okay, so with your
yes.
agreement, Madam, we'll put it
Yes.
up in the right section of the core documents with the next number in sequence.
Yes,
Okay,
thank you.
thanks.
Yes. Right, okay, so I don't have an awful lot of questions on this.
What we suggested, if you would like, but you may not, but my learner friend suggested that a solicitor on behalf of the produce the document for you. I mean, but if you've already read it, seen it, and you just put what is on your mind,
Yeah, you can introduce it to me. Yes, thanks.
Sure. No, that's fine. I've got the document open in front of me, and it opens at 106 pages. It follows in the sequence of the Table 1, the committee report. Largely, it's evolved since then without much changing, to be fair. And it is a largely agreed document. I think it has as many as 20 obligations. If you track back the progress from the planning committee document, the Table 1, that forms the basis of the SIL compliance statement, and it is consistent with that. So I don't propose to go through every single page in depth, but I think the first chunk of the document is largely the introduction, what the index, etc., and the parties there with unilateral undertakings to the county council, which apply to some sections. The explanation as to title and the history of the matter, the recitals when it went to planning committee and was refused, etc. And then all the definitions, as you'd expect. The sort of active parts beyond that are schedules primarily relating to affordable housing and green space and various financial contributions to be given. I'm scanning through as I read it now I'm not doing it fast enough, to apologise. I think that it's fair to say that, as I said, it's consistent with the Table 1. There has been some dispute, which we need to draw your attention to, about the affordable housing cascade, which I believe has been mentioned in the position statement as well, with both parties there having their say on whether that's required, and ultimately that's being left down to yourself, I believe, Madam Inspector, to make that decision. You can maybe go on to that more if necessary, but the nuance, the final bits that we've been between the developer and ourselves discussing has been the trigger points for the amenity open space at Schedules 4 at page 45 and Schedule 9 at page 55, where we've come to a suitable compromise between the developer and the planning officer as to when the trigger points would take place. I think the council initially wanted them earlier and the developer later, and we came to an agreement whereby a suitable compromise to start one earlier than the other with those two schedules, so that I suppose the main argument there would be that those people that bought, if the development is built out and people are to move into the earlier built houses, that they don't have no green space, etc. They don't feel disadvantaged, if you like. That's why there was that discussion about having those trigger points somewhere between the two positions, and that compromise has been reached. I think a lot of this, again, as I say, is non-controversial because it is consistent with the Table 1 requirements that were in the planning report, and that's given us a sound basis to work on, and there hasn't been much dispute apart from the affordable housing cascade. If you want me to go through any particular parts, we do use a standard precedent that the council's evolved over time, and we've had various discussions to try and ensure that it's a workable 106, basically.
Okay, thank you.
Could I introduce Mr. Jack Martin King, who's sitting next to us, the gentleman here on behalf of Hallam, who may have better answers to your questions
Yeah.
than you will. So I just thought I'd ask him to be here as well.
Yeah.
You can say something. That's okay.
Thank you, ma'am. Just one minor correction, if I may. Sorry, I've forgotten your name already.
Mr. Humphrey, yes.
Mr. Humphreys, apologies. Mr. Humphreys, in his introduction, said that the schedules follow Table 1 of the committee report. That is correct in all respects other than the primary school, because there was a reference to primary school in Table 1. That wasn't a request from the County Council on the basis that, as I understand it, there is adequate capacity at Hamstreet Academy. And that point is addressed in the planning statement of common ground.
Okay, can you remind me what it says, please?
Simply that the committee report, that part of the committee report, Table 1 primary school, was an error, and that shouldn't be sought as a planning obligation, that financial contribution.
Oh, but it is in here, is it? Is it?
No,
No.
it's not in the 106,
Right,
no.
okay.
No.
I think just to clarify, that came about from a request from KCC to the previous planning application for 170 homes. They requested a contribution towards primary education, but not for the 140 home scheme. So that was an error that was carried over from the previous application. That was the reason.
Oh, okay. Right, thanks.
Another thing I was going to note, Madam Inspector, is, again, to be even-handed, there were a couple of schedules added by Kent County towards the end, the SEND contribution and the waste contribution that they had requested, and the developer did not object to the amounts they'd requested or the need for those. So those weren't, I don't believe, covered in the initial committee report, but have been added subsequently and with the consent of all parties. That's Schedule 20 and Schedule 21.
Right, thanks. Right, okay. Shall I just scroll through my notes? Are you ready for that? So,
Yes.
yeah, okay. Right, so my first question is it's on page 12, but it's to do with you might want to start on page 11, 2.6, paragraph 2.6. It's about the cascade, affordable housing cascade, and it's the last sentence of paragraph 2.6. I'm just reminding myself what it says. Shall I state? Is that saying, I just need to be a bit clear on this, is that saying that I would have to say in the decision letter whether or not, I'm just confused about what it's actually asking me to do.
My understanding of it is that it's dependent on you expressly stating that the affordable housing cascade is required and will have legal effect. So unless you state that, then it won't do, even though it's in the agreement. So basically you have to expressly state it is required. Basically it's saying that you've considered the issue and found it necessary. So it's been left in there as a sort of alternative, and the wording of 2.6
Yeah.
draws that specific attention, so that one way or another you have to address that and make a decision upon that, because it has been that sort of sticking point between the parties as per the position statement that the council don't believe it is required and the developer insists that it is. So that's the compromise. Where we
Okay.
can't agree, we're leaving it to your authority, I suppose.
Right. Thanks. I'm just scrolling slowly so I don't miss something. I haven't got an awful lot of questions. Oh yes. In terms of the commuted sum calculations, for the affordable housing, if the cascade effect did take place, is there anywhere that says what the commuted sum would be?
Yeah, I believe it's subject to the calculator in the appendix. Is that appendix 3?
Oh right, okay.
I need to.
There's a formula that the council uses so the actual figure won't be there because you're not meant to set the actual figure at this stage. But the council has a formula, and I can't remember where it is in the appendix. But then that's all subject to the council agreeing to what that commuted sum looks like.
Okay, but does it say in the section 106, does it cross-reference to the formula?
Madam, you'll see on page 38 there's a definition, it's a defined term,
Yeah.
the affordable housing commuted sum calculation, which sets out how that has to be completed in
Okay.
accordance with notes at appendix 3 or any replacement notes.
Right, yeah, sorry, I've seen that.
So it sets out how that would be done.
Yeah, sorry, yeah, I obviously missed that. Oh, sorry, I'm scrolling back up. I had a question about the notices that would be served on the council. And what happens if the council, if the notice is served to change the mix of affordable housing, or if a notice is served to say that a commuted sum should be paid instead? What happens? What's the procedure for the council determining the notice, and what's the criteria for them to decide to make a decision?
Okay, I'm gone too far up. Apologies.
Yeah.
To try and work out where you're up to. There's the covenants. Yeah, gone beyond the cascade. It's 2 point. It's it. Yeah. So I think we're looking at page 34 of the draft I've got around the provision 1.1 change of tenures. I think we're talking about that in terms of
Yeah.
yeah.
And, well, 1.2A, I think. Yeah, but you know the gist of what I'm... Yeah.
Yeah, so hopefully what's in the clause directs us to the procedure it would go through, that again, once the relevant council development manager has approved a proposal, then the provisions come in 2.3 to 2.5. So therefore, it's dependent on the reserve matters, I believe. It's dependent on basically certain hurdles being cleared, and then the affordable housing commuted sum as per the appendix. I think I'm just double checking. So sorry, Madam Inspector, your question is saying what happens then in terms of what actioning that, in terms of ensuring it happens?
No, well,
Or-
it's just if the developer goes to the council and
Yeah.
says this mix is no good, I can't find a registered landlord to take this on.
Yes.
We want to change the mix. Here's your notice. I'm just what mechanism? How does the council decide? What criteria? Whether they agree to that or not? I mean, I know there's a formal process of trying to change a section 106, but presumably, if the council don't agree, they'd have to go down a more formal route.
Yeah, I suppose that the development managers are bound to consider reasonably
Yes.
what's put forward.
Yeah.
So therefore, you'd hope that between them that the proposals put forward will be suitable, and that you can come to that. I take your point that what if a stalemate is reached?
Yes. But there is a mechanism. I can't remember what section it is under the Planning Act to try and change a.
What, to vary
Yes.
106?
Yes.
Yeah, so ultimately, the cascade's designed to... Sorry. Yeah. The cascade's designed to say, well, if we do have this specific problem, then these are the steps we go down. So it will depend upon how... I see what you're saying. It depends upon the reasonableness of the planning officer
Yes.
in reviewing it.
I think in terms of your question, Madam, as well, in respect of whether there would be a need to vary the 106, I think the provisions are set out such that that wouldn't necessarily be the case.
Right.
The drafting of the 106 seeks what we call an affordable housing plan and an affordable housing scheme to be submitted along with the reserved matters detailing the mix and split of the 10 years, the size of the properties, for example, whether they're 1 bedroom, 2 bedroom, etc., and the layout of those on the site pursuant to the reserved matters. And that's all part of this section of drafting where the cascade basically says that, if the mix as set out required by policy isn't going to work, you then serve the change of 10 years notice, and those affordable housing plans and schemes would come in to be reviewed and considered by the development managers.
Right.
And if they feel that that is an alternate mix of 10 years that provides a suitable mix, considers local needs, considers borough-wide need, etc., then that approval process follows through with the cascade drafting. And of course, if that then moves through to the next stage of the cascade and that isn't agreed, and you work your way through the draft of the cascade, and you could potentially end with the commuted sum payment instead, calculated in accordance with the calculator that's appended. But in essence, it gives the appellant the opportunity to revise the offer that they make so that it is slightly different from the policy position, but which may ultimately be acceptable to the council's development managers when they're considering local need, local circumstances, and so on and so forth.
Okay.
Or may not.
Or may not, of course, yeah.
I think it's worth adding that that's why the subsections C and D on that page are there, involving the providers. So it's disseminated, so it's not just all on the shoulders of, hesitant to say a rogue officer, but just one planning officer. There is that level of dissemination of the information, so that it's not standalone. It's an informed decision, I suppose, is the sort of phrase.
Right.
Comes to
Okay.
mind.
Madam, just one further point, just to add another layer onto this in the sort of, if I can call it boilerplate part of the section 106, there is a sort of standard clause about approvals, which has a requirement that any approval, I've just used the word approval, but any approval that's required under the deed shall not be unreasonably withheld or delayed. So obviously, if there was a good reason to withhold it, then that would be, that would be fine. But it just adds that additional. I think you wouldn't really need it because obviously the council would have to act reasonably anyway. But that's just a further kind of level of, I suppose, security in terms of the process of an approval, that it does have to be, done reasonably promptly and not withheld for unless there's a good reason.
Okay, all right, thank you.
Can I just add one short point, Mum? Implicit within paragraph 1.1, 1.2 and 1.3, the operational effect of it relies on an evidential burden on the applicant.
Yeah.
They will need to bring forward the evidence to substantiate whether they have been able to secure the first affordable housing scheme and what is required for the alternative affordable housing scheme, or indeed what is required in terms of the commuted sum. And the role of the development manager will be to assess that information and to reach a judgment using Ms String's terms about not being reasonably withheld. Have the developer satisfied the local authority or not in those terms? So there is that judgment process which isn't captured in the legal drafting, it's implicit within it, and it's intended it operates through those steps effectively. It's not a race to the bottom by any stretch.
Right, okay, thank you. I think I had one more question. It's quite a long document to scroll through. Yeah, it's about the primary health contribution and the query. Sorry, shall I let you get there? It's on page 75.
Okay.
And under owners' covenants. And I'm not saying it's wrong, I'm just asking about it. So the covenant is to pay to the council the primary health contribution. So I'm just wondering, why is that paid to the council? Because the council, I'd have thought, don't provide primary health care, especially GPs practices.
I think that at 3.1.2 the council pass it on. I think that's covered there.
Where's it
the
covered?
ICB, bottom of page 76. So the council agreed that it gets paid to the council at 3.1.1.
Right.
And I suppose it's implicit that it then goes to the ICB as defined already in the document.
Right, that's fine, thanks.
So that links that together, yes.
It'll be the weekly test, madam, apologies.
Okay.
Working.
That woke everybody up.
Just glad I just finished.
Apologies.
At least we don't have to go out to the car park. Right, let's recover from that.
I think we did say last week, only for it not to happen.
Yeah.
Say it did happen.
That's right, because, anyway. Okay, page 78, and I probably need to read this plan. I didn't read it last night, about the pedestrian improvements. So it's on the table, the first box, and it says it comprises the provision of painted surface treatment to delineate the footpath along with associated direction signage, lighting within the car park, blah, blah, blah. So it's the provision of painted surface treatment to delineate the footpath. Is that, sorry, I should have checked the plan. Is that on the plan?
Yes.
Because I think the discussion was yesterday that you couldn't paint a separate footpath.
We're going to look at that plan today.
Yeah, I think we'll come.
Okay.
We'll look at that plan when Mr. Jones' evidence today anyway. We have that on our agenda.
Right, fine. Don't know if there's anything else. Just let me check. Yeah, there's just one query I had, and I'm sure you can explain it to me. So it's between, let me go back to the front page. So the section 106 is between Philip Wassell-Collick, Hallam Land, Ashford Borough Council, and then with the unilateral undertakings to Kent County Council. So it's okay that they're not party to the actual section 106. It's just that the council will undertake to pass on contributions or whatever. Is that right?
Yeah, and to be clear, they have been involved. They've been consulted. They've seen the draft and commented on occasion about the figures involved and the mechanisms, etc. So they have had a role within, all right, it's been primarily the council and the developer, but the county council's solicitor has seen and had opportunity to comment and agree upon. So yes, that is how it operates, and they have. It's not a surprise to them completely. Obviously, like I say, that they did do the addition of a couple of schedules at the end that I mentioned earlier, and some of the schedules clearly, explicitly relate to things that they deal with, and that's covered in the drafting as well.
Yeah, okay. Right.
So it's something we do quite often, the nature of the borough and the county's relationship with planning.
Because they're
sections.
linked.
Yeah.
Yes.
Yes.
Right. Okay. All right, that's all the questions I had. Thank you. Yes.
Mark, can I just check, did you have any questions for either of the parties on the position statement that was provided to you to set out the positions on the cascade?
No, I mean, I did read it, but I didn't have any, I mean, I understood what I read, so I didn't have any particular questions, unless you want to explain it to me.
No, not at all. I just wanted to make sure that you were happy
Yeah.
with that. Thank you.
Yes, thank you.
I wonder if we could just mention the consultation period for placing the 106 on the website. I think we discussed that there was that final agreed draft which was circulated on Friday. I think the point for us is when should it be uploaded? Possibly tomorrow?
It's gone up already.
Oh, it has gone up. Okay, great.
It's going
And what period would you think is the suitable period for consultees to respond? I think. Yes.
Under the recent judgment from the Court of Appeal in the Isle of Wight, it's
That's not about consultation. Sorry, go on.
No, go ahead.
I was going to say that's not really about consulting people. That's more about advertising it and making sure that it's available in a public forum for people to see it before it's executed. So you're not expected to actually get people to consult on it and tell us what they think about it. That's my reading of the judgment.
It's definitely not a duty to consult, I
Yes,
agree, but,
exactly.
but equally there is a requirement for us to publish it in draft form in case somebody does want to. And I completely agree, it's not a duty to consult on it, but if somebody does comment, given we've had a number of interested parties and 1,200 local objections to your client's application, I think it is reasonable to allow at least a period of time just in case.
I'm more than happy for you to advertise it. I'm
Yep.
more than happy for you to put it on the public domain, but I don't want the interpreter to walk away thinking that there is a formal period of consultation required, after which she would have to then have to either make representation or she would have to look at it. That's not what, you know.
Well, what I think we've got to decide is whether anybody would be prejudiced by the amendments that have been made to it. I don't know if they. I can't remember. I don't know what they were. What were they? What were the
It was
changes?
just a trigger, it was like 2 trigger
Yes.
points, wasn't it? That's
Yeah.
what it was. So the previous draft has obviously been on the core documents since before we opened the inquiry, or just about the time we opened the inquiry.
It's listed on the 16th,
Yeah.
so it's been up for about 8 days.
Yeah.
Right.
And obviously
okay.
we're discussing, it's substantially in the same terms. We've had an open forum which the public can watch this morning,
Yes.
discussing the terms of it. I think that the case in question is a bit more nuanced because it was specifically dealing with requirements under the Development Management Procedure Order, which was relating to the determination of applications, but we're obviously a step beyond that. So without getting too kind of into the legalities of it, I think provided, I mean, there has already been a substantial period of publication, but I think it probably does make sense for it to be published. Obviously, you won't be determining it for
No.
a little while anyway,
Yeah.
so I don't think it's something we need to be too worried about, but I think it's worth noting and making sure it goes up on the website as soon as possible, so that there then will have been a sufficient period for it. If anybody does want to pop up and try and say something, they can do. But I agree, certainly no requirement for there to be any kind of further consultation or for you to receive any representations or anything of that nature.
Yeah, I mean, I don't think there's any reason for anybody to write in about it because it's been up. The other one was up, and there's nothing that's significant that's changed that would affect anybody. Right. Okay, but yeah, it's up now, and so I just would need the signed version, and I can give 2 weeks for that, so that should cover it, if that's all right. It's quite generous, isn't it?
Until you find out that one of the landowners lives on the Isle of Jersey, and you can only get like a hard copy on a plane that only leaves on a Thursday morning. But I think 2 weeks is great. Thank you, Mum. With your permission, may I introduce Mr. Jones, please?
Yeah.
I've got a list of documents, including the plan that you mentioned. I'll start from the top. Mr. Jones's proof of evidence, Mr. Musk's proof of evidence, the local plan, which is 6.1, core document 6.1. Mr. Jones's proof is 11.5, Mr. Musk's proof is 11.9, local plan 6.1, the inspector's report 4.3, design and access statement 1.6.
Sorry, inspector's report on the local plan?
Yeah.
6.3.
Yeah. Sorry, 4.3.
From 4.3?
Yeah. Is it 4.3 or 6.3?
6.3.
I think you're right, 6.3. I've been
Sorry.
6.3. Design and access statement, we've already looked at 1.6. The planning statement of common ground we looked at yesterday at 5.8. And the highway statement of common ground, which we also looked at yesterday at 5.9. And then the public rights of way plan that we were just discussing as part of the section 106, that's at 2.8. You got all of that? I think
Yeah.
if we can make a
Thank you.
start, and then I will formally introduce the appellant's final witness. Good morning, Mr. Jones. You're not.
Good morning.
Thank you. Mr. Jones, in his proof of evidence at page 3, sets out he's a chartered town planner with a member of the RTPI for 25 years, practitioner member of the Institute of Environmental Management and Assessment, and an associate member of the Association of Project Management, Bachelor of Arts in Local Economic Development and postgraduate in Town Planning. I can take the rest of that introduction of his qualifications, ma'am, as read on page 3. And just it's worth highlighting a few other elements in relation to Mr. Jones's experience, which I think is quite relevant for today. On page 4 of his proof of evidence, you will see he acted for Hallam Land in respect of Court Lodge, the allocated site in the local plan, which is now part of the south of Ashford Garden community. On page 4G, and then his involvement and following the issues around nutrient mitigation. On I, he's been involved in this scheme since 2023. And then on J, he relies on the other evidence that's available. So I think we can take the evidence formally as read, ma'am. Mr. Jones, I'm going to invite you. Sorry.
So no, just before we begin, there's a bit of feedback, and I don't know, madam, I can see you've still got your microphone on. I don't know if it's that or if there's something else.
Yeah.
Is it
Hello, hello, hello. That's better. Oh, no, that's better. Yeah. Thank you. Thank you for that. Mr. Jones, I'm just going to ask you, hopefully, very few questions that we haven't sort of covered already in some great detail. The first is just to give the inspector your summary of what the previous scheme was that we know about 170 units and the current scheme that's in front of her and why that change took place, please.
If I could ask you, ma'am, to turn up the design and access statement, CD 1.6. So as Mr. Mohammed has said, I was first instructed in 2023, and I was involved in preparing that application, the first application. And in the design and access statement, on page 40, page 40.
PDF page 40. Yeah.
You will see the scheme that was the original planning application that sought consent for up to 170 units, and you will see the arrangement of development proposed on that plan. I just ask you to note in particular the development on the eastern side of the site and north of the public right-of-way. And if I could take you then to page 50. Page 50 is the appeal scheme, and in contrast you will see that the development on the easternmost part of the site has been removed, and the development...
Just pausing there, you mean, I think it's PDF 51, I think. What you...
yes, apologies. 50 is the written text.
Yeah. 51.
51. The eastern development block has been removed, and the northern development block, north of the public right-of-way, has also been removed. And the consequence of that is the reduction in scale. Rewinding to the summer of 2024, we had begun as a team to consider the representations that were being made in relation to the application, and I recall having a conversation with Mr. Musk about the prospect of amending the application, but the local authority's decision was to take the original scheme to planning committee for refusal, and then that was withdrawn. That was August 2024. It was withdrawn.
Thank you. Can I move on to a conversation that is a theme in this inquiry? This is covered in section 3 of your proof, and it's about the borough-wide considerations and the spatial strategy where we are. Just give the inspector the benefit of your understanding of the borough-wide considerations in Ashford and what are the general sort of constraints and opportunities that exists in this borough.
I refer in this section to 2 distinct spatial areas, and that's a reference to the local plan. And they exhibit very clear and distinguishing characteristics. Firstly is the urban area of Ashford, the largest urban area and rightly the focus of most development. And then there is an extensive rural area beyond Ashford. And that's made up of a number of smaller settlements. Tenterden is the second largest settlement in the borough after Ashford, but is only 1/10 of Ashford's scale. So that gives you an appreciation of the comparative differences. And then there are what are referred to as 3 other rural service centres, Wye, Charing and Hamstreet. And in the paragraphs that follow...
This is your section 3, page 12 onwards, I think.
Yes.
Is where you set out. Page 12, we can see Tenterden and then Charing, Hamstreet and Wye. And then you've got a table on page 13 with the list of settlements, the dwellings, those within the Stour catchment, those within or adjacent to a national landscape. Sorry.
Under the 312 heading Charing, Hamstreet and Wye, and I give various references there to documents that were current at the time the local plan was being prepared, which talk about the role and function of those other rural service centres. And the conclusion from those is clearly embedded in the local plan that they are suitable and sustainable locations for future development. The table then essentially looks at the settlements that are listed in policy HOU 5 and identifies the scale of development that was allocated to them. And you will see a distinction very clearly between the scale of development at Charing, Hamstreet, Tenterden and Wye and the other settlements. And then in the right-hand columns, whether those settlements are within the Stour catchment or whether they are within or adjacent to a national landscape. And you will see that Hamstreet is the only settlement, the only named settlement in the spatial strategy that is absent of either of those constraints. And I recall both Mr. Withicombe and Mr. Musk saying it was, in Mr. Musk's words, preferable to direct development to the least constrained settlements in those terms.
Thank you. Moving on to, so that's the borough-wide considerations, and we've covered a great deal of that already. Could I then now just deal with the planning statement of common ground? 5.8 of the planning statement of common ground, please. Sorry, bear with me. Just to help the inspector understand the list, I think 3.5, let's start with 3.5 of the planning statement of common ground has the list of facilities and where they are located, and then section 4, page 4, Hamstreet, 4.1, Hamstreet is a large village with a good range of facilities and then it sets out what all these facilities are. Just your comment on what the inspector will find at Hamstreet, please.
You will find a good range of local facilities. Educational needs, primary and associated nursery, healthcare in the form of doctor, surgery and dental clinic, convenience store providing day-to-day needs, a public house, restaurants, and also sports and recreation facilities. And those were the facilities present in Hamstreet that led to its identification as the Rural Service Centre. So the characteristics that existed at that time remain at the present time.
Mr. Musk yesterday very fairly accepted that the development of 140 dwellings at Hamstreet would not displace the spatial strategy and it would not impact the spatial strategy as we currently understand it, both now and in the emerging plan. Just your comment on that, please.
I'm not surprised by that conclusion. I make something similar in my evidence. It's very difficult to comprehend how 140 dwellings at Hamstreet would unsettle that spatial strategy. Even with the development that's already happened, the overall quantum doesn't exceed what's identified in the other rural service centres and doesn't get close to what Tenterden is providing. So it remains of an appropriate scale within the overall settlement hierarchy.
Great. And then just thinking about, we don't necessarily need to turn it up unless we do, but MPPF 110 we discussed yesterday, and about sustainable development and the approach to that. Just your comment on that, because I think one of the things that Mr. Musk again very fairly accepted yesterday was that this is an aspirational rather than an outcome-based policy. Your comment on that, please.
It's a direction given by government to the planning systems and the custodians of the planning system as to how new development should be arranged spatially. It's clearly intending that there should be an active management of patterns of growth to achieve the objectives in paragraph 109 above.
Okay.
The achievement, the ability to achieve a sustainable pattern of development. What's not possible, of course, is the regulation of people's behaviour. You can provide opportunities, but you can't dictate how people will then choose to behave.
Now I'm just going to move on to the question of housing generally, and the kind of questions that we went through yesterday a bit. The housing position, I think at page 25 of your proof, sorry, we start at page 24. You're looking at the Ashford Borough Local Plan, and then over the page at page 25, you go on to look at SP2. Just your reflections on what parts of SP2 in particular we meet or fail to meet, and your thoughts on that, please.
If I can just turn up at SP2. So SP2 sets the strategic housing requirement, 13,000 dwellings between 2011 2030. Sorry, 2018 and 2030, and it's 16,000 from 2021, the beginning of the planned period. Mr Musk fairly accepted yesterday that the council are failing against that measurement. So clearly granting planning permission that would deliver more housing within the planned period would positively contribute to the achievement of that strategic housing requirement. I think it was also accepted that the only way there could be an improvement towards that housing requirement is the grant of planning permission.
And then very briefly, how long has it been since the local authorities had a 5-year supply?
I believe it's since 2021 there hasn't been a supply.
Are they likely to meet their needs within the planned period as it's currently left?
No.
How would you characterise the affordable housing need?
Acute.
And what would you say about the statutory build that comes with what we're proposing?
So the self and custom.
Sorry,
build.
self and custom build. I meant, what would you say about that?
The council also hasn't been able to provide the necessary number of plots. This scheme, in contrast with other schemes, I have to say, provides the 5% that's being sought. Elsewhere, a lesser proportion has been secured on planning permissions that have been granted.
Mr Musk also accepted that insofar as the new local plan is concerned, nothing is likely to happen, certainly this year, and certainly not before this decision is out. Just your comment on that?
I'd agree wholeheartedly with those views. I think it's more likely that we are several years away from a new local plan. The local development scheme anticipates it being adopted in 2 years. I have to say, in my experience, I think that's optimistic. But in any event, even if that were the case, a material supply of new housing land pursuant to that local plan is further beyond the 2 years.
Now, in my learned friend's opening, there was a very fair acknowledgement, and I don't want to mischaracterise what she said, but it's in her opening, very fair acknowledgement of how important housing is. What's your view on comparing what my learned friend had said in her opening and what Mr Musk was prepared to agree as part of your negotiations on the Statement of Common Ground?
Mr Musk wouldn't agree that the housing benefits of the scheme were important. Ms String included that in her opening. I was struck by that difference.
Thank you. Moving on to the next topic, which is about the criticism around the criticism on the focus on accessibility. So the accessibility point, I think, again, we've covered a lot of ground, and I'm sure you're going to cover more ground with my learned friend this morning. So I'm just going to try and focus on the bits that I think are critical for the purposes of our evidence today. It's common ground that all of the village's facilities are within the 2 kilometres of the site.
Yes.
It's common ground that we've seen 1,600 metres being the furthest distance from the furthest house, and everything else is less than that. Just taking a step back, before we get to gradients and stepped accesses and Fairfield Avenue and all the rest, just take a step back and just give the inspector the benefit of your experience of just those distances and what they mean for a development of this scale, please.
It's significant that the facilities and services within the village are within 2 kilometres. That's generally understood to be the distance where there is the opportunity for trips to be made by walking. So as a global view of it, we have the day-to-day services that I referred to earlier, all within that 2 kilometre threshold. And I see that as significant.
And again, I'm going to go through each and every single one of the criticisms that Mr Musk charges against us, but just again giving the inspector the benefit of a global position and just to cut through this. What do you make of the sort of various barriers being suggested around whether or not people will take up walking and cycling? Before I get into gradient and quality, but just your view on 2 kilometres, whether people will actually take those opportunities.
I haven't been able to identify a physical barrier that would preclude someone from walking to those facilities if they chose to do that.
And yesterday we had a conversation about the quality of the routes, and again, your reflections on, I don't want to go back over the way that Mr. Musk decided to identify and sort of, what's the word I'm looking for, define quality, but just your view on his understanding of what it means to have a quality route, please.
If I give my view first and then perhaps deal with Mr. Musk's opinion of it. It's clearly the case that there is going to be a difference in the type of route that can be provided in a rural context versus an urban context. And we don't need to walk very far from the inquiry venue and you'll see significant pedestrian and cycle intervention on a scale that could never be conceived of in a rural context. What we have in Hamstreet is a existing network of walking routes that are actively used. And there are comments about needing to cross roads and the width of footways, etc. Clearly none of those factors constrain local residents from walking to local facilities at the moment. If they were so significant a barrier, then I don't see how Hamstreet would have the designation that it has. Turning briefly to Mr. Musk's view of it, it was very difficult to comprehend what it was he envisaged a high quality route to be. He simply cast the aspersion that our route wasn't of sufficient quality.
Can I then ask you about Mr. Musk's view of attaching limited weight to the statement of common ground from the Highways Authority, his Highways Authority, his statutory consultee? He said he was only attaching limited weight to their position. I mean, have you ever seen anything like that before?
Not in my experience, no. I was surprised to see that categorisation of a statement of common ground with a statutory consultee. I would be heavily criticised if I came to an inquiry adopting that position.
First criticism is around, I'm going to put this as a heading of the convoluted route. So the criticism being that there will be a convoluted route. And one of the criticisms is that there would need to be a need to cross Ruckinge Road south of Carter's Wood. Just your view and KCC's view, and then what you make of Mr. Musk's view, please.
I accept that the northern route would require a crossing of Ruckinge Road, as it is at that point. People already cross Ruckinge Road because of Carter, the residential enclave that is Carter's Wood to the north of it. So that won't be a new movement, shall we say. The County Council would have been mindful of the implication of that drawing and the need to cross the road. And they formed the view that that was unacceptable, movement. Clearly they felt the traffic levels now and in the future did not make that a dangerous journey. It's also worth noting that further on the southern side of Ruckinge Road, there is no footway. So there is an inevitability that existing residents have to cross that road to the north side. And once you're on the north side, there is a continuous footway to Ashford Road, which then turns north towards the railway station and the school. So I don't accept the criticism that it is so convoluted as to be an impediment to people making that journey.
What do you, and the next topic is about safety. Again, what do you make of Mr. Musk's view of attaching limited weight to the statement of common ground, and yet constantly repeating and constantly telling us about the email from Mr. Jensen that refers to this, in his view, not being a high quality route, but it's not dangerous? Just your view on that kind of judgment.
There's an inconsistency in approach, because on the one hand, we're putting to one side entirely the substance of the statement of common ground, and we're taking one sentence from one email.
Half a sentence.
Half a sentence from one email, and basing a case around that. It's just inconsistent.
The next is about the safety. Again, we've gone over this a great deal, and we know what KCC says, we know what we say, we know what Mr. Musk says. Just your view on what this inspector should take away from whether or not what we're proposing will have safety implications, please.
The statutory consultee will have considered carefully the issue of highway safety. It's not a low bar, as was suggested yesterday. Highway safety and danger is not a low bar. It's something that will have been thought about carefully by the County Council as highway authority, and they came to the view that it wasn't unsafe.
Thank you. What did you make of Mr. Musk's approach yesterday about the fact that he hadn't taken time to discuss what his views were with KCC? What would you have expected somebody in his position to have done?
I would have expected...
He didn't say that. He didn't say that. He just said that there weren't any documentations. He said
That's
he'd had
fair.
conversations,
That-
but there
that's
wasn't
fair.
anything in writing.
What do you make of the fact that Mr. Musk did not present any evidence at all of any discussions he had with the council to substantiate his view?
In the context of needing to bring compelling evidence to this inquiry to justify the position versus the statement of common ground, I would have expected there to be documentary evidence of exploring the County Council's position, Mr. Musk putting his position to it, and understanding why one party was justifying one aspect versus Mr. Musk's conclusion. I don't think that's unreasonable.
The fact that he had discussed matters with the council and then chose not to present any evidence from that, what would your view be if you were in his position and you had discussed matters with the council, with the KCC, and they gave you material and information? What approach would you have taken in that context?
If the material that they gave, notwithstanding the position that they take in the statement of common ground, if the material that they gave substantiated the position that it was an unsafe access, I would expect that to have been brought forward.
And so what's the inference to draw from the fact that he seems to have spoken to them and chose not to present anything?
That there is no evidence to that effect.
Thank you. And then in terms of the point he makes about the future, he's more focused on the future condition of the highways, and that that's more on his mind than the current circumstances. You don't need to turn this up, but I took him to that passage in the Statement of Common Ground, where they say at 2.2.1, on review of the incidents in particular, we're still on the safety issue. It was concluded that there are no existing highway safety concerns within the site vicinity, and as such, the development will, future tense, not negatively impact highway safety. Just in terms of how much we can attach to the weight of this conclusion reached by the Highways Authority, and Mr. Musk's view that he thinks the future context will lead to an unsafe environment.
It's clearly a highly germane sentence, because it's looking at the current situation, it's factoring in the development that's going to happen alongside the improvement schemes, and it's coming to the view that the development will not negatively impact highway safety. It's a highly germane sentence.
Thank you. Can we just look at the actual plan proposals for this area? We didn't look at it, and it just came up in the conversation during the Section 106. This is the plan. I think I asked Mum at 2.8 to turn that up. This is the revised Public Rights of Way Improvements Plan, and it's what goes into Fairfield Avenue. And just in terms of just introducing this document, we can see proposed mobility kissing gate, where the lighting is likely to be. I think it's quite self-explanatory. The colouring on the road, on the footpath, and so on. Just talk the inspector through, please. What are the component parts of the improvements that are actually going to take place here, please?
It was helpful that we looked at the definition of those works in the 106. And if at any point, Mum, you need to revisit that, I think that's a very helpful summary. Because essentially, if we go from the right-hand side of the drawing, the site side of the drawing, and if we visualise the existing public right-of-way within the site being upgraded as part of the development, that's showing a cycleway and a pedestrian route. And there's no criticism, as far as I'm aware, of any of the routes within the development, there being an issue with DDA compliance. We then get to the egress from the site, and it's going to be widened. You will have experienced the inset diagram, the inset photograph at the top of that drawing, which is narrow, overgrown, unsurfaced. Those are the current conditions. The vegetation is going to be removed. It's going to be widened to 2 metres. It's going to be resurfaced. And there will be a clear physical and visual relationship at that point with the internal route within the development. We then move further to the left on this drawing, and the footway, it's going to be, is painted the right word? Let's use painted. There will be a surface treatment applied to that 2-metre stretch. And that will clearly demarcate the public rights-of-way and the pedestrian route from Fairfield Terrace to the site. And that extends along the length of that. I think Mr. Musk, in his evidence, refers to it as 70 metres, 30 metres beside the house, and I think there's a further element within the car park.
So where I can see a pink, I think it's pink, a pink line across the route.
Yes.
Where is the surface going to be improved?
It's essentially that 2-metre extent.
Which 2 metre? Sorry,
The
pink,
the
the
pink,
entirety of the pink line.
Yeah, the entirety of the pink line.
Okay, and where? Because I've got a really small screen. Where's the note on the drawing for that?
Good question. Let's have a look. Now I can see the width is mentioned.
Yeah, that isn't obvious. A written note to that effect.
It just doesn't. If there's no note, then the drawing doesn't include. The drawing doesn't include the surfacing.
There's the visual representation,
The pink,
the pink.
but that doesn't
but
mean
there's,
anything.
There's no written note to that effect.
Yeah, but that's it. That won't mean anything.
Well, we can check. I don't think there is a dispute between the council and the appellants that the plan is to surface and improve that whole section.
Yeah.
But if that requires us putting it in a condition or defining it some other form, we are more than happy to do that.
I think all it would need is an amendment to the plan.
To just
Add
annotate
the
it.
note.
To annotate it.
Yes.
Okay.
I haven't checked because I can't open the document, but I have a strong suspicion that it's written in the section 106 to that effect.
It is. It's part of the Section 106 schedule, Ma'am. It deals with the pedestrian link improvements, secures those. It refers to surfacing, treatment.
It
and
does,
so on.
but we need to know where the surfacing goes. I mean, it's not a massive point. It can be easily.
Yeah, the definition in the 106 agreement also cross-refers to the Prow improvements plan that we are looking at. It's specifically referenced and appended.
I understand that, but I don't understand where it says on the plan.
You're absolutely right, and we need to deal with that. Just what I might suggest, Ma'am, is if you look on the plan on the right-hand side, there's that annotation that says public right-of-way formalised and surface within the site confines to provide a 2-metre route, and then it says within the site confines provision of a parallel 3-metre cycle route. Essentially the same annotation that I just read out, public right-of-way formalised and surfaced. We just basically need a similar one at the other end of the pink line to say, you know, the public right-of-way will be formalised and surfaced within this whole stretch, whatever that stretch equals to in line with the section 106.
Yeah, it's just a really simple thing.
Yeah,
That's all. Yeah.
The only issue is that it will obviously require amendment of the 106 because if it's still going to be a replacement plan, that will be a new version of the plan.
Oh,
so it will
right.
affect the 106 because that secures this plan.
Yes, so that could just be amended quite easily, I'd have thought.
Very easily,
Yeah.
and it's a very immaterial amendment, I would have thought, but we can definitely adjust that.
Okay, thanks.
But the evidence is that this whole stretch is what's being improved, and that's reflected in the section 106.
Yes.
We just need to align that with the plan.
Yes.
So you were talking about the designation of the pedestrian and the surface. Should we just reflect a bit on the lighting and the signage? Because I think Mr. Musk was very helpful yesterday to also point out what was going to be happening there. Just, do you have any comments?
So we don't need to turn it up, but CD 2.9 is the lighting plan. That identifies various lighting columns within the car park and at Fairfield Terrace, which will illuminate that stretch. And then in addition to that, there's proposed signage to assist with legibility.
So with the lighting plan, I'm just looking at the contours, the lighting contours,
Yeah.
and from the way I understand it, there's no new lights, there's no lights that would illuminate the actual passage between the Fairfield Terrace and the car park.
No, there isn't any lighting proposed at that point.
So there's a really good, helpful explanation in the statement of common ground with the council. And what they had requested in particular. I'm just going to probably get, just for your note at the moment, 1.2.16 of the statement of common ground with KCC. It refers to a meeting held in January of this year, and they raised the point about the lighting at Fairfield Terrace entrance and signage to alert all users to pedestrian presence. They asked for a topographical survey, which was subsequently carried out around the Fairfield Terrace entrance, confirming enough footway width to install a lighting column while maintaining a 1.2 metre path. The footpath signage was also proposed on the column to meet KCC's concerns, it says, and then they confirmed with these improvements in place the route is now acceptable to provide a pedestrian access on the site. And that's confirmed in an email dated the 8th of May of this year. And I just need to just show you that 8th of May email is the same email that we've looked at core document 3.8, the one that Mr. Musk was referring to around the question of high quality walking and cycling. And then in that email of the 8th of May where they confirm their content, it follows our email from the 14th of April, which is just below that. And that sets out, I don't know if you've got that in front of you, the email, Ma'am, core document 3.8. I think it's worth just having a look at that, and then
Is it 3.8 or 3.8A?
3.8A, as I was corrected by Ms. Tring yesterday.
Yeah.
So if you go on the second page there, you'll see that the last sentence, the penultimate sentence of that big first paragraph within that email says, based on this, it is likely that the lighting column can be positioned further back on the footway towards the existing hedge, allowing for greater footway. And then it says, however, to err on the side of caution, we have shown the lighting as per the attached. I don't know what that is referring to, but I've also indicated the wayfinding signage. I've also attached a suitable, the provision lighting column overcomes the concerns. And then if you go up in that same email, an email from Mr. Jensen, 8th of May at 15:13. Thank you for the revised drawings. The additional lighting column at the entrance to the car park from Fairfield Terrace does take care of this issue as previously discussed. As mentioned previously, is not a true system of highway street lighting in this location for this column to be added into. As such, need to be included in a private system of lighting. Please consider this with any maintenance discussions. That's the context in which we now find this plan and where the lighting is being identified. I hope that helps, Ma'am.
Sorry, I'm just thinking.
Yeah, absolutely.
Yes, so there's a light at the entrance of the I don't know what you call it, the vehicular access, and that's how it's been resolved by
Yes.
the light at the entrance.
Yes.
But that doesn't. But just my query was, it doesn't then spill to the whole of the, I don't know, alleyway, or I don't know how you describe that thing.
You mean the footpath into the
Yes.
car park? Which part? The part that goes into the site?
So I would describe the vehicular.
Yeah, the car park, basically.
No, so let's describe it as an alleyway.
Yeah,
I think
yeah.
that's the easiest bit. The bit
Yeah.
between the houses.
Yeah.
So I was just asking about light being spilled onto that. It doesn't seem to be illuminated. That's I was just querying that. But I can see it's illuminated at the start. So
Yes.
drivers would have, it would be illuminated turning in, or pedestrians going in and out of the actual route. But when you're in the middle between the houses, that doesn't appear to be illuminated. Well, it's not on the plan anyway.
Your thoughts on that, Mr. Jones?
You're right, Ma'am. The plan, which was to the satisfaction of the County Council, doesn't have any additional lighting between the two dwelling houses.
Yeah, okay. Yeah, I was just confirming that.
Yeah.
Yes, but I understand that the County Council has accepted that.
Yeah.
I understand that. Right, thanks.
But more importantly, they haven't asked us to do more, partly because I don't know where I read this, but there was something about, some of the discussions involved something about impact on neighbouring, the light pollution on neighbours. I can't remember where that discussion came from. Does that ring any bells to you? If it doesn't, don't worry.
No, it doesn't.
Okay,
No.
we'll find that material. But what I remember is a discussion with the highways consultants about the extent to which, if we decided to light more within the buildings, what the consequences would be in other ways. But I'll get to the bottom of that. But
Okay.
at least hopefully that answers your question
Yes,
on this.
thank you.
Thank you. And then just the final question on this. In terms of just thinking about this overall, Mr. Musk's view is that there will be lots of conflict and it may lead to safety concerns, and that's one of his main issues. Just your view on how people will experience and recognise this particular route after these works have been done, please.
The route will be materially different to the way it appears at the present time. There will be a change in the character of that part of the route. There'll be the surfacing, there'll be the illumination, there'll be the signage, there'll be the visual appreciation of the link through. And that changed context will inevitably influence behaviour. It will no longer be a vehicular access to simply a car park. It will be part of a pedestrian route. And pedestrians are at the hierarchy, at the pinnacle, of the hierarchy of users. So one can expect car drivers to moderate their behaviour in the knowledge that that is a pedestrian route, clearly demarcated.
Just your view then, the KCC's view is that it's acceptable and it's not dangerous. Mr. Musk obviously takes a different view. Just your thinking in terms of understanding the position and what you would say to this inspector to draw from the respective positions, please.
For Mr. Musk to depart in the way that he has from the view and opinion of the professional highway engineers at the County Council, he would need to bring compelling evidence to this inquiry. I don't believe he has brought compelling evidence. He's brought his opinion. And on that basis, the view of the County Council regarding it being an acceptable and safe access takes precedent, in my view.
Next heading is just so that deals with the safety of the route. Next is about the journey being too far. We know where we are in terms of the 2 kilometres, and we know where we are on what Manual for Streets says about 800 metres. We know Mr. Musk accepts that it's not an upper limit. Just your views on how we understand the facilities and the distances, please. We've got that table in the Statement of Common Ground between you and the Council, page 3. Just your thoughts on the journey distances and how far it will take to get to things.
I think it was accepted yesterday that we shouldn't be measuring accessibility from the furthest house to the furthest facility. That would be wrong. And what we have are a range of facilities within a closer distance to the maximum 1.6. There are things in the village centres, facilities in the village centre, which are closer. Some are less than the easy walking distance of 800 metres that are referred to. Some are slightly beyond that. Some are beyond that again. But none are beyond the 2 kilometre.
And just help me with this. Not all of the facilities are within 800 metre distance. And what does that mean for the experience of other people in the rest of Hamstreet, not just our site?
People at the moment will be accessing facilities and services. Some of those facilities and services will already be beyond the 800 metres. If I lived at Fairfield Terrace, for example, and was accessing the train station, that's beyond that distance.
Okay.
But as we heard yesterday, people are making that journey already. So I don't accept that it's prohibitive, that distance.
Have you recently walked the site and distances to, and two of the places actually Mr. Musk and I discussed yesterday is the school and the train station and the issues around the gradient and the hill. Just give the inspector the benefit of your judgment, having walked to the site before. I don't know more recently if you have, but certainly you and I have walked the site together, but just your benefit of your judgment on that.
I've walked in the past and more recently. The journey from the site through the village to the train station, and there are 2 routes to the train station depending on which way you go, and to the school. And it's a journey time of approximately 15 minutes. If you allow a little bit more for people on the further side, and it will be shorter if you're closer to the western boundary. But that's the order of magnitude that we're talking about. It's shorter to the train station. It's 15 minutes, to the primary school. I don't view that journey time as prohibitive. It's a walk through a village. You have to cross Ashford Road in any event. People have to cross Ashford Road at the moment because there is no footway on the eastern side as you go under the rail bridge. And it's not a journey that is affected by high-speed traffic, large volumes of traffic. It's a perfectly acceptable, in my opinion, journey to make. Yes, there are footways that are narrower in parts, but that's characteristic of Hamstreet in any event.
And then just thinking about we know from the table that we've got in the Statement of Common Ground, page 3, that Hamstreet Village Play Park, the GP, the Victory Hall, Community Hall, the bus stop, Morrison's, Post Office, Indian, the coffee shop, the pub, sort of everything up until the dental clinic, let's say, or including the dental clinic, based on this, that shows less than 800 meters from the closest dwelling and up to 1,000 meters from the furthest dwelling. So just ignore for a moment the train station and the primary school. Again, give the benefit of your judgment to this inspector that if these distances are found to be unacceptable, what does that mean for Hamstreet?
I imagine it would be very difficult to find future development opportunities that are less than 800 metres from those facilities because of the way the village has grown over a period of time relative to those facilities that are in the centre of the village. And I don't see that there is a discernible difference between a journey that is 800, 850, a kilometre in terms of the propensity to walk.
Yesterday we went through this. We're going to get to this at some point, I'm sure. But the supporting text to HOU 5, and in particular the supporting text that Mr. Musk only partially quotes, it talks about the reliance on cars in a rural location being inevitable. Do you remember that?
Yes.
But at paragraph 4.43 of Mr. Musk's proof of evidence, of his proof of evidence, bear with me. Yes, at 4.43, where he says the development, and it's a sentence right in the middle of that long paragraph, the development would therefore not prioritise active and sustainable modes of transport for all users, with residents being reliant on the private motor vehicles to access day-to-day services. In the context of the discussion we've just had of the distances, in the context of your experience having walked the settlement, and in the context of policy expectation that there would be some reliance on a vehicle, does that sentence make any sense to you?
I profoundly disagree with that sentence. To say that the development and that the future residents are in effect going to be wholly reliant on the private car is simply overstating it by some margin, I must say.
Next, the steep hill. Again, we've covered this in some detail, but just your view on the steepness of the hill, whether it would be prohibitive, particularly in the context of the train station and the primary school.
Perhaps originating from South Wales, I have a particular view of hills, and I'll put that to one side. It's an incline. It's an incline. I don't accept it's a steep hill.
Now, on the Mr. Musk talks about the gradients and makes a point about mobility for all user groups. Again, just your judgment on this, please.
There was a comment yesterday that part of the route was 1 in 20, and when you looked at what was in the documentation, that was leading towards needing to provide mobility impairment, make provision for mobility impairment at that gradient or less. We haven't been asked to provide any such infrastructure by the County Council. So to the extent that that was a concern for them, the gradient at that level, that hasn't followed through to them identifying a need for physical intervention to assist with that. They were comfortable, I surmise from their position, that they were comfortable that was a route that was being taken daily without impediment.
And then finally on this TRA 5, which I didn't go through with Mr. Musk yesterday because I thought it would be useful to talk to you about that. In the local plan, core document 6.1, PDF 286. You there?
TRA 5.
Yeah. TRA 5, core document 6.1, PDF 286. Development proposals shall demonstrate how safe and accessible pedestrian access and movement routes will be delivered and how they will connect to the wider movement network. Opportunities should be proactively taken to connect with and enhance public rights of way whenever possible, encouraging journeys on foot. Your views on whether we comply with this or not, please.
My opinion, strongly held opinion, is that we comply with that policy.
And then just going to HOU 5, I think the compliance with policies is in your proof, and I don't want to go through each and every single one of them in the interest of time, but just the HOU 5 being an important policy, it begins on PDF 231, supporting text above it. We've discussed this a bit yesterday, but just going through the sections of the various criteria, just give the inspector the benefit of your views. So criteria A, this is PDF 231, if you're there.
Yeah.
Criteria A, please, first.
I agree that 140 dwellings is of a proportionate scale, and Mr. Musk also agrees that.
Criterion B.
My view is that day-to-day services are within an easy walking distance. I accept some are beyond the 800, but that isn't the upper limit. It's not prohibitive.
Criterion C, please.
The position of the County Council is that the site is capable of being safely accessed, and the traffic generated can be accommodated on the local highway network.
And we know what the view of Mr. Musk is and what we think about that. I'm not going to go over that again. E, please.
Have we skipped D?
Sorry, D. I beg your pardon. D.
D, there is a degree of overlap, I would suggest, with B, because the second part of B talks about access to sustainable methods of transport. Hamstreet benefits from a train station. That's notably important relative to other settlements. There are bus services. So again, I think the development is located where it is possible to maximise the use of public transport.
E.
Well, E was a matter that was discussed with Mr. Williams, and his view that in strict terms there is a conflict with E, but you'll recall he adopted the lens of paragraph 187B of the MPPF and considered that the development scheme would accord with E in those terms.
Miss Dring asked Mr. Williams around the fact that the local plan was consistent with the MPPF having been adopted by the period when the MPPF was around. Just your thoughts on 187B in that context, please, given that you're a planner. You will probably be asked about that as well.
I think it's important to recognise that the local plan, although it was adopted in 2019, was prepared in accordance with the 2012 version of the MPPF. And the examination proceeded under transitional arrangements, whereby it was the 2012 MPPF was relevant. And we see that, don't need to turn it up, I suggest. We see that in the inspector's report to the local plan, CD 4.3 at paragraph 2.
That's the reason why you were referring to the local plan, the examiner's
Yes.
report. We
Yes.
don't need to turn that up,
Yeah.
but just give that reference again.
So paragraph 2 of CD 4.3.
Yeah. The implications of
the,
that.
The implications of that is that the sub-clause of paragraph 187 isn't in the 2012 version in the section concerning conserving and enhancing the natural environment. There is a clause in there that relates to valued landscape, but the requirement to have reflect the intrinsic character of the countryside comes later and wasn't part of the local plan process. So it is right to view it as Mr. Williams does through the lens of 187B.
Back to HOU 5, F please, F for Freddie.
Again, Mr. Williams dealt with numbers 1 and 2, so there is partial conflict only.
Okay. And then, sorry.
Sorry, if I can just finish, because I recognise that the opening sentence says that each of the criteria have to be met, but we are in a position where the tilted balance is engaged and the weight to be given to policies needs to reflect that situation. And there was a discussion yesterday about policies that frustrate the achievement or the objective of significantly boosting supply. So these would be one of those criteria where if you rigorously applied it, gave it full weight, you frustrate that objective.
And Mr. Musk agreed with that.
He did.
Yesterday. In terms of then, finally, briefly on SP1, which we haven't touched upon, what would your approach? We don't need to turn it up. SP1 and ENV3 and ENV3A and ENV13, please.
It would be a similar approach. To the extent where there are individual criteria or aspects of those policies that strict adherence serve to frustrate the need to increase housing provision, those policies would attract less than full weight. Those criteria would attract less than full weight.
Thank you. SP6, finally.
Design policy, my understanding was that Mr. Withicombe, if he progressed beyond his in principle objection, Mr. Withicombe was in agreement that the design and access statement provided a framework for a high quality development. I might be paraphrasing, but that was the tenor of his evidence.
Yeah. Heritage harm, we know where we are on that, but just your reflections on Mr. Musk's analysis from yesterday, a very substantial weighting exercise. We don't want to, I'm not going to trouble you with the difference between the great weight to the conservation and what weight you should attach to the harm. I'm not going to go over that again, but just your view on if Mr. Musk's view is maintained, a very substantial weight, how does somebody approach that from trying to overcome that in a judgment?
We're in the territory where both the development plan, ENV 13, and paragraph 215 of the MPPF require there to be a balance struck between harm, less than substantial harm, and the public benefits. If the harm is being attributed very substantial weight, I fail to see how you could arrive at public benefits that exceed that level of weight. It kind of prevents, it prevents that balance being struck because the harm is being put right at the top of the scale.
Thank you. I don't think we need to do any more on that. Overall planning balance now, finally. But no, before we do that, can I just touch upon the other allocations that yesterday Mr. Musk and I discussed them briefly? You know, the allocations that are referred to in our rebuttal, you don't need to turn this up, but it's in our rebuttal at 2.1.8. Yes, sorry. The transport rebuttal 2.1.8, and to be fair to Mr. Musk, he didn't know enough about them. But just your thoughts on what this rebuttal says about those two allocations, S31 and S56, which have walk distances to these services and facilities which are comparable.
I think what he said was there isn't any evidence of the figures, not that he didn't know about them, but there are no figures in the inquiry in relation to walking distances and that.
There are no figures in the inquiry specifically on this point, but Mr. Musk, if I recall correctly, said, and I said to him he had had this rebuttal for a number of weeks and he hadn't done anything to check himself, was the evidence that I got, and so he didn't know. But your thoughts on whether that sentence or that paragraph that's unchallenged is right?
Essentially, it's saying that because of the distribution of facilities within the village, that there is a comparable, not identical, comparable level of accessibility. So the development at the north, I recall it as St Mary's Close because it's moved on and it's called something else, Nightingale's, Brimstone Road. That is at the northern extent of the village, yet the general practitioners and the recreation ground are at the south and southwest, which is the reverse of the situation with the appeal side. Warehorn Road is at the western extent of the village beyond the railway line. It too has some facilities that are close to it at the village centre, some that are further away. And it's a product of the morphology of the village, that locations to the north, the west, to the south, southwest will be closer to some facilities, more distant from others. But that doesn't undermine the overall accessibility.
Thank you. A couple of other final points on this. Yesterday, Mr. Musk's view on the individual policies, just the general view on this. Do you remember he and I went through and, for example, were discussing part of a policy being impacted, and then he was saying on all of the policies we discussed, his view was that even though part of a policy was impacted, he was of the view that you failed to meet the policy as a whole. Do you remember that?
Yes.
Just your reflection on that approach, please.
There is a difference between accordance as a whole and partial accordance. you can accord with some things, but not necessarily everything. And we have that in this case. And there needs to be a balanced judgment taken at that point in terms of the things that are accorded with versus those that aren't, and the benefits or disbenefits of that partial accordance. My view is that it's wrong to take the view that if you conflict with one criteria, you conflict with the policy as a whole without that balanced judgment.
I'm gonna, just the final point is we've covered the MPPF 110 already about the reliance on the car. The housing crisis point is common ground, so I don't want to spend onto that. But just your final thought on, just picking up the point about development as a whole, your final thoughts on how you say this inspector should approach balancing the harms against the benefits of this proposal, please.
I've set out in my evidence a recognition of the harm or the disbenefit that developing this site will have. I don't try and suggest that there isn't harm. It's inevitable that development on the edge of a settlement will cause some degree of harm. That's inherent in the operation of HOU 5, I'd suggest. But when you look at the extent of harms versus the extent of benefits, we have a position where Mr. Withycombe accepted there were localised harms. I'm not going to discuss the heritage position. I think the positions there are clear, and on our case it's low level, less than substantial, which is outweighed by public benefits. I think that was said yesterday. I don't accept it's an accessible location. So we essentially have localised landscape and visual harm versus what are clearly borough-wide housing difficulties. So the benefits of the scheme have a much wider application in terms of the local plan and achieving SP2 versus localised landscape harm.
Thank you, Mr. Jones. Those are my questions. I'm sure my learned friend has plenty for you, so just sit there for now. Ma'am, thank you.
Okay, thank you. I'm just thinking about 11:30, so I think probably a break. If we have maybe a short break now, say 15 minutes, and then have a lunch sort of, well, it'll be up to you, but maybe sort of aim for about 1, if that's okay. And of course you can't talk to your team now. Okay, right, so we'll be back at 11:45. when you're ready.
Good morning, Mr. Jones.
Good morning, Ms. String.
Right, I am going to get straight into the detail with the questions about accessibility and access, and starting with walking distances. So can we have the local plan, which I know you've already got there in front of you, and I'm going to look at policy HOU 5 and in particular the supporting text. We've obviously already looked at these paragraphs throughout the inquiry so far. And focusing on paragraph 6.58 of the supporting text, which we looked at yesterday. And we can see from the first sentence that although this acknowledges some reliance on the private car is inevitable, the aim of this policy is to reduce that reliance, isn't it?
That's what the first sentence is referring to, yeah.
Yeah. And that aim of reducing reliance on the car is the context for the next sentence about basic day-to-day services being within a generally accepted easy walking distance of 800 metres. That's the reason for that requirement for easy walking distance, isn't it? To reduce reliance on the private car.
Yes.
And I mean, the logic of that is fairly obvious, isn't it? See, the shorter the distance, the easier and the quicker it is to walk, the more likely it is that somebody will choose to walk instead of driving. That's fairly
As a principle,
fairly
yes.
obvious. Yeah. And I know in your evidence in chief, you were talking about reliance on the private car, and you made the point that a developer can provide opportunities for active travel, but can't dictate how people choose to behave. But if we look at it the other way round, would you agree that how people choose to behave, i.e. whether they drive or not, depends on the opportunities that are available?
To an extent, yes.
If opportunities are more limited or more difficult, that's going to influence the choice that people make more towards driving than if the opportunities were freely available and wide-ranging.
People would balance convenience versus the quality of the route. So if there is something that is accessible, people may choose the route that's available, the route that's proposed, not necessarily dictated by the quality of that route.
No, but I think so you agree that both of those factors are relevant when you're looking overall at the opportunities that are available and the propensity for people to walk. It's both the distance and the quality go together.
Yeah, it's a balance of considerations.
So we're looking in 6.58 still, it refers to that generally accepted easy walking distance of 800 metres. And we can see that in paragraph criteria B of the policy, that phrase easy walking distance is used. So we can tell from that, can't we, that where the policy refers to easy walking distance, that means 800 metres, and then there's a caveat about specific local context.
Yes, there's a qualification at the end of the sentence relating to 800 metres,
Yeah.
requiring a case-by-case judgment.
But leaving that aside, that I'll come on to that in just a second, but just obviously a supporting text, part of the role of that is to help us to interpret and apply the policy. So where we see the phrase easy walking distance in the policy, and then we see the supporting text telling us that a generally accepted easy walking distance is 800 metres, we then know that when the policy uses that phrase, that's what it's referring to, don't we?
Yes, with the qualification.
Yeah.
It's Mr. Musk's evidence that makes the case that HOU 5 is supported by Manual for Streets. And when we turn up Manual for Streets, we see that wider explanation of accessibility. So I don't think you're restricted solely to interpreting 800 metres as being the only measurement of an easy walking distance. There are wider factors.
I mean, you just referred to manual for streets. I think we both know the paragraph that we're referring to. We've looked at it already. That talks about walking neighbourhoods having a range of facilities within 10 minutes up to about 800 metres, which residents may access comfortably on foot. So would you agree that, you know, the comfortable walking distance and the easy walking distance, we're talking about similar concepts there, aren't we?
Comparable, but again, it's in a context of the 2 kilometres being a distance where there is a propensity for trips to be by walking. I accept, you know, there is a range below 2 kilometres where things will be more accessible, shorter distance, but that doesn't mean that facilities beyond 800 metres aren't accessible.
Obviously, the policy is specifically looking at, it doesn't use the word, well, in the particular paragraph we're looking at right now. Oh, I've just closed the document, hold on a second. It uses that phrase, easy walking distance, not accessible, doesn't it? We can agree that.
Well, I think that's a distinction without a difference, if I may.
Okay. Coming on to that, the caveat, so 6.58 talks about basic day-to-day services and a generally accepted easy walking distance. Although the specific local context may mean a higher or lower distance would be a more appropriate guide. Looking at your proof of evidence and what you've said, and looking at Mr. Scarrett's proof of evidence, the appellant doesn't identify any aspects of the specific local context of this site that would indicate any different distance, do you?
Other than the facilities being within the 2 kilometres, no. And of course we know that the furthest facility from the furthest dwelling is less than the 2 kilometres, 1.6.
Yeah, my understanding of the case that's put and as set out in Mr. Scarrett's proof is that 2 kilometres is advanced as a kind of generally accepted upper limit threshold. So it's very much not something that's based on the specific local context, is it?
Well, it's derived from Manual for Streets, which is a recognised document which itself refers to the earlier PPG on transport.
But none of that is based on specific local context that might mean a different distance would be appropriate to measure as an easy walking distance for the purposes of HOU 5.
No, it's not local, but it's a widely accepted measure of a distance where the propensity to walk exists.
In terms of thinking about the specific local context and walking distances, would you agree that the characteristics of the route are part of that local context? So, for example, things like hills we've talked about, the attractiveness of routes, would they be a relevant consideration as part of the local context in terms of distances?
They could be. But as I've said in my evidence in chief, I don't, having walked it, I don't believe the incline is prohibitive in those terms.
Yeah, we'll come on to that in a bit more detail in a moment. That 2 kilometre distance as is described by Mr. Scarrett as an upper limit threshold. Can we agree that there's a difference between the concepts of an easy walking distance on one hand and an upper limit that may be acceptable on the other hand?
I think we can agree that beyond 2 kilometres, the propensity for walking is clearly less. I don't think that certain trips, 3 kilometres, some people may choose to walk that. But in answer to your question, as I said previously, there is a range of distance below 2 kilometres, where some facilities would be plainly less than that distance.
is there a difference between the two concepts? We've got the policy that says easy walking distance. Then we've got Mr. Scarrett saying upper limit threshold for what's acceptable. Do you accept that there is a difference between those two concepts?
Yes.
Thank you.
But I don't want to go over the point again. But the 2 kilometre is an accepted measure of a distance where the propensity of walking to walk exists.
And we've gone through, we already discussed the logic of the policy about reducing reliance on cars, and the shorter the distances, the easier it is to walk, the more reliance on cars is reduced. So it's logical, isn't it, therefore, that the policy would seek facilities to be within easy walking distances and not within the upper threshold of what's acceptable. That's sort of logical when you think about the objectives of the policy.
Yes, but when you take account of the qualification at the end of that paragraph, it clearly recognises, doesn't it, that there will be some facilities that are beyond 800 metres that are accessible by walking. That's what that's essentially saying. And that's consistent with Manual for Streets, which Mr. Musk tells us underpins HOU 5.
If the inspector reading this policy thinks that 800 metres, is the appropriate easy walking distance to judge compliance with the policy, we can see we've looked at the table in the Statement of Common Ground, haven't we? And we know that for houses on the western edge, proposed houses on the western edge of the development, both the station and the school would be over 300 metres beyond that easy walking distance. Factually, that's correct, isn't it?
I would caution against basing a decision on the facilities that are simply within the 800 metres. That is not what the essence of the policy is trying to achieve.
Yeah, I mean, we've been through what it's trying to achieve, but can we agree factually that's correct? So for the closest houses on the western edge, both the station and the school are more than over 300 metres beyond that 800 metre distance.
Sorry, if that was
the question.
The nub of the question, yes.
And for the furthest houses on the eastern edge of the development, I think only 3 of the listed services and facilities would be within what the policy is describing as an easy walking distance.
Yes,
Yeah.
including the village hall and the surgery, and of course every house is closer than that.
And for those furthest houses away, I think the distance to the station and the school is nearly double the 800 metre easy walking distance, isn't it?
Yes, it is.
Yeah.
Not everybody, of course, will need to walk to the primary school.
No.
Not all of the residents would need to walk to the primary school. Not all of the residents would need to walk to the train station. Some may choose to walk 2 days a week. So I think it's very difficult to base the overall analysis of accessibility on that very narrow measurement.
No, I mean, you'll appreciate we're not. That's not the council's case, as Mr. Musk has explained. It's distances, it's quality, it's all of these things wrapped up together in an overall judgment. But obviously, I can't ask you a question about everything all wrapped up together. I've got to go through it in stages.
No,
you'll appreciate that.
And that's why you asked me to advise the inspector. That was my advice.
And we can agree, just on the primary school in particular, that is one of the day-to-day facilities that's specifically identified in paragraph 6.58, isn't it?
I'm sure it is, but yes.
Thank you. Lest we forget, as it was pointed out to Mr. Musk. Yes, go on.
Sorry.
Go on.
I'm at an age now where I need reading glasses. Just reading that sentence that you've referred me to, basic day-to-day facilities such as. So there is a qualification there.
It's saying that it's not an exhaustive list, but these are
Yes.
examples of services
Yes.
that should be within that distance. Yeah. Yeah, it was obviously pointed out to Mr. Musk that we're looking back at HOU 5B. See, we've been talking about easy walking distances, and there is a second limb to that policy, isn't there, and or has access to sustainable methods of transport to access a range of services. So we're talking there about essentially sustainable transport other than walking. So we're talking about cycling, bus and train, aren't we?
Yes.
Yeah. And we know you've told us there are bus stops and a train station, and we can see the distances to those. Obviously, there's an issue between us in terms of how accessible those are, which this wrapped up in the general issues about distance and quality of
Yeah.
route. So that's,
Hamstreet benefits both from bus and rail-based
yeah.
public transport.
But and then in terms of the policy, there's a difference between us in terms of the extent of access to those, which is dependent on these same points about distance and about the quality of the route that I'm just about to come on to.
Yes.
Yeah, thank you. So it's all sort of wrapped up together in that way. Can we just look at, just on KCC's position on these, the accessibility and walking distance points? Can I take you first to CD 3.8, not A, but 8, just 3.8, which is the letter from them, dated the 11th of November 2024. It was their kind of formal consultation response. Let me know when you've got it. Great, thank you. Second page of the document, we've got paragraph 11. And they say there, the overarching view on sustainability of a proposal lies with the LPA, however. That's right, isn't it? And that's what Mr. Musk said yesterday, that, you know, that those issues of accessibility and sustainability are really within the LPA's remit.
If we're using sustainability as a proxy for accessibility, that's what that sentence is saying. But we mustn't forget the local highway authority, in my experience in Ashford and in Kent, if they were concerned about accessibility, they would make that known.
Yeah, it's just that there's obviously this point about, well, they're a statutory consultee and there's a particular, you know, approach that needs to be taken. But so if we're going to go down that route, we need to be clear about what they are the consultee on, and then other things that they might comment on which they're not the statutory consultee on. Do you see my point? And on these accessibility matters, they are not a statutory consultee on those matters, are they?
I don't know the answer to that.
Okay.
They are the local highway authority. The local highway network includes walking, cycling and highways, public rights of way.
I mean, leaving aside the kind of legalities of it, they are telling us here in this document that the overarching view on sustainability lies with the LPA, and this is in the context of walking distances, which is what they then deal with.
Yes,
so that's what they seem to be advising, that, you know, it's for the council to ultimately make these judgments, and now the inspector, of course.
Yes, it sets out a series of observations relating to accessibility.
Yeah, and one of those observations, just to pick up on in particular, is C. The primary school is between 1 kilometre and 1.6 kilometres. The latter in particular is doubtful in terms of walking distance for small children. So they're essentially agreeing with Mr. Musk on that, aren't they? That those distances are, you know, they're not really realistic.
Well, they're referring to small children.
Yeah.
I think Mr. Musk's position was more general and was referring to all children.
Well, I don't think he was specifically asked about ages, but it's a primary school. There's a kindergarten there.
Yes, and
So
there's a difference between a child in reception, or year 1, and a child in year 6.
Yeah, okay, well, we can see what they then say about other distances there. Just picking up on, other allocations and other applications that you kind of touched on a couple of times in your evidence in chief, and, comparisons of walking distances and so on. It's right that the inspector doesn't have any of the details of those applications, what the actual distances are from those other parcels of land.
No, there's no
have that evidence.
there's no table of measurements.
No table, and no, there isn't anything in any of the core documents to assist her with drawing any kind of comparison.
Other than the identification of the location of those sites.
Yeah.
And the inspector will be familiar by
Yeah.
now with where the facilities are in the village.
Yeah.
So I think it's fair for the inspector to be able to form a judgment about
Yeah.
comparable accessibility.
But of course, we can all agree that, ultimately the inspector's got to determine this appeal on its own merits, and, what has or hasn't been accepted on another site, not really of great assistance. We agree that.
Well, the answer that I gave was in relation to the distribution of facilities. And some things will be closer than other things. And that pattern exists on those sites in the same way as it does on this site.
In the Statement of Common Ground with Kent, so it's CD 5.9, obviously bearing in mind, what they've said about it ultimately being for the LPA to take a view on these matters, but just what they've agreed in the statement at paragraph 2.2.6. They say that the walk distance...
Sorry, could you just bear with me
Sorry,
a
yes,
moment?
I'm sorry.
In my wisdom, I put all of the statements of common ground together in one document. Sorry,
2.2.6, so it's page 8 of the Statement of Common Ground, page 9 of the PDF.
Yeah.
They're discussing the walking distances in the TA, and they say that the walk distance between these facilities and the site would not preclude all households from accessing these services on foot. Residents of the site would not therefore be wholly reliant on travel by private car to access these facilities. And just to be clear, no one's saying, are they, that the residents of this proposed amendment would be wholly reliant on the private car. That's not what Mr. Musk has said. We went through this with him yesterday. That's not anybody's case, is it?
I'm sorry, that's just not right.
I know you went to the paragraph of his proof. He doesn't say wholly reliant there, and you cross-examined him yesterday on it, and he said what he said. I've got a note. Inspector heard it.
I'll let Mr. Jones answer, but I don't think I agree with that. But I'll let Mr. Jones answer.
Thank you. Is that your understanding of the council's case?
Bear with me. Mr. Musk yesterday said that not all residents would be dependent on car travel. The other side of that coin is that some residents will be able to walk to local facilities. The paragraph that I read out, or I was taken to this morning, 443, doesn't say wholly. What it says is that with residents being reliant on the private car to access day-to-day services. That's different, I'd suggest, to saying some residents will not be reliant on the car. And it was a helpful clarification yesterday on that point.
Good, I'm glad. I mean, looking at what KCC have said there, it's pretty faint praise, isn't it? Wouldn't you agree? Wouldn't be wholly reliant, wouldn't preclude all households from accessing these services on foot. I mean, that's not any kind of policy test.
I
Would
can't,
you agree with that?
I can't put myself in the mind of the authors of this note. What it says is what the paragraph that we've talked about, 648, you know the one I'm talking about reducing reliance on the car. It's wholly consistent with that policy intention.
they're not saying, are they, in that paragraph, they haven't signed up to a statement that says that these distances will help to reduce reliance on the car, or that there will be easy walking distances. They haven't agreed to that.
I'm not going to go through the document line by line, but what it says is that, in terms, local facilities and services will be accessible by means other than the private car.
But I'm right to say what I just said, aren't I? That they don't say that these distances will help to reduce reliance on the car, or that there will be easy walking distances. They don't say those things.
I'm loath to go through the whole document.
Do you want to point me to where it does say?
No,
Sorry, I'm sorry, that's just not a right characterisation of 2.2.6 is very clear what it says in its entirety. It may not say exactly what.
Okay, look, I don't.
No, but don't put something to him that's not true.
It is true. It doesn't say, it does not contain a statement that these distances will help to reduce reliance on the car. It does not contain a statement that these will be easy walking distances. I absolutely resent the suggestion that I'm putting something that's not true.
It's not
That
true.
it is true that the document does not say those things.
Yeah.
Madam, I'm sorry, I did not interrupt. I could have interrupted a lot of times during Mr. Mohammed's cross-examination. I held my tongue. I didn't. It's not necessary to interrupt. I'm not putting anything inappropriate.
Yeah, I think the question you asked is fair.
Thank you.
without going through it line by line, I don't have anything to say that it doesn't say that.
Thank you.
But what it does say is that the distance between the facilities would not preclude all households from accessing these services on foot.
Yeah.
The implication of that is that it does serve to reduce the reliance on the private car.
Can I just pick up on, it's not a related point, but since we're in the document, I just want to clarify for my own understanding and for the inspectors. At paragraph 2.4.3, so on page 9, PDF 10, third sentence states, the emergency access route will also provide an alternative route to Hamstreet Road for both pedestrians and cyclists. That's not accurate, is it? There isn't a pedestrian access proposed via the emergency access to Hamstreet Road.
Not pedestrian access, no.
Thank you. And because I think it's probably been carried through from the TA, and I don't think we need to look at it, but it essentially says it has that same kind of comment about there being a pedestrian access there. So I just want to be clear that that's not. Thank you. Just so that we're all clear exactly what the proposal is. And also, just whilst I was looking at that yesterday, I just wanted to clarify the position on cyclists, actually, because I looked back through the TA on this, and I think perhaps it's helpful to open it, actually, just so that the inspector can follow through. So it's 110, isn't it? Probably find I've already got it open now. I'm going to open it. No. Oh, yeah. Yeah, so 1.10, and it's page 28 PDF. And that's, so I'll just...
Sorry, bear with me.
The PDF's 28, page 28, core document 1.10.
I'm on the page, but I don't know the paragraph.
No.
No.
So let me just read through and set out what my understanding is, and then see whether I'm right about this. 4.2.12 talks about a meeting with KCC. Discussions were held regarding the implications of redesignating the footpath to a bridleway. We're talking here about the footpath that crosses the site through Fairfield Terrace. So talking about redesignating it to a bridleway. 4.2.13, it's not feasible to redesignate the route at this location. It's proposed to retain it as a footpath designation. Jump down to 4.2.16. It's proposed that a cycle route would run alongside the footpath through the site. And then going over the page, cyclists will then be able to utilise the emergency vehicle access route to access Hamstreet Road for wider connectivity. So I think, and this is no doubt my mistake, I think I'd assumed that cyclists would also be using the Fairfield Terrace access, but am I correct that that's actually not right? The cycle route is via the emergency access and the Fairfield Terrace is only for pedestrians. Is that correct?
No, I don't think that is correct.
No. Okay. Where do we go to find out what it actually is then? Because if it's a footpath,
I take the
cyclists
point.
don't have a right to cycle on footpaths, do they? And it would need to be a bridle way. And
There's
it's
a
not.
legal impediment at that point.
Yes. So am I right then that the Fairfield Terrace access, strictly speaking, isn't a cycle route because it's a footpath?
Strictly speaking.
Yeah. I mean, what people actually in reality choose to do is probably another matter, but from a legal perspective, they don't have a right to cycle into the site that way. They would have to dismount, walk that part of the route, and then get back on in the site, or vice versa.
Yes. And that characteristic exists on the other side of Fairfield Terrace as well.
And so that's a pedestrian route only. The cyclists are going up via the emergency access to Hamstreet Road. I don't think we've got a plan of any cycle provision. I'm not sure if you can point us to what's proposed there in terms of cyclists.
It would be on carriageway at that point.
On carriageway. I mean, I'm not going to start opening up some sort of point or objection about this, but I just wanted to be, because I think I've been on a misunderstanding about this. Obviously, the inspector needs to be clear about what is actually proposed. And so in terms of, there's obviously specific policy relating to cycle provision. So when she is assessing that, she basically needs to be looking at the emergency access route, doesn't she, in terms of assessing that provision. Appreciate there's not, it's not been a part of the case, so I'm not, like I said, I'm not opening it up, but that's what she needs to look at.
No, it hasn't been part of the case.
No.
It's a new point.
No, a new point, but equally, well, it's a clarification. I mean, it's not something that I had previously been aware of. I don't know whether the inspector had appreciated that. I wanted to make sure that for my closings, I'm not closing on an incorrect basis and a misunderstanding. So I'm glad we've clarified that, and the inspector will then know how to approach that.
I did notice actually when we were looking at the plan earlier, there is a marking, say, cyclist dismount.
Is there, right? Well,
Yes.
I've obviously, not noticed that, so that's on me. But thank you for that clarification. Right. I'm moving on then to the issues about the quality of pedestrian routes now. So
Can I close the TA?
can you close the TA? Maybe, but we might need to open it again later. Yeah. I would keep it open for now unless you're about to crash your computer, which can happen. Yeah, so quality, I think there's three issues that we need to cover. There's the stepped access point in the northern pedestrian access, there's the hill point, and then there's the car park route, the quality of the route through Fairfield Terrace car parks. So we're going to do those in that order. Stepped access, we can hopefully deal with quite quickly. We can agree that that's not an inclusive access for everybody, because obviously anyone with something with wheels or mobility impairment, it's not accessible for them.
I don't disagree with that. I think we've all got experience of buggies being taken down steps.
No doubt. And it's proposed to be, we've just covered the cycle access. This isn't, for obvious reasons, proposed as a cycle access either, so it's just pedestrians there.
Yes, but again, we've all got experience of people dismounting and taking bikes down steps.
Yeah. And plainly, you wouldn't suggest that stepped access is suitable as the kind of main pedestrian route into the site. We can agree it's a sort of secondary access, and the main route is via Fairfield Terrace.
It depends on the origin and the destination.
But if that was the only access, you wouldn't be suggesting that that was acceptable because
But
because of the steps.
It isn't the only access.
No, I know it
That's a
isn't, but that's why I'm
hypothetical.
saying you're reliant on the Fairfield Terrace is the one that is inclusive for everybody, and so that's, and the walking distances are measured from there because that's the main access.
That's the access, that's the inclusive access.
Mm-hmm.
But that's not to say that the stepped access doesn't serve a purpose.
No, I'm not saying it doesn't, but just trying to get the parameters there. Two factual matters. It is a fact, looking at the plans, that there would be a pinch point with the new pavement provision on the southern side of the road where you'd come out from the steps.
Yes, the footway narrows.
Yeah, footway narrows, I think, to between, there's 1.2 and then there's 1.4 for its section.
And that's,
we can agree that is factual.
There are other instances of footways
I know you say
narrowing.
that there are. I know you say that there are. There is here.
Well, there's no contrary evidence to that. So
I'm not suggesting that there aren't other narrow footways, but
Thank
do
you.
you suggest that the fact that there are narrow footways, you know, elsewhere means that that's something that we should be kind of following?
I'm saying it's characteristic of Hamstreet, and we established yesterday that there are differences between urban and rural areas.
Are you saying that's a positive characteristic?
I'm saying it's a factual point.
Yeah. Do you agree it's not a positive thing to have narrow footways? It's not something that we should be striving for. We should be trying to have footways of an appropriate width in modern standards.
Yes, but if you look at the character of Hamstreet,
So it's yes, but
if you look at the
Yeah.
character of Hamstreet, having narrower footways does not preclude people from walking and cycling. Sorry, walking.
yeah. And as a matter of fact, and I know what you say, and you don't need to repeat it about crossings and people have to cross places elsewhere in the village and so on. I've got that point. But it is a fact that in order to access facilities, particularly, let's take the GP, there will need to be 3 crossing movements made across to the north side, across Carterswood, across back again. That's a
Yes,
fact.
if you chose to use that route.
Yeah. Yeah. Okay, then the hill, obviously, the inspector's seen that. We've got the evidence on it. I think we can just hopefully try and agree some of the following points. Particularly concerned with this about the journey to school and kindergarten. Can we agree that by definition that is a journey, if you're walking, that will be undertaken with young children and possibly pushchairs? If you're walking to the school.
If you had children at the school, yes.
Yeah,
If-
I mean,
if
you
you were-
probably wouldn't be, unless you were a teacher working there.
Unless you were a teacher,
Yeah,
yes.
okay,
Or a dinner lady,
Or a
or a caretaker.
okay. The majority of people making that journey by foot will have young children and possibly pushchairs if they're going to the kindergarten, won't they?
Yes, but not everyone necessarily.
No. And having those young children, pushchairs and so on, that will always make a journey slower and it will make it take longer, leaving aside questions of hills. Just if you compare an equivalent journey that you would make by yourself to a journey that you would make with a 5-year-old child in a pushchair, it's going to take longer, isn't it?
In all likelihood, yes.
And so you've got to, I know you said you've walked that journey, I think you said it's about 15 minutes, a bit further from the further side of the site. But obviously that's you from your perspective as an able-bodied adult man who is walking up that hill.
Yeah.
We've got to put ourselves in a different position, haven't
Yeah.
we? Thank you.
Yeah, we have. And I imagine someone who makes that decision, part of their judgment would be, is walking to the school beneficial for my child's well-being and health?
Mm-hmm.
So it isn't simply a case of saying it's going to be longer than Mr. Jones's walk, therefore it's not going to be attractive.
That journey, if we're talking about taking kids to school, that is a journey that will need to be undertaken twice each day. Drop them off in the morning, pick them up in the afternoon or the evening. home to school,
if
home.
you were walking them both ways, yes.
Yeah. In terms of the gradient, I think we can see from Mr. Scarrett's proof of evidence, he has that sort of chainage, that little graph. It looks like a graph on page, hard copy page 4, PDF 7. And what
Sorry, bear with me.
Sorry.
Which CD number is this? I had to close a few because
Sorry,
my
I don't know because I've downloaded them. I've had the proofs separately. I don't have them.
Thanks.
Thank you. Sorry, I always downloaded them separately first and accessed them that way. Let me know when you're there.
I'm there.
Thank you.
No, sorry, I'm in the document. I need the paragraph
Yes,
reference.
sorry. Well, I was on page PDF 7, and I think it's hard copy page 4. It's got that aerial photo and then the little graph thing. Now, my reading of that, the annotation on the graph says chainage 150 metres to 250 metres, change from 13 metres to 18 metres, 1 in 20. So my understanding of that is that 100 metre section of that route up to the school is at a 1 in 20 gradient. Is that your understanding?
That's what that drawing is showing, yes.
Thank you. And Mr. Simon, well, no, I'm going over things that we've already discussed here, but Mr. Scarrett tells us at paragraph 2.1.12 that gradients of 1 in 20 or steeper are defined as a ramp when measures should be considered and implemented to ensure inclusive mobility. I heard what you said in Chief. Nobody's asked for any kind of measures. I take that point. But that is an indication, isn't it? Just in terms of thinking about easy walking routes and accessibility, that kind of gradient isn't necessarily an inclusive one for all people.
Based on that text, it's at the outer limit of the 1 in 20, isn't it? But as I say, being at that gradient hasn't caused the local highway authority,
No.
familiar with the area, no doubt, to suggest that those interventions are necessary.
Yeah. No, I know, and I acknowledge that.
Yeah,
But
yeah.
you don't always have to repeat. You don't always have to repeat the things you've already said, especially when I've reminded you that everybody that you've already said them. But so this is just another factor, isn't it? So if people are deciding whether to make that journey on foot, you said, well, they're going to consider health and well-being, and it's healthy to walk. They're considering all of these factors. They're considering the distance, how long it's going to take, the fact there's a hill, the fact they've got a young child with pushchair. All of these things are combining together, aren't they, to influence whether somebody's likely to walk or whether they're likely to be reliant on the car.
It's a balance of considerations.
Yeah.
And those same balance of considerations apply to the people who make that journey today. The only difference would be it's a longer journey.
Yeah. Okay, let's get on to Fairfield Terrace, the access through the car park. I think you've already told us that's the inclusive route, so that's the one that's accessible for everybody. And we know from the framework, I don't think we probably don't need to go to it. I think we went to it with Mr. Musk yesterday. Paragraph 115B talks about access as being safe and suitable for all users. We've got 117B addressing the needs of those with disabilities and reduced mobility. So we've got to specifically consider, haven't we, how that access will function for children, for those with mobility impairments, people in wheelchairs, people with pushchairs. We've got to factor all of that in.
Yes.
And we can agree that and I look back through the DAS and the historical mapping on this, the public right-of-way predates the existence of Fairfield Terrace. It's a long-standing route, isn't it?
It's a historic route.
So it's no part of the design of that route that it would go through a car park. That's something that came later.
Yes.
The fact that a public right-of-way already exists along the route doesn't demonstrate or doesn't provide any kind of positive indication, does it, that will be safe or suitable for a new 140 home development?
The current usage will be different to the future usage.
Can you just ask the question? Answer the question first.
Sorry.
The fact that there is already an existing public right of way, it's a historic route that predates Fairfield Terrace. It doesn't provide any kind of positive indication that there's access to 140 home development there will be safe and suitable.
No, because it serves a different purpose.
Exactly. Thank you. I don't want to cut you off from something you wanted to say. So if there's something you wanted to add, please do. I think you were talking about the current use and...
Yes, thank you for... There will be greater use in the future compared to the leisure use that exists at the moment.
Yeah. And I think we don't have any evidence, quite understandably, of what the current level of use of that public right-of-way is. But clearly, we know it goes out across the field to Carter's Farm. So we're talking about, leisure use, perhaps dog walkers, that kind of thing.
I'd agree with that.
Yeah. And we know from I think Mr. Musk kind of alluded to it yesterday, the transport assessment. I don't think we need to look at it, but it tells us, I'm referring to paragraph 651 and 652, that there'll be a minimum of 107 trips. Perhaps I'll get you to look at it just so we can cover it off. So it's PDF 45. See, you're glad you didn't put it away now.
I was just thinking that.
Yeah.
Sorry, page 45.
PDF 45. There's a section 6.5 non-car modes.
Yes.
Yeah. 651 tells us, unsurprisingly, the trip generation is based on the census journey to work data. And then it tells us that there'll be a minimum of 107 trips on foot each day. And then also tells us about the cycle trips. But obviously I'm interested in the foot trips. So we've got a minimum of 107 trips on foot each day from the development. And we can agree, it tells us that's based on journey to work data. So obviously it's not accounting for, journeys to school or any other kind of journey purposes. So, whatever the current level of use is, it's clear, isn't it, that it will be dramatically increasing from where it is now. And it will also be, there'll be different types of journeys, different purposes, different times of the day, etc.
Yes, its utilisation will be different.
Yeah. Now, I know there was references in the Statement of Common Ground and so on to personal injury records. I think we've probably covered that adequately. I think we probably don't need to go over that again. I think we've reached a position on that we understand. In terms of the current use of the car park by cars and the volume of traffic, there isn't anything before the inspector, is there, in terms of figures, quantities, etc.?
I don't believe so.
No.
Obviously, the inspector will have been there and she will have a sense of the space.
Yeah, of course. She can see the size of it and can make a judgment, but we don't have anything kind of concrete on that. The width of the access road, or I think we referred to it as an alley earlier, I think. Mr. Musk says first of all, he said it was about 30 metres. That section between the end of it at Fairfield Terrace and the end of the car park is about 30 metres. Do you agree that that's, not to the nearest, 0.5 of a metre, but would you agree that's broadly accurate?
From Fairfield Terrace to the opening up.
Yeah.
That's broadly accurate. It's the length of a dwelling.
Yeah. And he says that the width of that, I think he's measured it, is between, I'm just talking about the access road between the dwellings here, between 2.4 and 2.75 metres, and I haven't seen any or heard any kind of dissent from that, so would you accept that as accurate?
I don't disagree with that.
Okay. And we can see from the drawings that it's not possible to provide a segregated footway to keep pedestrians and vehicles separate.
No,
So what I mean is there's not a footway with a curb that is separated from vehicles. They have to share the same width, don't they?
Yeah.
And in terms of the surface treatment that's proposed, we can see that because of the width of the access road, essentially that pretty much takes up the full width of the access, doesn't it? Because it's a 2 metre width.
Yes.
So there's not going to be a kind of discernible painted line that's for pedestrians and an unpainted area for cars.
There's no segregation,
No.
if that's the question.
But yes, but also there won't be, in terms of perception, you sometimes see, you know, we can all imagine a kind of painted cycle lane alongside a road, and you can see there's an area there for bikes, and there's an area, even if it's not physically separated, it's kind of demarcated, but it won't have that appearance because it takes up basically the full width of the road.
It won't have that appearance. It'll have the appearance of being painted in its entirety.
Yeah.
With road markings and signage relating to pedestrian use.
Yeah.
So it will no longer have the appearance of an access to a car park for vehicles. It will look like a pedestrian access painted, no footways except that. So its character will be different in those terms.
But that painting, it's not, it won't be kind of read as a continuation of, you know, that surface doesn't kind of continue, so it won't be read as a continuation. I mean, talking about the Fairfield Terrace Centre, you won't be reading it as a continuation.
Well, it'll
of that.
continue.
You'll just be entering it. It's a painted surface.
It'll continue from the back of the footway.
Yes, I understand
Yes.
that. Yeah.
So I suppose my point is a vehicle turning in will be met by a changed surface.
Mm-hmm.
New signage, changed surface. So visually, it would look different in those terms.
And this lack of segregation, so we've agreed that would persist for about the 30 metres of the access road, and then I accept, obviously, as it opens out in the car park, you will then see that area demarcated that's painted in the car
Yes.
park that isn't. So we've got 30 metres where there isn't any.
It's a shared surface.
Shared
for 30.
surface, yeah. Vehicles turning into the access road from Fairfield Terrace. I think there was a point made in Mr. Scarrett's evidence about they won't do a left turn, or they can't do a left turn, and they will instead drive down the right-hand side of Fairfield Terrace and will kind of approach in forwards. Mr. Musk's given his view about that. Can we agree that there's nothing to stop vehicles from turning left into the access road, and nothing's proposed to physically stop them, or no signage to tell them they can't do that?
Not that I'm aware of. Obviously, whether it's physically possible to make that turn. Just because something may be possible doesn't mean it'll be the movement that people make because of the perception of narrowness.
Does the inspector have any evidence about how?
Only her experience.
No. Okay. Right, lighting. I think we've agreed no illumination in that 30-metre access road itself. That would be unlit.
That's correct.
Yeah. Can we just go through how the evolution of this? So core document 1.9.
You'll appreciate I've not been involved in the evolution of this.
No, but I mean, I'm just going to take you through the documents and just see. I do fully appreciate that. Just want to kind of see for the inspector as well how I understand it's evolved. So core document 1.5 was an earlier iteration of the public rights of way improvement plan. I think this one is PO2. We're up to PO7 now.
You'll have to slow down a moment.
I'm sorry.
.107, did you say?
Core document 1.9.
Oh, hang on, 1.9. PO2, yeah.
Yes, that's version PO2, and I think we're up to PO7. We looked at PO7 earlier, and that's the one that's in the conditions and in the 106, isn't it? Although it seems like we might get onto PO8 potentially. But
Yeah.
But anyway, so this is an earlier version of this drawing, and we can see there's an image there's various images, but the one on the left-hand side, there's like an image of a dark path with some little lights on it.
Yes.
And it says possibility of low-level sunken lighting within the PRO area to improve year-round usability of the route. Further discussions with ABC to be undertaken regarding this. So we see that.
Yes.
Then can we go to core document 3.8, which you might still have open from earlier. That's that consultation response from Kent County Council, their letter. When you've got it, I'm going to page 3 of the PDF and paragraph 15.
Yeah.
It's saying, as presented in figure 4, I'm not entirely sure what figure 4 was at this particular point, but says, I do not believe the proposed revisions to the existing access car park are sufficient to make this an acceptable all-year, all-weather pedestrian route. The indicated sunken small-scale lighting, so that's what we were just looking at, is only suitable for wayfinding and would not contribute much to personal security. As there is little direct overlooking of this route, I would expect adequate lighting to be provided that would allow users to see and be seen. So that's what they were saying in November 2024, isn't it?
That's what that letter says, yes.
Yeah. And then if we go tracing it through further, that sequence of emails at core document 3.8a, which just going to the bottom of the chain.
Yep.
The bottom email within the second paragraph says KCC Highways has raised the question of lighting for the route comments attached, currently looking into options.
Sorry, you'll have to slow down.
Sorry.
Lost that. What is this 3.8?
3.8a, the emails.
Yeah, and
The last one, the bottom of the chain.
2nd of December.
It is the 2nd of December.
I didn't see that. What you just read out.
It's within the second paragraph, so the first kind of substantive paragraph there, halfway down. KCC Highways has raised the question of lighting, but you're looking into it. So that's from your transport consultant. So that's just following on from what we just looked at in the letter. Yeah. Then we have an email from David Kemp, who was the, as he sets out, this is 2nd of December still. He's just sort of introducing himself at the beginning of that email, pointing out that he's dealing with it as a surveyor to the landowner, and that's the capacity in which he's responding. The large paragraph towards the bottom of the page, about halfway down it, says the low-level lighting that's been advanced seems sensible and indeed acceptable from our perspective. Believe there's a question posed by KCC as to whether that is sufficient in terms of personal security for users of that connection at night. It may be possible to overcome this by erecting columns at the corners of the parking area in such a way so as not to further reduce the minimal width of the access strip, but shrouding of this for the adjacent homeowners and indeed the back population may need to be considered. So it was being picked, this prospect was being picked up with the council surveyor, making the point that, there's an issue with the width of the access strip and that KCC was suggesting that the low-level lighting wasn't really sufficient, so we can see that. Then we've looked at the current public rights of way plan and the lighting plan that we have. So we know that there isn't any lighting now included in that section. Obviously KCC on here, they've signed a statement of common ground. We can see what they said. We can see what's done. I don't know how they found those concerns to be resolved, but that's the position, isn't it? I mean, it was hoped to provide some lighting, but basically it wasn't possible. People weren't happy with it. Now there is no lighting and it's unlit.
lighting was explored.
Yeah.
Lighting in that section isn't proposed.
Yeah.
And KCC's conclusion is as per the Statement of Common Ground.
Yeah.
So ultimately, they formed the view that it was acceptable, deemed acceptable. I think that's the phrase. And safe.
This is
without the lighting that we're talking about.
This isn't part of the adopted highway, is it? It's a private access road, isn't it?
I think that's right. If I'm incorrect, someone will correct that.
I mean, I think that's
That's
fairly
the
clear
yellow,
from
isn't
this
it?
email,
That's the
isn't it?
yellow,
Yeah. And we know, and we've got the provisions in the 106, and we kind of know what the deal is with that. Okay. And just going back on one thing as well that Ken had said, they've made the point that there was little direct overlooking of this route. That's also correct, isn't it? There's not any kind of natural surveillance from the houses on Fairfield Terrace. When the proposed dwellings, we know about the landscape buffer, it's not really going to be visible or overlooked.
No, the dwelling side onto it. Mm-hmm. It's clearly an open and straight route. Mm-hmm. With a garden on the northern side.
Mum, I want to put down a marker here. I could see this line of questioning coming after you had asked about the lighting earlier. I've had my learned friend here look through every single passage in which Mr. Musk raises any issue to do with lighting, and I'm going to deal with it in my closings, but there is no point at all during any of Mr. Musk's evidence where he raises the issue of the lighting in this particular location as being a particular concern that could lead to safety issues. And I've got about 10 different references here. The only conclusion that he comes to is he says the additional lighting column was asked for by KCC, and KCC have confirmed that they have resolved their objection. Now this line of questioning is like, oh, well, this is what they wanted. This is not what happened. There isn't going to be overlooking. Next, we're going to be told that people are going to be accosted. So I'm putting down a marker here that none of this is part of the council's case. And if they're saying it's going to be a problem, they should tell us where that evidence is and how is that supported. Because this is just sort of an innuendo and a suggestion that something might or might not happen when the Highways Authority have asked us everything about what we need about the lighting, and we've complied. And so this is just not fair.
Okay, it's not innuendo. Mr. Musk addressed the question of lighting yesterday in his evidence in chief. That's part of his evidence. Our case is that this is not a high quality access, that there are safety concerns about the access, that it's not attractive. He's made that point. I am simply putting points that are in the documents that are part of the proposals. I'm entitled to do that. It's okay. He doesn't mention it in his brief. He mentioned it in his evidence yesterday. It clearly goes to attractiveness, which was going to be my next question to Mr. Jones, to agree that these points go to the attractiveness. We're talking about propensity to walk and factors that may or may not put people off walking. And I think it's a matter that you're entitled to be interested in and to form a view on. So I don't accept. Mr. Mohammed can say whatever he wants in his closing. I will say what I say in my closing. That's where we're at.
Mum, I think you'll be able to reach your own judgments on it.
Absolutely.
So I'm confident that you can. But the last thing I'll say is this. If Mr. Musk was unhappy about what KCC accepted and withdrew their objection, he could have gone to them, produced evidence, and we could have dealt with that. Instead, what you have is my learned friend reading between the lines of communications that they were not part of.
I'm reading the words on the page. I'm not reading between the lines. This isn't innuendos. I'm simply reading words on pages that are in the core documents and putting them to the witness.
The result of what we have is a series of discussions and communications with KCC. They've told us to do what they've told us to do, and they've taken away their objection. What you now have is an interpretation of those documents and Mr. Musk telling us through Ms. String that this is going to be an unsafe route. If it's about attractiveness, to say, well, it's not going to be that well lit, it's not going to be really attractive, I'm happy for you to hear that. But if the suggestion is that a woman might not be able to walk down this route because it's going to be too dark for her at nighttime, or that kind of innuendo, I'm not having it. And that's what this comes down to.
Right. Okay. So, I'll just say what I think from my point of view. That the plan of the route was put to me yesterday. It was in front of me, and the lighting was mentioned, and then again it was in front of me again today, and I'm perfectly entitled to ask a question about the lighting.
Yeah.
Okay, thank you. I mean, I don't know how the question is going to progress, but my understanding is it's about the quality of the route. And maybe this point I'm going to ask now. I hear that you say Kent County Council withdrew their objection, but I'm not sure. I think that their role is for highway safety.
Exactly.
My understanding is what you're saying is, and you drew my attention to what they said about. I can't remember, sustainability,
Yes.
or related to the quality of the route, which they
Yes.
mentioned. I don't know whether they withdrew any objection in terms of that. I don't know if that's part of their remit, so perhaps that could be clarified. Yes, okay, thank you.
Yeah, I mean, obviously, highway safety, and they have made comments about and requested lighting of the public highway on Fairfield Terrace. The point that Mr. Jones just agreed with me, and we can see in the emails, is that this car park and access is not part of the adopted highway. It's private access. I don't know. I can't say why they have formed the view that they did, and why the point that they made earlier has gone by the by. I don't know. That I'm not trying to invite anyone to speculate on that. I'm simply taking through the chain of events and seeing where we get to, and it's, you know, for others to say what they say about that.
That's just not how this works.
But it is how it works.
That's not how it works. It's not how it works. We're here and we're entitled to know what case we're here to meet.
The
It's
inspector asked a question.
No, your questions are perfectly valid, and I'm not talking about that. I'm talking about this sort of Donald Trump-esque, I'm just asking questions. I'm just asking questions. No, tell us why you're asking those questions and what you mean and what they lead to and what are the consequences. Then I can address it. It's not fair to just be like, let me ask you about this, let me ask you about this, let me see what happened here. Fine, but what is the point you're making? Because then I can deal with it.
Perhaps if you let me get to it, then you would find out, because it's not part of cross-examination to tell the other side all of the points that you're going to make and where you're going to be getting to. That's not part of this either.
Well, let's see if you get there anyway. So far you've spent a lot of time with no journey ending.
Madam, I'll carry on, thank you. Right. I just need a moment to remember where I'd actually got to with that. Yeah, okay, so we've agreed unlit. We've agreed dwelling side on, no overlooking or limited overlooking. These points are relevant, aren't they, to the attractiveness of the route and whether people will be willing or wishing to walk that journey, particularly when it's dark, if it's unlit and it's not overlooked. Those are factors that go to people's propensity to walk and whether it's something that they feel they want to do or whether they would prefer to drive a car.
They could be factors for some people.
Yeah.
At some times. At other times, they wouldn't be a factor.
No, I mean, in the middle of a summer day, when it's bright sun, you don't need lighting. I can understand it's not going to be a problem, but obviously you need lighting when it's dark. if it's dark and there isn't lighting, that may be a factor that will affect people's willingness to do that walk. won't it?
Yes.
Thank you.
And if we go back to the paragraph that we spent a lot of time talking about, it is a measure that reduces reliance on the private car. It's not replacing it necessarily. That isn't the objective.
Sorry, I'm just reviewing where I've got to here. Yeah, okay. We've been to it a number of times. The sentence that Mr Musk has referred to in the email from Kent County Council and their assessment that they don't consider this to be a high quality walking and cycling link, and they say it's not dangerous. Can you agree with me that the inspector is not bound to accept Kent County Council's assessment on either of those matters, in the same way that Mr Musk or the council were not bound to accept that view?
Not bound, but it's highly germane, and there would need to be compelling evidence to the contrary.
Yeah, I heard you say compelling evidence, but actually what the case law says is clear and cogent and compelling reasons. You're not suggesting, are you, that there needs to be some document or piece of documentary evidence in order for the inspector to be able to reach a different view from Kent?
I think the reasons will be based on evidence.
Part of that evidence will be witnesses' professional opinions.
Part of that evidence would be.
That evidence could entirely be professional opinions and judgment, because it's reasons, it's about reasons.
If they were compelling.
Yes. It is open to the inspector, if she thinks there are good reasons to be concerned about the safety of this route.
Compelling reasons, yes.
Then she is entitled to reach that view, notwithstanding that Kent find it acceptable.
As I said, she's not bound by that position. I'm sure any legal implications of that will be addressed in submissions. It's not. I'm not a lawyer.
And it is plainly correct from the face of the documents that both Kent and the council both consider the route to not be high quality, leaving aside safety. That's an agreed position between Kent County Council and the Borough Council.
Kent County Council say it's not high quality.
Not high quality.
They don't go on to explain what the definition of high quality is that they're using, but I accept that's what it says.
Yeah. And new development should be high quality, shouldn't it? The framework tells us that in various places.
It does.
Yeah. Madam, I think I've got to the end of the access and accessibility finally, and I'm about to move on to some of the policies, but it's basically 1 o'clock, so it's probably a good time to break for lunch, if that's okay.
Yes, I think so.
Thank you.
Okay, so we've got the conditions to do this afternoon, so I think we're still okay for an hour lunch, or do you want something a bit shorter?
I think we're okay. I'm happy either way. I mean, I suppose perhaps slightly shorter would be good, just to
Okay.
make sure we definitely.
Yes. Okay. So if we come back then at 1:40, please. Right. Thank you. We'll resume when you're ready, Ms. Drink.
Thank you very much. Good afternoon, Mr. Jones. You can put away anything, I know you've probably done this already, you can put away anything to do with access, accessibility, transport, so on and so forth. You probably just need your proof, the local plan, Mr. Williams' proof, I think, possibly the framework, possibly not. So I just want to go through some development plan policies now with you then. So can we start off with, I'm going to do them sort of in order, so SP1, which is on PDF 23, core document 6.1.
Yes.
And just in terms of how this policy works, we can see that it identifies strategic objectives to deliver the vision of the local plan, and that they form the basis of the framework in the local plan, as well as providing the core principles that planning applications are expected to adhere to. So this is obviously a policy which is setting out strategic objectives that all applications should adhere to. That's what it's telling us.
Yes, and it needs to be read with the more detailed policies in relation to various subjects that follow.
Yeah, and we can see kind of when we go through that, you know, certain of those objectives are then reflected in more detailed policies, as you say. So this is the overarching objectives. And we can also, I think, agree that these aren't alternatives. They're not. It's not a list of objectives where some are optional. The policy wants compliance with all of these policies. We can see the "and" in between the last two policy criteria, can't we?
Yes.
Obviously noting that, you know, some of those criteria might not be relevant to a particular application. For example, you've got H is about employment opportunities, and clearly that wouldn't be engaged. But so far as they're engaged, the policy is seeking all of those objectives to be complied with, isn't it?
Yes.
And so it follows that if one of those objectives, if there is a breach, non-compliance with one of those objectives, there is then a breach of the policy because it wants all of the criteria to be complied with.
Well, I take a different view to that. As I set out in Chief, you'd end up in a situation where you comply in part with the policy.
I can see that the number of conflicts is going to be relevant to weight. So clearly, if there's a conflict with one criteria, that might be given a different level of weight to if there's a conflict with 4 or 5 criteria.
All but one, yes.
But that there's a distinction, isn't there, between the question of whether there is compliance overall with the policy, which wants all of the criteria to be complied with, and then the question of weight, depending on the degree of compliance.
Yes.
Those are two different points, aren't they? Can we then agree that, given that the policy is written as a policy where all of the criteria are to be complied with, that there will be a breach of the policy if there is conflict with one, albeit that will get a different weighting than if there's breach with more than one?
Yeah. Conflict and accordance in part.
Just want to look at what you've said about this policy in your proof. So I'm on page 24. And you refer in paragraph 5.6 to criterion A and Hamstreet's role. At 5.7, you refer to other principles that are, as you've said, reflected in later policies. And you then say at 5.8, on the basis that the appeals scheme can be shown to accord with various relevant development policies, it can reasonably be said to accord with policy SP1. But it's right, isn't it, that we actually need to look at the criteria of the policy itself. The policy doesn't cross-refer to other relevant policies or make compliance dependent on that. We've got to go through those criteria.
Yes, you have to go through the criteria, but plainly, when we're talking about for example, to conserve and enhance the designated and non-designated heritage assets,
Yeah.
to establish the compliance with that, you'd apply policy ENV 13.
Yeah.
Yeah.
Okay.
Sorry.
Yes, okay.
Because EMV 13 says something slightly different to that criteria, because it allows for there to be harm, because it applies the public benefit test. So it would be wrong to end up in a position where you were able to satisfy ENV 13 and then said to fail the test in C.
I mean, would that necessarily be, just as a matter of principle, would that necessarily be wrong? Because obviously you can have policies that pull in, say, slightly different things and pull in slightly different directions.
Well, you have to read the development plan as a whole.
Mm-hmm.
And if there is if there is a specific policy relating to heritage, which sets out a test and you can comply with that test, as I said, it would be wrong to then to be seen to fail SP1.
Mm-hmm. Okay. You haven't, I think, in your proof, and probably that's why you haven't in your proof of evidence sought to go through the criteria one by one. You've got
No,
to
I
have
haven't.
an overview.
I've gone through the specific development management policies.
Yeah, okay. I just want to quickly go through them with you, if I can. So the objectives of policy SP1 that are in issue are A, B, C, D and F. A is about focusing development accessible and sustainable locations. Can we agree that that is applying to the particular site that the planning application that's being judged against this policy relates to? So it's about the location of the site rather than the settlement.
Ultimately, but it's talking about focusing development at accessible and sustainable locations. And there is this, we've been over this several times now, there is this balance between Hamstreet, a sustainable and accessible settlement, and then sites on its periphery. So as a matter of principle, development at Hamstreet accords with that. There's an issue between myself and Mr. Musk, between the appellant and the local planning authority, about the site.
Yeah, so you're not suggesting that the fact that the site is at Hamstreet, which is a rural service centre, is of itself meaning that there's compliance with this criteria. One has to also look at the site, and we've been through the accessibility, sustainability side of things.
It complies with A, but there are later policies that then the council say we offend.
Well, I think we also say you offend this one on accessibility. So I'm
okay. You say that as
I
well.
know we have different views on that, but the point is that it's not enough just to be at Hamstreet to be able to comply with this, because it's accessible and sustainable location. So that also falls in the side points.
Point, yeah.
Thank you. B, conserve and enhance the borough's natural environment, including designated, undesignated landscapes, biodiversity, etc., etc. There's obviously the point that I'm just going to come on to in a moment about paragraph 187. But in your proof of evidence, of course you don't deal with this in your proof of evidence, do you? You deal with that point under HOU 5E, I think, don't you? Let me just deal with it this way. Mr. Williams looks at SP1 in his proof of evidence. So he identifies, I'm on page PDF 53, page 51.
Sorry, I haven't managed to open his evidence.
Okay.
We moved on too quickly. I'm
Sorry.
afraid.
Yes, I'm sorry. It's probably worth doing. You're going to ask me for a core document reference next, and I don't know what it is.
No, it's okay. I'm just going to ask for your patience.
Quickly.
Sorry,
you can have that. 11.3, madam.
Sorry, what page?
I was on page 53 of the PDF.
Yeah.
Sorry, just bear with me a second. Yeah. Yes, it's 51 instead of 53. It's 2 pages different. Yeah, and so the first point I want to raise with you is at paragraph 7.3.2. Mr. Williams, in respect of SP1 criteria B, identifies some policy conflict. Do you see that?
7.3.2.
Yeah.
Create some policy conflict,
Yeah.
yes.
So I don't see in your... He's obviously identified a conflict, so level of conflict with that policy. You don't acknowledge that in your proof, do you?
I don't believe I do, but no.
And can I take this together with HOU 5E because it's essentially the same language in the policy? Again, looking at Mr. Williams' proof of evidence 7.35, he identifies at the end of that paragraph conflict with this policy based on a strict interpretation of its language, doesn't he?
7.3.5. Yes.
Whereas if I look at your proof, paragraph 5.3.4, where you deal with that same criterion, again, I don't see there that you've acknowledged that he's found a conflict with that policy. You don't identify any conflict in that paragraph.
No, although clearly the opening sentence there is acknowledging that it leads to change in the character and appearance of the site, and later on I refer to that being harmful.
Mr. Williams is obviously the landscape expert, and you've relied on his evidence. He's looked at these landscape-based policies and drawn conclusions. You do refer to some of his findings in this paragraph about there being adverse and beneficial effects. He says, and then you go on to talk about housing and open space and so on. Why don't you acknowledge that there is a policy conflict in terms that he's identified?
I don't do it in strict terms.
I mean, you've not sought to take a different view, explain why you don't agree with it. You've simply ignored what he said about that policy, haven't you? And about SP1.
No, I don't, because I've dealt with ENV3A and HOU 5 later on in my proof, and the character and appearance. And for the reason we talked about earlier, I focused on the development management policies rather than the SP1 policy.
Yeah, but I'm looking at your paragraph 5.4.3, which is 5.43, which is in HOU 5. You're talking about the development management policy here. You're talking about criterion E. I'm dealing with them together because the language is
yes.
similar.
Yeah.
But you've not acknowledged that there is this conflict here.
No, I haven't acknowledged in strict terms that there's a conflict, but I've acknowledged in that paragraph, I note that there are both adverse and beneficial effects in this regard.
Yeah.
Which is, when you read 7.31 to 3, 4 and 5 is what Mr. Williams is saying. There are benefits and harms.
And what you do refer to in paragraph 5.43 is other factors such as the provision of housing, habitats, recreational spaces and so on. But those aren't matters that are addressed in criterion that part of criterion E, are they? These are other points to weigh in housing delivery, something that would be weighed kind of in the balance. It's not something that's relevant to compliance with HOU 5E, is it?
Sorry, are we talking about HOU 5E?
Yes.
Bear with me.
I'm sorry to interrupt this. I'm having quite a problem with my laptop.
Oh, no.
So can we just, I'm going to try and, what's happening is the documents just aren't showing up. They're all open as
well, you do
tabs.
need to see them.
Yeah, so if, I don't need to adjourn, but if you could just bear with me while I just restart the computer and see if that's, yeah, thanks, sorry. Message here. It says update restart, and it's estimating 8 minutes, but there doesn't seem to be any option not to update it. Yeah. Should we take a 10-minute break and hopefully it'll be sorted out? Maybe they've just sent out an update to all our laptops without warning. I don't know. Okay, right.
Next then.
Yeah. So okay. So we'll come back at 10 past. Thanks. Right, okay, it's restarted, so hopefully it'll work.
Yeah,
Now,
back up and running. Always at the worst times.
Okay.
Right.
You just might have to remind me which CDs you're in, because I had to open them
Yeah,
again.
so I was in the local plan,
Yeah.
6.1, and then I had Mr. Jones's proof and Mr. Williams' proofs.
Yeah. Okay, I've got those three things up.
Excellent. Good. Great. Right, Mr. Jones, apologies, because I said we were going to go through them in order, and then I immediately started jumping around from SP1 to HOU5. So I think since we were looking at HOU5E, I might as well just continue and finish that point. And the point was just looking at that policy and that criteria. It's again that wording: conserve and enhance the natural environment and preserve or enhance any heritage assets in the locality. And the point I wanted to make was that in paragraph 4.53, where you deal with that criterion, you factor in matters such as the provision of housing and habitat creation and recreational space as part of a kind of overall balance. And I wanted to just have your confirmation that those are not matters that are relevant to compliance with this criterion. I appreciate that they're balancing factors in general, but those are not matters that are dealt with in this criterion of the policy, are they?
I don't necessarily accept that that characterisation, because what I've referred to there is new green infrastructure, landscape planting, habitat creation, recreation space, all of which are things related to the natural environment. And they all come as a consequence of the housing development.
Okay, let's go back to SP1, because that's where I started. And I think the reason I went to HOU5E as well is because of that language that we have in both of those policies of protect and enhance, conserve and enhance, sorry. And I just wanted to pick up on this point about paragraph 187, the framework.
Before you do that,
Yeah.
can I just draw attention to, again, one of these perhaps internal conflicts within the local plan, because B is talking about the borough's natural environment, whereas HOU5 is more specific than that. Or should I say it doesn't cast the net so far as the borough's natural environment.
Okay, can we just deal with this point about paragraph 187, please? Now, that's a point that Mr. Williams sets out in his proof where he's dealing with HOU5E. So it's on his page 54. And you obviously wrote
Sorry,
your...
just
Yes.
bear with me.
I'm not on 187. I'm on that point, but I'm not looking at that paragraph.
736.
Yes, 736. Yeah, that's where he deals with it. Now, you obviously wrote your proof in light of his evidence, didn't you? So you were aware of the point that he was making on this paragraph. Yeah, and the relationship with 187, you were aware of that. And notwithstanding that, you don't, in your proof of evidence, adopt that approach, and you haven't invited the inspector to apply that approach to the policies in your proof, have you?
No.
And can we agree that when approaching the exercise that's required under section 38.6, the task of the decision maker is to apply what the policies say to the proposal that's in front of them, and that's the wording that you apply, not different wording that's taken from whether it's the NPPF or some other place. You have to apply the development plan policies as written.
Yes, but there are sections in the NPPF which talk about consistency with the NPPF.
Yeah, and I don't see anywhere in your proof, no point has been made
No.
that there is an inconsistency.
No, but Mr. Williams clearly raises it.
But you're the planning expert, and you don't advance that kind of case.
No, but it's implicit in what Mr. Williams is saying in reaching his conclusions, which I've adopted. Explicit rather than implicit.
Just on that, the point about, the relationship between that requirement of conserving and enhancing and the National Planning Policy Framework 187, recognising the intrinsic character and beauty of the countryside. There's nothing inherently inconsistent between those two concepts, is there? There's nothing inconsistent between conserving and enhancing a landscape and recognising the character and beauty of the countryside. You can recognise it by conserving its positive characteristics. Would you accept that?
Bear with me. Do you mind just repeating what you said?
Yeah. There's nothing inherently inconsistent between the concept of conserving and enhancing the landscape and the natural environment and the concept of recognising the character and beauty of the countryside. You can recognise the character and beauty of the countryside by conserving positive characteristics of the landscape.
Yes, you can.
Thank you.
Paragraph 187 doesn't refer to conserving. That talks about contributing to.
Yeah.
Mr. Williams talks about the appeal scheme in the context of 187B contributing to the natural and local environment.
Okay. Just looking back on SP1 then and the criteria. So we've looked at A, we've looked at we've looked at A, we've looked at B. C, we obviously know what the issues are between us on heritage. D is the issues of accessibility and the prevailing character of the area. So the inspector's got our cases on that. And then F is those points again about sustainable transport modes and so on. So those are the, I'm not going to been through all those points, I'm not going to go through them, but those are the areas of disagreement. SP2.
Just before we move
Yeah.
on to SP2, I think it's worth noting the level of agreement over G.
Yeah, there's compliance with G. Subject to the cascade, obviously. Potentially.
Are we going to debate the cascade here?
Not here, no. But later. Yes. I think. Or perhaps not. We'll see where we get to. SP2.
Well, no, because we talked about the 106 this morning.
Yeah,
The
but
one-
can we? I want to just go through the policies first.
Fine.
I will talk about affordable housing later,
That's fine.
but I would prefer
You
to do it
raised
in my
it.
order. Thank you. I did. I did raise it somewhat off the cuff. It's fair to say. SP2. So what we have 1, 2, 3, 4, 5 paragraphs down is windfall housing development will be permitted where it's consistent with the spatial strategy outlined above and is consistent with other policies of the local plan. So the spatial strategy outlined above, I think, is the 2 paragraphs above that. You've got the first paragraph about Ashford and its periphery, and then you've got the second paragraph about development in the rural areas. Is that what you understand by the reference to consistent with the spatial strategy outlined above?
Sorry, I'm struggling to see the text. It's my eyesight. Well, I think we all understand what the spatial strategy is.
Yeah. And the spatial strategy, it tells us for the rural areas, includes suitability of sites and environmental sensitivity,
Yes.
doesn't it? Yeah. And so in the rural area, if the site is considered not to be suitable and there are issues with environmental sensitivity, it would not then be consistent with the spatial strategy.
It wouldn't be consistent with that paragraph.
That paragraph that says development in the rural areas.
Yeah.
Yeah. But then it then goes on to say that windfall development will be permitted where it's consistent with the spatial strategy outlined above. So that's what that's referring to, isn't
Sorry,
it?
yes.
Yeah. Yeah. And then, so there's that limb of compliance is it consistent with the spatial strategy? And then it also is requiring development to be consistent with other policies of the local plan.
Yes, and I talked this morning about the weight that will need to be given to some of those policies in the context of the housing position.
Yeah. So if, just in terms of compliance for now, if there are breaches of other policies of the local plan, then there would also, the development would then also not be consistent with SP2.
Yes, but you'd need to look at the weight
Yeah.
that you would give to that conflict.
No, I understand that, but we agreed earlier that there are two different, there's a question of, do you comply with the policy?
Matter of fact,
what is
and
the
degree.
extent of compliance with the policy? And then there is a separate question of what weight do you give to those conflicts or accordance. So that's where we are with SP2. SP6, I mean, I think it's really a case of just agreeing what the kind of parameters are. I think there's a disagreement between us on character, distinctiveness and sense of place, which is, you know, the kind of the landscape evidence. And yeah, so that's I think that's the disagreement between us on SP6.
Yes.
A, yeah. Then HOU5, so we've touched on that a little moment ago. This policy, just again in terms of how it works, I think you agreed in your evidence in chief, you drew attention to that, providing each of the following criteria is met. So again, we know it's a policy where you need to comply with all of those criteria to comply with the policy.
Yes, and at the risk of repeating the point earlier, there's a question of weight.
Yeah, exactly. And you've described it in your proof of evidence as a permissive policy, but we can agree that it is only permissive insofar as those criteria are complied with. If they're not complied with, it's not permitting.
Of course, yeah. The policy framework is a permissive one. And the policy itself is kind of performing, there's reference in the supporting text and you refer in your proof to kind of balancing different impacts and so on. The policy itself does that balance, doesn't it? It takes into account all of those various factors and considerations to give you the answer as to whether or not this is going to be an acceptable windfall development or not. It lists relevant factors. I don't think it performs a balance.
But isn't the balance the outcome of considering those factors?
That would be, yes.
We had the local plan inspector's report open earlier. I don't know if you've still got it open.
Could somebody give me the
6.3, madam.
Thanks.
And I'm looking page 36. It's paragraph 190. This is in the context of discussion about policy HOU 5. And about halfway down paragraph 190, the inspector says, in any event, the criteria within policy HOU 5 are quite demanding, so it does not provide carte blanche for every proposal close to a listed settlement. So it's not intended to be a policy that will necessarily be easy to comply with. That's how the local plan inspector was seeing it. Do you disagree?
Yes. He's saying there are policy provisions that will need to be complied with. I don't think I've ever said HOU 5 is carte blanche.
No. But it's not suggesting that you can kind of fail particular criteria or parts of criteria but still comply.
Well, in the circumstances that exist by now, you have to apply it with weighting the individual criteria.
Yeah. Your paragraph 5.46 is where you go through the criteria in HOU 5, and then paragraph 5.46 is drawing it all together. You acknowledge there'll be some adverse effects. These harms have to be balanced. You refer to the need to increase the supply of new homes, constraints elsewhere, spatial strategy, and you say this balance leans towards the grant of planning permission. You don't actually expressly address there the question of whether or not there is compliance with HOU 5, do you?
Not directly, no.
No.
Because we're in a situation where you apply those criteria with a degree of balance.
Yes, but again, I mean, I'm sorry to keep repeating the point, but we've got compliance and then we've got weight, and you do not set out there a conclusion. You don't say that there is compliance.
No, I don't.
You don't acknowledge that there is conflict either. You sort of dodge the question, if I may say so, in that paragraph, don't you?
Well, I think the concluding sentence is clear. The balance leads towards the grant of planning permission.
Right.
So there are a number of considerations in that policy, and when you look at them in the round, the balance leads towards granting planning permission.
Okay, so through those, B and D we've covered. They're the same. Those same issues of walking distance, accessibility, so on. E, I touched on with you briefly earlier. You agree with me that Mr. Williams identified a conflict with that policy based on its actual language, but you hadn't acknowledged that. F, again, Mr. Williams in his proof of evidence, 7.3.10, he identifies a conflict with criteria F, doesn't he?
Yeah.
But if I look at your proof of evidence again, I don't see.
No, I
any
haven't
acknowledgement of that,
imported those. It's inherent within the balance.
But why don't you? I mean, again, I just think, you note conclusions from, you refer directly to his evidence, you note conclusions that are positive conclusions in support of the development. It's going to function well, it's going to be visually attractive, mitigation, etc. You say that these are highly relevant conclusions in the context of the criteria, so you're looking at the criteria, but you don't actually acknowledge the key point that he has said there's a conflict. Why?
No, but I recognise that he says there is harm.
Where in this? Where you deal with criterion F?
criterion F.
Yeah.
Sorry, I thought we were looking at the whole.
No, I'm looking at F. So you deal with this at paragraph 5.44 and 5.45. And I just read out to you, the fact that you'd have referred to Mr. Williams' evidence. You've noted some positive conclusions that he draws about it functioning well, visually attractive, etc. You said that those are highly relevant conclusions to the criteria, but you don't.
That's
you
a fair
don't
point.
say he
That's a
found
fair point.
conflict, do you?
That's a fair point.
But why don't? I mean, why don't you?
I couldn't tell you why. It's just one of those things.
Because I think you did accept orally that there was. You do actually accept there is partial
I accept
conflict.
in many instances in this proof of evidence that there is a change to the character and appearance of the site, and that is a disbenefit.
So can we agree that there actually is a conflict with policy HOU 5?
In strict terms,
Yes.
But when you balance the factors,
But when you balance the factors, you're talking, there is non-compliance with that policy. When you're looking at 38.6,
in strict terms,
in the terms of the policy,
in strict terms, yes.
the correct terms on the language of the policy.
But when we come to apply the policy in the overall decision, we have to recognise the circumstances of some of those criteria which restrict the supply of housing land, frustrate boosting significantly the supply. They don't attract full weight.
But that is a separate question.
Yes, it is, yeah.
There is non-compliance with that policy. There is a breach of policy HOU 5.
Yes, but when we
Thank you.
when we do the planning balance exercise as a whole, those are relevant factors.
Don't disagree.
Thank you.
Completely relevant. When the inspector comes to the overall balance, she's got to weigh all these things up. But the starting point, as we know, is the development plan. Is the scheme in accordance with the development plan as a whole? Then you look at material considerations.
Yeah.
So there is a conflict with HOU 5, we've agreed that. It must then follow there's a conflict with SP1, mustn't it? And SP2.
Well, SP1 is framed slightly differently, isn't it?
Conserve and enhance the borough's natural environment. You've just agreed with me that HOU 5E...
But we're talking about a localised impact.
Right. So that's the distinction there. Right, okay. What about SP2? Consistent with other policies of the local plan?
Well, that would import itself into that, but you have to read the policy as a whole.
Yeah.
And we talked this morning about the housing shortfall, etc.
Yeah.
So the extent that this policy, HOU 5, is a restrictive policy, accept it's a weight point, but in applying the policy, it's clearly relevant.
Yes, but in terms of accordance with policy, it must follow there's a breach of SP2, mustn't it? That just has to follow from the language of the policy.
In part, not all of those criteria
SP2?
flow from one another. There's no "and" at the end of it, I don't think.
Windfall housing development will be permitted where it's consistent with the spatial strategy outlined above and is consistent with other policies of this local plan in order to ensure that sustainable development is delivered.
Yeah, and the opening sentence talks about an amount of housing that needs to be provided, which isn't being provided. So it would comply. It would contribute to that.
Yeah, but that's the overall housing requirement for the plan. It then sets out how that's going to be delivered. It sets out the spatial strategy for Ashford. It says about development in the rural areas. Then it talks about windfall housing development and tells us when that's going to be permitted. And there is a conflict with the policy then, because this is a windfall development and it's not consistent, it's not complying with that part of the policy that is the relevant part.
So you'd have conflict with that part and
Yeah.
accordance with the other part.
With which other part?
the contributing to the strategic housing requirement.
That's not a policy criteria for development to be assessed against, is it? I mean, otherwise, if you're right, any housing development will always be compliant with this policy, even if it's completely contrary to the spatial strategy, because it's housing. That can't be right.
The appeal scheme contributes important housing. It has harmful effects which conflict in narrow terms with 1 HOU 5. That is a factor that needs to go into the balance.
Mm-hmm. There is conflict with SP2, isn't there?
In that sense, in the narrow sense of that policy, that aspect, yes, but it contributes to other aspects.
So conflict with HOU 5, conflict with SP2.
In part.
In the relevant part that deals with windfall housing.
In the part that deals with windfall housing, yes.
Yeah.
But in the context of the
because we're not
housing
interested
requirement.
in development at Ashford. We're not interested in allocations.
No.
Yeah. Okay. ENV3A, landscape character and design. So that's at PDF 303 of the local plan. And let me just find where you deal with it in your proof. That's at page 32 of your proof. Looking at paragraph 5.55 there, halfway down, I agree with Mr. Williams' analysis. You're going to sense a theme here. Mr. Williams finds a conflict with that policy, doesn't he, in V3A in his proof of evidence?
Do you mind just directing me to that?
7311 of his proof.
Says there is partial conflict.
Yeah, the local landscape character guidance, which,
Yep.
if we remind ourselves, is criteria H of
Yes.
the policy. Once again, in your proof, we see reference to his evidence, reliance on his evidence, but you do not accept or acknowledge conflict.
I don't refer to that conflict.
No. And that conflict with the landscape character guidelines, which feeds through into the policy, is something that's agreed in the landscape statement of common ground, isn't it? There's no dispute about that.
I don't believe there's dispute about that, no.
So you've got to agree there's a breach of this policy as well, haven't you?
In the terms that Mr.
Yeah.
Williams does, one criteria.
And again, I mean, at the risk of repeating the point, we see again that and in between criteria I and J. So again, it's not a list of criteria where comply with some, don't comply with others. It's a cumulative list, isn't it, again?
Yes, although the introductory sentence is somewhat different. It's asking us to demonstrate particular regard.
Mm-hmm.
I don't see it saying we have to comply with all of those.
But that does seem to be how criteria H has been interpreted, because having particular regard to the landscape guidance, here we've got conflict, that's fed through into a conflict with the policy. Yeah. And just while we're here, we can see that I think A, landform topography, obviously that's something between us, and pattern of settlements is something in E that's been obviously referred to, so those are also...
We're going back.
I know we don't, week, obviously Mr. Williams doesn't find conflict there, so that's something where there is a disagreement.
Your case, yeah.
But there is agreement on H. Yeah, okay. Can I just go back on SP6 actually, because if you agree that there is conflict with HOU 5, E and F, doesn't it follow that there's conflict with SP6A positive response to character distinctiveness and sense of place. Isn't that logical?
Well, it's requiring a careful consideration and positive response to those matters, those design matters. And we've got Mr. Withycombe, as I understand it, saying that once the principle, if the principle is accepted, the appeal scheme is appropriate in those terms. That's how I understood his evidence.
Well, I think the way he put it was it sort of falls at the first hurdle, or words to that effect. I'm slightly misremembering possibly what he was said a week ago, but he essentially is saying, you know, because of its location, it can't have a positive response to character because it's in the wrong place. So surely that must follow that there is a conflict with that criteria based on the other conflicts you've identified.
No, I don't accept that, because
No.
it's talking about high quality design. And we're not at the detailed design stage. What design material we do have, once we've cleared Mr. Withycombe's hurdle, if we clear Mr. Withycombe's hurdle, he's content, without wishing to put words in his mouth, that SP6 can be achieved.
Okay, well, we'll have to leave that as an area of disagreement between us then. So,
No,
Ian,
I'm not sure. I think he did agree that. That was his position, wasn't it?
no, I don't think well, I'd have to look back over my notes to see exactly what he said about SP6, and I don't want to take time to do that now. I think that does remain an issue between us, but I'll review. EMV 13 is heritage, and we know that reflects the framework in terms of the heritage balance for less than substantial harm. Can I just pick up on one thing that you say in your proof, please, at paragraph 5.60? Because it's a point that was made in opening as well, and I just want to be clear what the appellant's position is on it. It's this point about how the local authority hadn't articulated the extent of heritage harm prior to Mrs. Connolly-Moss's proof. And you say at the end of this paragraph, you say, it's now sought to claim that they judge the harm to be moderate in the scale of less than substantial, but I'm bound to observe that it's only done this to contrast with and counter the appellant's low-level, less than substantial harm. Can I just be really clear about what you're saying here? Are you suggesting that Mrs. Connolly-Moss, that her evidence doesn't represent her genuine opinion? That she's only saying moderate to... that she sort of made that up in response to the appellant's case. Just want to be really clear about it.
Just bear with me while I find the relevant passage in the Statement of Common Ground. So the Statement of Common Ground says, 3.7, Miss Connolly-Moss has formed the view that the appeal scheme...
3.7... Sorry, you're in the Heritage Statement of Common Ground?
No, Planning Statement of Common Ground. My apologies,
right.
Planning Statement of Common Ground.
3.7. Right.
Miss Connolly-Moss has formed the view that the appeal scheme will result in a moderate level of less than substantial harm in response to the appellant's low level, less than substantial harm. I don't know at what point she formed the view that it was moderate. It wasn't at the point the statement of case was written. It arrived thereafter.
I mean, so where did that take things? Like, what should the inspector take from that?
It's just an observation.
Right.
As I say, I'm bound to observe.
Okay.
It wasn't front and centre in the council's case at the point it determined the application or the statement of case that it was moderate harm.
So we're not, there's no, it's not, because it seemed like it was being implied, and this was in opening as well, that somehow I don't know, that there was something slightly underhand going on, or that this wasn't a kind of genuine assessment in some way, but the appellant accepts that her evidence, she's put a declaration in her proof of evidence that is genuine evidence.
I'm not casting any aspersion in terms of the way she's set out her evidence.
Thank you.
I'm simply recording the chronology of what's happened.
Okay.
And the wording in response to was something Mr. Moss and I exchanged correspondence on. And he agreed it was in response to the appellant's low level, less than substantial harm.
Okay. No, that's fine. I think it's just so the inspector kind of knows, what the positions are. She can take that as being the genuine assessment. She's got the appellant's assessment. She then has to weigh those up.
Yeah, I'm not suggesting that isn't the
Fine.
assessment that needs to be undertaken.
Good. I just wanted to make sure that was the case. So your proof at paragraph 7.23. Not 7.23. Hold on. 7.22, sorry. Dealing with the heritage harm and weight to be given to heritage harm. So you say, whilst affording great weight to the conservation of a heritage asset, I attribute limited negative weight to this heritage harm. Obviously, we went through this yesterday with Mr. Musk in terms of the difference between conservation and harm and so on, so we'll just go over it with you. Have you got the framework there in front of you? Just want to look at the glossary and the definition of conservation. On the PDF, it's 72. And indeed on the hard copy, it's 72. Conservation for heritage policy is the process of maintaining and managing change to a heritage asset in a way that sustains and, where appropriate, enhances its significance. So, sustaining significance must mean not harming significance, avoiding harm, preserving, conserving. That's the sense of it, isn't it? So where we see conservation, that involves avoiding harm to heritage significance. We see that word, that's what it means. We can leave enhancement out, but we're not worried about enhancement right now. But when we see the word conservation in the framework, we know that means avoiding harm.
Yes.
Yeah. So if we look at paragraph 212, when considering the impact of proposed development on the significance of a designated heritage asset, great weight should be given to the asset's conservation. So that's telling us great weight should be given to avoiding harm to the heritage asset.
Yes.
So, I mean, logically, if you're going to give great weight to avoiding harm, you have to give great weight to the harm, don't you? How else do you give great weight to avoiding harm?
I have in my mind the great weight that needs to be given to the conservation of the heritage asset.
Yeah.
And then I have, on our case, low level, less than substantial harm to the heritage asset. And then I contrast that to the public benefits.
But so how does the great weight... Sorry, Karen.
And is there convincing justification for that? And I conduct that heritage balance, and I find the harm is outweighed, the low level, less than substantial harm is outweighed by the public benefits.
But so how does the great weight given to avoiding harm, you've told that it's in your mind, but it doesn't, in your approach, feed into anything?
Well,
because you just keep it in your mind, but then you weigh a low level of harm.
It feeds into the way I balance low level, less than substantial harm against the public benefits.
Madam, what I think I might do, because I think there is obviously there's sort of a legal point here around what conservation means and what the courts have said about that. I know the case law is not currently in the court documents, so I'm not going to start putting, case law in, but I think I may ask to add a couple of cases to the court documents and refer to them in closing, and I'll provide them in advance to Mr. Mohammed, just to cover this point, because I think we'll stray into, and I don't think it's fair to Mr. Jones to kind of make points when the cases aren't in front of him and they're legal points on case law anyway. So I think that's what I propose to do, rather
so
than
you'll
take it further here.
You'll make those points and submissions.
Indeed.
Yeah, okay.
Thank you. Okay, I don't think we need to go through the TRA policies in particular, only to, we've covered the cycling point and how the inspector needs to perhaps approach that differently to how we'd previously thought that she, or I had previously thought that she did. So I won't go through those in detail. So section 38.6, we know that's the starting point. We've got to consider whether the appeal scheme is in accordance with the plan as a whole. Then we've got to move on to material considerations, the framework, balance, weight, and so on. You have accepted there is conflict with HOU 5.
A part of HOU 5, yeah.
But we've been through the fact that
Yeah.
HOU 5, to comply with that policy, the demanding criteria requires all of the...
But in judging compliance with the development plan as a whole,
Yeah.
you've got to recognise the narrow point of conflict.
You've got to recognise that policies point in different directions and can pull against each other, but you have to form a view on a policy like HOU 5. Does it comply with that policy or not? And then you've got to weigh that and the extent of compliance. We've got a breach of HOU 5, we've got a breach of ENV3A, we've got a breach of SP2, agreed. You can't maintain that this scheme is in accordance with the plan as a whole. I know what you say about weight, but for that starting point, you surely have to accept, based on what you've accepted today, that that is the starting point.
It's written here, substantial accordance with the development plan when read as a whole.
Yeah, but substantial accordance means you're accepting
That there
there
is
are
some
conflicts.
conflict, but when read as a whole, the appeal scheme substantially accords with the development plan.
Even though policy HOU 5 is the kind of key policy that deals with the acceptability of windfill developments, and even though SP2 is the key spatial policy.
Yes, because they're narrow conflicts.
Okay, we'll obviously leave that there. On 11D1 of the framework.
Sorry, just on that point.
Yeah.
If that is going to be your closing based on the way you put it, if there is case law that you wish to rely on to support that point, I'd like to see.
Sorry, which point?
Just
Sorry,
the
which point now?
That, the fact that you're saying if you contravene HOU 5 in the way that you're saying,
Yeah.
not in the way that Mr. Jones is saying in terms of in part, but if you're saying we fail to meet the whole of HOU 5 and therefore that means you do not accord with the development plan as a whole, which I think is what you've just been saying, if that has a legal support and a case law to put that, I'd like to see that as part of the closings as well, please.
Well, you'll appreciate there's not a case law on policy HOU 5 and what would amount to
There is
compliance.
plenty of case
we
law
know
on
the case law on
policy interpretation.
Corbett and Cornwall.
Plenty of
that.
cases on policy interpretation. That's what the courts are there for.
I-
A matter of judgment for the inspectors on whether or not how you
Yep.
deal with compliance with policies, but there's plenty of case law. So if you're going to put in
Thanks,
your
yeah.
closings,
I am familiar with the case law as well.
but I'm just saying, if you
It's
are
a
going
matter.
no. Let me finish my thought.
Go on.
If you are going to submit in your closings that failure to meet HOU 5 means that we fail to meet the whole plan as a whole, when you're looking at section 38.6, I'd like to see the legal proposition.
Well, that would be a matter of planning judgment, clearly. We know the parameters of how one weighs up policy compliance and the development plan as a whole. So, I mean, no, I'm not going to be putting in a case that says if you don't comply with policy HOU 5, you will then not comply with the development plan as a whole, because that is a matter of planning judgment, applying the established principles. So no, I won't be putting an authority in. Hopefully you'll be putting one in then that says the opposite to that.
Oh, I can put plenty of cases that make it very clear that failing one policy does not mean we don't meet the policy as a whole.
Yeah,
So I can
it's
find
not,
that
yeah,
for sure.
there's three, obviously there's three here. Anyway, look, I'm not here to debate with you about it.
No, but it's important that if you're going to say that in your closings, I have to have an opportunity to deal with that one. It's only fair.
You will have the final word.
No.
You will have the final word in your closings.
If you very fairly said you were going to put in case law on the heritage and conservation point,
Yes.
that's great, I can deal with that. But if you're going to put a case to say that failure to meet one policy means you failed to meet the development plan as a whole, I would like to see that in advance.
Yeah, I've just said I won't be, and it's also not the case that it's failure with one policy. It is common ground now that there is non-compliance with 3 policies, and the inspector will be able to assess, and these are very well-established principles that we can all apply. So,
I think you've got a point, so I won't.
it's very distracting to be trying to kind of work through in a sequence and then be kind of interrupted and taken on a diversion, and then it then takes me time to kind of get back to where I actually was.
Yeah.
And anything that needs to be said about what may or may not be in my submissions doesn't really need to be interrupting my cross-examination. It's not really fair to keep interrupting me and throwing me off the...
I'm entitled to interrupt if I disagree with something, and I need to understand the case.
But you weren't disagreeing with something.
I am
Okay.
disagreeing with you. If you it's not
Right,
possible
can
for
I-
you to
sorry,
get
can
your
I just
thoughts
stop
back,
this?
That's not my fault.
The point you made before was about whether, maybe I've misunderstood, but you say Ms. String shouldn't say that the proposed development is in conflict with the development plan as a whole, and if she were to do so, she'd have to put case law in.
Yes.
And Ms. String says, well, that's not right. It's a planning judgment, which I presume anybody's entitled to make if it's the council's judgment.
But the interpretation of policy and how we approach development plans is a matter for the courts. I agree with you that the application of the policies and whether you decide we conflict with this or that is a matter of judgment. But what I'm trying to get an understanding of is what's being put to Mr. Jones is that failing one policy...
I didn't say that. I'm sorry, you're completely mischaracterising everything that I say. I've not said
Right.
that.
Okay. I think we might need to have an adjournment where I speak to both of you.
Sure.
Yeah.
Thank you.
Yeah. Can we just go to my retiring room, please?
Thank you.
Shall I continue, Madam?
Yes, thank you.
Thank you. Right, I'm going to get on to benefits of the scheme for the purposes of the tilted balance if we get to that point. I think the strong reason for refusal, I think we're fairly clear now what the parties' respective cases are and kind of what the inspector should do if she agrees with us or if she agrees with you. So we move on to the benefits of the scheme, please. Now, on housing delivery, you, in your proof of evidence, on pages 48 and 49, I think you identify a benefit of housing to contribute to the overall plan requirement and sort of longer term. And then you also refer to benefit of housing to contribute to the housing land supply shortfall in the short term.
Yes, there is and has been a shortfall in the number of completions hitherto in the plan period, almost 3,000 dwellings.
Yeah.
That's separate from housing land supply going forward.
Mm-hmm.
So there is no prospect at the moment, or indeed at all, of the requirement in SP2 being met.
Sorry, carry on.
So in that regard, I see the appeal scheme having an important role, and I've given its contribution in those terms substantial positive weight. So there is a plan requirement, and then there is the boosting supply.
Mm-hmm. Yes, and I'm going to deal with both of those. So shall we deal with the short-term supply first? And we're concerned in this inquiry, we've got the housing land supply evidence is covering the period, the 5-year period, which ends on the 31st of March 2029. So that's in terms of contribution to housing land supply shortfall, that's the period that we're interested in this inquiry, isn't it?
Yes,
and beyond that is the longer term.
We're a year and a half into that.
Yeah.
And there will be a new 5-year period.
Yeah.
From 31st of March 2025.
Yeah.
And we're in the hands of the council as to when it produces that material.
Indeed, but for this inquiry, all the evidence is based on the current period, and
yes.
that's what's before the inspector.
Yes.
Now, you, in your proof, paragraph 7.7, you give substantial positive weight to contribution to housing land supply in the short term. You don't, do you quantify anywhere in your evidence what that contribution would be?
No, I don't.
No.
But I hope the insinuation isn't that this scheme is not going to contribute within the 5-year period, and indeed make a substantial contribution in the 5-year period.
There is the inspector doesn't have any evidence of what that would be. There isn't anything set out in your proof of evidence as to what you're relying on. That's correct, isn't it? You just agreed that with me.
That's correct.
Mm-hmm.
But for the avoidance of doubt, my oral evidence is that the appeal scheme will make a substantial contribution, the 140 dwellings substantially contributing to the 5-year period. And I'm happy to go through how I arrive at that.
The appellant is a promoter and not a developer, so Hallam will have to sell the site to a developer in order for the development to progress.
Yes, and all of the examples given in the appendix are based on that model.
There isn't any evidence that's been put forward in this case of any house builder interest in this particular site.
No, and I wouldn't necessarily expect there to be.
It would be so that Hallam's sort of role in this is to hopefully secure an outline planning permission, but it would be for the developer who ultimately then acquires the site to prepare and submit the reserve matters, wouldn't it?
Yes.
And obviously no work will start on the reserve matters until the site's sold, clearly.
No. Certain work could start on the discharge of conditions.
By who?
By Hallam. I've certainly got experience of that elsewhere.
There are a number of pre-commencement conditions that would have to be discharged, whether that's by Hallam or by the developer before any development could commence.
That's correct. That's normal.
You referred to the note in your Appendix 1 that sets out an average of 1.91 years from the grant of outline approval to the first reserved matters. Can we agree that the first reserved matters approval is not necessarily the final reserved matters when you have a full permission? It would be up to the developer whether they submit all the reserved matters in one go, or they might do a number of different reserved matters submissions.
They could, but in my experience on a scheme of this scale, it will be a single reserved matters application. There's nothing particular or peculiar about this scheme that would warrant any sort of phased implementation of the reserved matters applications.
But fundamentally, a matter for the ultimate house builder developer that acquires the site.
Yes, and I'm sure having purchased the site, they would want to move that forward as quickly as possible.
The note that is in your appendix, see, that comes from Hallam. It's not from you're the author of that. You're producing it. It states, I'm on PDF 64 at the moment, within the note. Further evidence regarding deliverability nationally is set out in the table attached appendix. I'm in the middle of page 64 here.
Sorry, I'm in a hard copy.
Oh, are you? Well, I don't think it has a page number because it's your appendix,
No.
but it's the second page of the note.
Okay, thank you.
It's about halfway down. And there's that table, and it says this summarises a selection of recent Hallam Land residential development sites, each comprising between 100 and 400 dwellings, which have been disposed of to developers over the past 5 years. It's not claiming, this is a selection of sites, it's not claiming to be a comprehensive set of sites. The average that's derived isn't purporting to be an average based on all sites. It's a selection.
No, it is a selection, and I'm aware from involvement elsewhere that there are other schemes which are significantly larger in scale, which wouldn't be representative of this scheme. Hence, it's a selection.
There's the Southern Water. Sorry,
Ms. Dreen. Can I go back a step? Because earlier you asked me, was it 1.9 years to the submission of reserve matters application?
Yeah, 1.9. Well, it says 1.91 years. Well, I'll read directly from the note. The average time from outline approval to a deliverable consent, i.e. approval of first reserve matters, is 1.91 years.
Yes, approval of first reserve matters. Sorry,
Yeah.
I'd misunderstood. I thought you'd said submission.
No, approval. Obviously, that's an average.
Yes.
So some sites will take longer, some might be shorter.
And some might be shorter indeed.
We don't know where this site might be, whether it's going to be one of the shorter ones, whether it's going to be one of the longer ones, whether it might be average, we don't know.
No, so the average is a reasonable figure to take.
Sorry to bear with me. Thank you. Taking that 1.91 for reserve matters, there's obviously the usual condition that's would be imposed about, timescales for the submission of reserve matters. And my understanding is that Mr. Musk was seeking for a shorter period of 2 years for that to take place, but there was pushback on that, and so it's a 3 year. Is that accurate?
The first draft had 2 years.
Yeah.
I altered that to 3 years.
3 years.
And there was no pushback to that.
So although there is this note saying 1.91 years to approval, when it comes to the actual condition, the appellant isn't willing to reflect that in a shorter period, are they? You've not accepted the 2 years, you've gone for a higher figure.
I altered it to 3.
Yeah.
If in some way this is germane to the view that's taken of the deliverability of the site, a conversation between Mr. Musk and I could have yielded a different view of that. There was no conversation about a perception of importance of it being 2 years rather than 3 years. These are only draft conditions at the moment.
Mm-hmm. Sorry. Okay, can we just move on to Southern Water, please, and that issue? So there's the appellant's note at core document 1214.
Do I need to open that?
I think probably it's a good idea.
1214.
1214, yes, it's the new one. It's that one that didn't have a number, or one of the ones that didn't have a number that we added into the, I think it's the miscellaneous folder, isn't it?
Yeah, mine. Sorry, I downloaded the core documents, the latest version, and it only goes up to 12.
I think you probably don't necessarily need it in front
Okay,
of you, although in
right.
fairness, Mr. Jones might want to have it in front of him.
Sorry, could you remind me of the number again?
Yeah, it's 12.14.
12.14.
Yeah, I mean, again, you may also not have it. You might have it separately as well.
I've got the same problem as the inspector has.
Do you have it to hand anywhere? Shall I see how we go? Because I think you probably are familiar with what's required.
Okay.
Let's see where we get
Let's
to.
see how we get on.
In that note, it details essentially there are two upgrades, two pieces of work effectively that need to be done. There is there's the Hamstreet wastewater treatment works that have planned improvements, which I think we have clarified don't have any impact on the delivery of this site.
Correct.
Then there is also separately improvements that are required to the sewer network between the appeal site and the wastewater treatment works.
Correct.
There needs to be some sort of reinforcements or works done to that.
Correct.
And that is the piece of work that the 24-month figure in the letters refers to.
Yes.
Yeah.
The correspondence as a whole refers to the need for upgrades to the sewer.
Yeah.
It refers to modelling, hydraulic modelling needing to be undertaken, and that there may be capacity for a lesser number of dwellings before the upgrade is needed.
Yeah. So it says, and I think you're referring to the same letter that I am looking at, which is
I am talking from memory.
Yeah, no, I know you are. And for the inspector's note, it's PDF 8 of that document, it's a letter 23rd of May, which I think is the most up-to-date letter. And then we have that later email. And it says that Southern Water have undertaken a desktop study of the impact. That initial study indicates that additional flows might lead to an increased risk of foul flooding. Southern Water will liaise with the developer to review the timelines. As you say, it may be possible for some initial dwellings to connect pending network reinforcement. Southern Water will review and advise on this following consideration of the development programme and the extent of network reinforcement. So uncertainty there. We don't know at this point whether that will or not be the case. It depends on when they've reviewed a programme and worked out exactly what they need to do.
Yes.
Yeah. They then say that Southern Water will carry out detailed network modelling, which you just referred to, as part of this review, which may require existing flows to be monitored. This will enable us to establish the extent of any works required. So they've got to do modelling, and they might have to do flow monitoring to work out what it is that they need to do.
That's what the correspondence alludes to, yeah.
Then they say they'll endeavour to provide reinforcement within 24 months of planning consent, full or outline. However, for more complex applications, our assessment of the timescales needed will require an allowance for the following, which may result in an extension of the 24-month period. Initial feasibility, detailed modelling and preliminary estimates, flow monitoring if required. So it seems, we know that there's going to be modelling. There might need to be flow monitoring. There are some indications then that this could be one of those cases where it might be longer than 24 months, aren't there?
I'm not qualified to confirm that. I'm not an engineer, utilities engineer.
No.
I recognise the letter says it could take up to 24 months. I think that's right.
Well, it says that there are factors that might result in an extension of the 24 months.
Yes, but the starting point is it could take up to 24 months.
But then also that it could take longer because there's detailed modelling which we know is needed.
For larger, more complex projects. That one of the pieces of correspondence talks about larger, more complex projects. Because that's a footnote that's in the note. There's been no suggestion from Southern Water that this is one of those larger, more complex projects. There have been larger, more complex projects at Ashford, which has required a whole new, in turn, super sewer to be constructed. We're not in that territory.
Do we know how they define that at all? Have we got anything before us as to how they define that?
Well, in the context of the works that have been needed in Ashford, those complex works have been associated with thousands of new homes. This is 140, but I don't have a definition of 140, of large and more complex.
No, okay. All right.
But
yeah, go on.
Sorry, that's leading to occupation, isn't it?
No, I know. Well, I was going to come on to that because there is, obviously that leads to a condition whereby, as I understand it, there needs to be submission of a strategy that includes details of the delivery of the reinforcements and then no occupation until connection in accordance with that strategy. But obviously, there's obviously uncertainty then around when dwellings could be occupied, depending on that. So no house builder's going to start delivering houses, are they, until that's resolved?
And that's why I alluded to Hallam, in some instances, taking on the responsibility for discharging that type of condition in order to de-risk the sale.
You're not employed by Hallam, you don't know whether or not that would be the case here or not, do you?
No, but I have many years of working for Hallam, and I am very familiar with the pre-commencement conditions that they will take on in order to reduce that risk and reduce delay.
Can I go back on the contribution in the 5 years? Because I think you said a moment ago that there would be 140 dwellings in 5 years.
I said a substantial element of that.
I said to avoid doubt, we'll make a substantial contribution of 140 dwellings in 5 years. So how are you... So you're not saying 140 in 5 years?
Well, it could be.
It could be.
It could be. It could be less than that. But either way, it'll be a material contribution to the 5-year supply. And there's no evidence being put to suggest it won't contribute materially to the 5-year supply?
Well, I mean, I think in fairness, it's a point that you obviously positively rely on as a benefit of the scheme and seek to attach weight to it.
Yes.
So if that's something that you want the inspector to attach weight to, it's probably for you to make that good. And I think
But there's no evidence coming the other way to suggest otherwise.
Which is why I put it to you. The inspector doesn't have any evidence
Well,
of the likely contribution, other than you've made an assertion today in cross-examination that there will be a substantial contribution.
Yes, that's
the
the
position.
oral evidence, yes.
That is the oral evidence. Okay, well, I think that's clear. Okay. Longer term. So we're talking now beyond the current 5-year period.
We're talking to the end of the plan period. It so happens that 2029 is very close to the end of the plan period.
Indeed. Yeah. But you talk about longer term. You're not just talking about just to the end of the plan period, because as you say, I mean, we're basically talking about almost the same thing there. So if that's the position, then these are not really two separate benefits in a way, are they?
Sorry, I don't recognise the reference to longer term.
Okay, let me just find.
I might be mistaken.
Let me just make sure that I've got it right.
7.6 is talking about the housing requirement in policy SP2. There is a sentence later on that talks about the longer term, but that is in a different context. That's in the context of Ashford's housing requirement not diminishing in the longer term.
Yeah, the need for new housing in Ashford will not diminish in the longer term.
Yeah.
So you're not seeking to place weight on anything beyond the end of the plan period then?
No, it's the contribution to the strategic requirement. The point of referring to the long term there was to illustrate that the housing requirement is not going away. So it gives reassurance to the inspector that it's important that this site comes forward. And in fact, the housing requirement goes up in the new local plan. We heard that yesterday.
Yeah, and we know, I mean, obviously you refer in your evidence to the emerging local plan and the process, and heard what you said about the timescales of that. You say in your proof, I think, let me just make sure I've got the right reference here, it's at 646 to 649 that you deal with that. Where you're referring to the local development scheme, and that it sets out. I don't think that's actually in the documents, but it sets out, as you say, the Reg 18 consultation in the second quarter of 2025. That's currently running. I appreciate it didn't start in the second quarter, but it's running between August and October, so it's in the third quarter, tipping over. So
yes, I acknowledge.
We're broadly on track with that, aren't we?
Well, behind.
With one
but
quarter.
You've started, yes.
Yeah. Yeah. And you say, you make the point orally as well, 649, you think it's ambitious to complete adoption in 24 months.
Yes. Based on where we are with the current consultation document.
Yeah, based on where we are. But would you accept that it is reasonable to assume a new plan will be in place by the end of the current 5-year supply period, so 2029, to address kind of housing needs beyond that point? That's reasonable.
There's the possibility of that, subject to the progress that's made on determining strategic directions of growth at Ashford, identifying housing allocations across the remaining parts of the borough, and I've said neither of those are easy undertakings. So there is a possibility of it. But you'll appreciate that the housing land supply pursuant to the local plan won't arise for a few years beyond that.
No, but, well, yes, I suppose I'm not exactly sure when the plan period will start to get into all of that. But I mean, that's for that period, the end of the current 5-year supply period, it's almost 4 years away. So it's likely that there will be a plan-led solution to dealing with longer-term housing needs in Ashford by that point.
By 2029, 2030, I think that's the point you're making, there could be a local plan that allocates development land for the next decade, up until 2042. What I'm saying is that that process does not provide a plan-led response to the failing of delivery of housing either in this plan period or the 5-year supply requirement. I think it was accepted yesterday, the only way planning permission is the only way to achieve an improvement in that 5-year land supply position is through the grant of planning permission. That should not be a controversial statement.
No, indeed, which is obviously why we were discussing the contribution that this site would make, and we've been through that. Can I just touch on Stodmarsh? Can we agree, because your proof, I'm looking at paragraph 513, you refer to it delaying development and it's an impediment in the short term. We can agree that this is a temporary constraint that will be overcome, can't we?
It's been a temporary constraint since 2020.
Yeah.
It has taken a long time, 5 years, to get to the position that the Borough Council have got to.
Yeah.
There
So
is,
is it yes?
there is a mitigation strategy. What we don't know is when that mitigation strategy is going to assist in delivering housing and at what rate. We have a sum of money, we have a scheme, we have an identified amount of dwellings that could be released. What we don't know is the rate at which those works will be undertaken. So I don't think we can place any certainty on the Stodmarsh mitigation resolving the 5-year land supply position.
Well, no, I mean, we obviously went through that with the housing land supply and the sites that are
Indeed.
disputed and those that are reliant on that mitigation. But I'm talking
There is
more
still
here.
a shortfall of 1,700
Understood.
regardless.
But I'm talking here about longer term. This is a temporary constraint. We heard from Ms Marchant that there's around, I think she said 3,000 homes or so held up with a resolution to grant.
I'm not
Once
sure-
that mitigation, let me just finish. Once that mitigation kicks in, and those credits are available, a significant amount of planned development is then going to be released, isn't it?
Well, we don't know that, do we? We don't know there's a significant amount going to be released. Because
Well-
we don't know the rate at which the septic tanks are going to be improved. We don't know the rate at which the sanitary ware in the council stock, or indeed how many, are going to be improved, over what period of time.
I understand those points, which no doubt will be made in closings around kind of deliverability and so on, but thinking about this in the longer term and just in terms of what we know about the amount of mitigation that that contract is going to deliver versus the amount of houses, this is going to release a substantial amount of planned housing growth, isn't it?
At a point, but it isn't going to release the amount of housing that's required to remedy the 5-year land
No, I
supply
know, I
position.
know that. I know that that's a separate point. I'm asking you about longer term here.
At some point in the future, there will be a remedy to the Stodmarsh issue, even if it's the arrival of 2030 and the upgrading of the Ashford wastewater treatment works. None of that helps in the short term.
All right, let's move on because I'm very conscious of time and we're very much running out of time. Affordable housing, we can agree that the appellant's proposing a policy compliant level of affordable housing and not exceeding the policy requirement. As a matter of fact, that's the case.
As a matter of fact, and that's an important contribution.
And obviously all affordable housing is beneficial and is meeting a need. The more affordable housing, the greater the benefit. So a scheme that exceeded policy requirements, on balance, you would expect to get a greater weight than one which doesn't exceed. That's fair.
So that's fair, but that doesn't diminish the weight that the policy requirement aspect attracts.
No, and to be clear, we're not disputing that there is a need.
No, but you're disputing the weight that's given to it.
Yes, I know. Yes. I just want to pick up on one point with you and appreciate, this is obviously Mr. Stacey's got his proof of evidence, and you didn't write that. But my understanding of that is that he sets out various shortfalls against in affordable housing, and that's based on the Strategic Housing Market Assessment, SHMAR figures. And that, I think we can probably agree, is obviously based on an objective assessment. It's an unconstrained figure. It doesn't factor in matters of viability and deliverability and so on. It gives you an unconstrained need figure in the SHMAR.
It's been a while since I've read the SHMAR. So
I don't think you need to read it
I would
necessarily.
hesitate to give a categorical answer. But what it does do is identify the amount of affordable housing that should be provided over the planned period. And what Mr. Stacey has done is contrast what has been provided compared to that.
But
and there is a shortfall.
Yeah, that's kind of the point I wanted to get at, though, really, because the SHMAR is telling us what the overall need is, but it doesn't tell us what actually has to be provided. That's what the local plan then does.
My understanding is that the local plan adopts the conclusions of the SHMAR. The supporting text is based on the SHMAR. If there were points around this, I would have expected them to be put to Mr. Musk yesterday.
No, well, I don't know. Don't really know what to say to that, really. When it comes to setting a local plan policy or requirement, the question of deliverability and viability of delivering affordable housing obviously has to be taken into account in setting what the requirement should be. In this case, we've got the percentage requirements, but that's something that's arrived at looking at deliverability and viability, isn't it?
The policy is based on the evidence from the SHMAR. Because of viability and deliverability, the policy adopts different thresholds for different parts of the borough. The proportion of affordable housing to be provided in the rural areas is greater, and it compensates for the difficulties of providing the amount of affordable housing necessary in Ashford Town Centre and in Ashford Hinterland. And it's unfortunate that the major allocations on the southern edge of Ashford have not been able to provide a policy compliant level of affordable housing. So it amplifies the need for affordable housing to be provided on sites where it can be achieved.
In the local plan, can we just quickly look at PDF 26? It's just the point that I was sort of making, but set out in the local plan, that it says at paragraph 2.20, refers to viability evidence.
Sorry, where are we?
Paragraph 2.20 on PDF 26. In fact, I think we could probably just look at 2.21. Let me know when you've got it.
Yeah.
Yeah. It says in order to fully meet the affordable housing requirements identified in the SHMA, it would necessitate an increase in housing target of over 6,000 dwellings. It would require housing delivery hugely in excess of any annual level of housing completions the market has ever achieved, not realistic or deliverable scenario, notwithstanding the significant environmental implications of this scale of growth. It's just, I'm not trying to downgrade in any way the need. Clearly there's a high need, and clearly, it's telling us what it's telling us about the inability to, to meet that in a deliverable way. But it's just that when one is looking at shortfalls, it has to be borne in mind, doesn't it, the context that those SHMA figures are not figures that could ever deliverably or realistically be met, and the local plan doesn't require those specific figures to be met.
I'm sorry, Mr. It's me, I'm sure, but I don't follow the question. There is an identified need for affordable housing,
Yep.
which hasn't been met, and this scheme is bringing forward affordable housing. Without the appeal scheme, there would not be the 56 affordable homes.
Yeah, it's really just a context point that the appellant is relying on evidence that there are shortfalls of a particular degree against the needs set out in the SHMA. So I'm just putting to you that one has to remember when looking at those kind of figures that assessment is against a figure that is not realistic or achievable or deliverable. So to treat that, you can't treat that as being the requirement. Do you see my point?
I do follow the conceptual point, but I don't think that moves away from there being a requirement in the local plan that hasn't been met, a worsening of affordable housing, a worsening of of housing need indicators, and the appeal scheme contributing affordable housing that wouldn't otherwise be provided.
No, I mean, it may not be a great point, let's face it, but that is the reality, that the shortfalls that are identified. It's a context point that the inspector just has to bear in mind when she's looking at that evidence.
Sorry, I wasn't prepared for this line of questioning, so I haven't read the affordable housing
Sure. Okay. Well, look,
policy,
let's
the supporting text, and
yeah.
I'd understood Mr. Stacey's evidence to be agreed, and his conclusions to be accepted.
I don't. Well, we don't agree with the weighting, obviously, as you know. We're not disputing the need, as you know. I'm just trying to establish as a point of context that when we're talking about shortfalls, we just have to bear in mind that figure is not actually the requirement. That's all.
Possibly, but what we can't avoid, what's inescapable are the measures of housing need that are in Mr. Stacey's report.
Mm-hmm.
So it isn't simply about numbers. And it's that whole analysis that leads Mr. Stacey to conclude substantial weight. And none of that analysis, until today, has been questioned. I'm
not questioning the figures,
okay,
just to be clear. It's just putting it in context of that figure. But look, let's move on, because I think we've spent enough time on it. I think I will probably... Yeah, I'll leave the cascade point, I think. Exhibitions on that. The inspector's got the notes, and I don't think we need to go over that. Yeah, I'll leave that. We're nearly there, you'll be glad to hear. Biodiversity net gain. Just this point about the potential for trading of credits. So I just want to cover that off with you. I think it was put to Mr. Musk yesterday. There's no policy or law to bar the potential trading in BNG credits. That's obviously correct. In fact, it's the opposite, isn't it? There's developers would be positively allowed to trade excess credits. That is a factual position.
If there was a scheme registered,
Yeah.
and my understanding is that we would have needed to make that known, that we intended this to be a bank contribution at this point. And we haven't done that.
I'll have to go away and check that.
That's why I said it's my understanding.
I'm going to go away and check that. But
that's fine.
Let's assume that the position is that there is the ability to trade. There would be the ability to trade in the absence of a restriction preventing that. If that were the case, the trading of excess BNG credits on this site would then be the BNG delivered on this site would then be being used as a benefit for a different scheme. So that other scheme would then be able to provide less or no BNG off-site. That would be how that would work.
It would give rise, hypothetically, it would give rise to a different benefit. Because in the event that they were traded, it would be releasing a scheme that couldn't otherwise be released, that needed to provide off-site credits.
But that would be a benefit to that other scheme rather than being a benefit of this scheme.
Yeah, but this scheme is releasing that scheme in that scenario. That's why I say it's a different benefit, but it's a benefit nevertheless.
In terms of, I know it was being put yesterday, well, there's no evidence that the applicant has an intention to do this, but as we know, the appellant's going to sell the site to a developer, so it's really the developer's intentions that are material, isn't it?
But it depends what was
Hallam doesn't have an intention to do anything with the BNG other than provide a site with a planning permission.
It depends what was in the sales contract. If that prohibited trading, then it does have a control mechanism. This again is another new point that had it been a point of contention when the Section 106 agreement was being discussed, it could have been explored there. It's been brought to the floor of the inquiry in order to undermine the positive aspect of the scheme.
Okay, just a couple of final points, just to say I'm not going to go through the weighting of all the different benefits and the overall balance and things. So I think the inspector's got the position on that. I just want to touch on a couple of other benefits that you've referred to. Firstly, the location of the scheme, which you give. I'm just trying to find. I've lost your proof momentarily. 7.4. Yeah, you give substantial positive weight to the appeal scheme in locational terms. Just a bit puzzled by this. So you make a point, it's outside the Stobmarsh constraint. That's not a tangible benefit of the scheme, it's not a positive benefit, is it? I mean, it's the same way as saying, well, it's not in a flood zone, or it's not in, it's not in a national landscape. It just means that it doesn't have this constraint. That's not a positive benefit of the appeal scheme, is it?
The appeal scheme is located at a sustainable settlement.
Yeah.
Consistent with the spatial strategy. We've established that there are constraints elsewhere that preclude this housing being provided in those locations. So the fact the appeal scheme is here, in accordance with the one bit of the spatial strategy that is unconstrained at the moment, perhaps I'll rephrase that, the one settlement that is not subject to the constraints that are experienced at other higher order settlements or those equivalent to it. And in the context where there is a desperate need to improve the supply of housing land and affordable housing, the fact is that a sustainable settlement, consistent with the strategy, is a benefit. It is not being located elsewhere in a less sustainable settlement. That's the point behind that.
But surely, the benefit that you're speaking of there is the delivery of housing at this location, isn't it? It's really the benefit is housing delivery again. It's not the location itself, it's the delivery of housing.
It's housing in a sustainable location as opposed to housing at an unsustainable location elsewhere, inconsistent with the strategy. There's got the alignment with the strategy is important.
But then on the other hand, we've been through the policy position, and you've agreed with me that there are conflicts with HOU5 and also with SP2. So it's not consistent, is it, with the spatial strategy, because that is determined by those policies that tell us when or development will or will not be acceptable.
And this is where our respective positions rub up against one another. Because, to my mind, the fact that this development is at Hamstreet, with its characteristics, with its facilities, with its services, that is an important aspect of the appeal scheme. I understand the issue around narrow conflict with the development plan policies that we've cited, but when you look at it in the whole, in the round, as we're required to do, on balance, this is a location that leads to a sustainable pattern of development, and therefore that is beneficial.
But can we agree that that kind of turns on what judgment the inspector reaches about things like accessibility and access and all of that? So
absolutely. That doesn't ride roughshod over that consideration.
I mean, it is kind of double counting though, isn't it? Because it is housing delivery that you are relying on. It's the same houses that are in a sustainable place, the same houses that are making the contribution.
It's the spatial element and what derives from the spatial aspect.
Okay.
So in the same way as Mr. Musk takes points off us because of his view that the development will be wholly dependent on the car, we say the opposite. No. Sorry, dependent on the car. We say the opposite.
Okay. All right, I think we're taking that as far as we can. Last point, just briefly on economic benefits. It's right, Mr. Musk made the point that there's not any quantification. I mean, sometimes one sees in appeals some evidence put forward about the amount of GVA that's going to be generated, jobs that might be created, etc. We don't have anything like that here to quantify the scale, number of jobs, amount of
No,
GVA.
we don't have that quantitative analysis. That is not to deny that those benefits will arise. Mr. Musk accepted those benefits would arise. What's between us is not the fact that there are those benefits, it's the weight that we give them.
But in terms of it, when one comes to weighing it, we don't have any evidence on the likely scale of it.
Not the likely scale, but we know there will be construction, employment, and we know there will be expenditure in the local village.
And there isn't any evidence of any particular local economic need that will be met, or that there'll be existing facilities that would be ceasing to trade or operate or anything like that without the additional residents from this appeal scheme?
No. What we have is the vitality of the local community being supported. And we heard yesterday about the thriving community that there was.
Right, I think that's more than enough, Madam. Thank you very much.
Okay, thank you. Mr. Mohammed?
Do you want me to just go straight into it?
I think...
I'm fine, yeah.
Thanks.
I'll try and make this as painless as possible. Starting from this earlier this morning's evidence, this is in relation to the 800-metre threshold point, and I just wanted to just check something with you. Let's say the inspector were to accept that, just for argument's sake, I think you said I would caution against this, but let's say she accepted that 800 metres was a cut-off point. What would you say to her in relation to what policy and supporting text says about people getting in their cars, as we've been looking at the evidence, some people getting in their cars.
That the supporting text refers to it being an inevitability.
Yeah. And so in terms of Mr. Musk's position, what does he think about the fact that some people might drive?
He views that as unacceptable.
And when we were being asked questions about Mr. Musk's evidence and whether or not yesterday he was prepared to accept that some people might get in their cars, and my learned friend took you to the evidence to say, well, where does he say people will be wholly reliant? When you read Mr. Musk's evidence, what impression did you get about what he was saying in relation to car use, please?
Well, he says, on the one hand, that there won't be those routes, people won't use those routes, and therefore they will be reliant on the car. So if on the one hand they're not going to use the routes to access day-to-day services, the implication is that it is wholly reliant on the car.
Thank you. Just now, core document 3.8, this is the letter that was from KCC. I will deal with this in the closings, but I just thought I'd highlight a couple of points, please. You were taken in particular to 11, where you were being asked about the overarching view of sustainability on a proposal lies with the LPA. However, I have the following observations. Pausing there, how would you characterize a situation if we were at this appeal right now and we didn't have any comments or contributions from KCC at all? What weight do you think the inspector should attach to anything we might have to say about sustainability and highways impacts if we didn't have anything from KCC?
There would be a degree of uncertainty.
Yeah. And so when we look at this, when the inspector comes to make up her mind about sustainability, whether or not she decides that this question of the overarching view on sustainability lies with the LPA, what do you say about how she should note these particular observations?
They're plainly relevant.
And when we see the primary school is between 1 kilometre and 1.6 kilometre, the latter particularly is doubtful in terms of walking distances for small children. Two questions. We've already dealt with the question about the supporting text saying that some car use is inevitable. But insofar as some of those children, or children generally, according to Mr. Musk, being driven to the school, how would you characterise the journey that they would be taking?
Short.
And is that relevant to an inspector's consideration in terms of understanding sustainability and the approach to that?
Yes, because the fact there is a school present is material, because there are other settlements absent those facilities. And we heard Mrs. Withy, I think it was Mrs. Withy, who was talking about the number of pupils who are driven from the school from outside of the village because the catchment has been enlarged. The appeal scheme has the opposite advantage.
Thank you. Again, the train station D is another example of what the County Council is looking at, a difference between us and Mr. Musk. Approximately 1.2 kilometres from the centre of the application site, not walkable by some users, it is within cycle distance. Again, what does that tell you about other users and whether or not people will drive and how far that drive would be?
Well, firstly, it recognises it's a positive aspect. Again, that isn't an aspect that is commonplace or uniform. It recognises that it may not be walkable for some users. By implication, it's suitable for others. And again, it's a short journey. And the fact that the onward journey is then by a sustainable mode of travel is relevant.
Thank you. And then a series of questions about gradient, Fairfield Terrace, the transport assessment in particular, and the increase in the utilisation of Fairfield Terrace. Can I just ask you, and then the lighting and all the issues around safety. I'm going to take this quite slowly because I think this is quite important. Number one, have you seen anything from Mr. Musk where he has suggested, for example, I think you used the word segregation when it came to the Fairfield Terrace footpath. Has Mr. Musk suggested what he might consider to be an appropriate way of, for example, segregating the traffic in this particular location?
Not that I'm aware of, no.
Now, the car park that is, it might be worth actually, as we are walking through this, just to turn up the plan that we were looking at, the highways plan with the colouring. I think I want to say 3.8.
2.8?
2.8. Insofar as segregation is an issue, has Mr. Musk or the Borough Council suggested something that can happen in that regard?
No.
You'll recall, I think my learned friend asked you about the fact that we don't have any evidence around the use of the car park. Do you remember that?
Yes.
Or the frequency of the car park?
Yeah.
Who owns the car park?
The Borough Council.
And if there was anybody with any evidence as to its frequency use and who uses it and how it works, do you think they might have the evidence to support that?
They would certainly have evidence in relation to it.
And have they presented any evidence?
No.
Again, in terms of the lighting question, first of all, we established yesterday with Mr. Musk that we don't have a reason for refusal on highways.
Correct.
And he told us that he didn't see it. Well, I can't remember what he said, but he certainly agreed that he chose not to impose a reason for refusal.
Yes.
Now, insofar as there are safety concerns that we're being told are an issue, I'm going to come back to that because I wanted to go to the local plan. Let's stick with the plan for now. In terms of the lighting, we know what KCC has asked for in terms of lighting. Do you know whether Mr. Musk has asked for any more lighting than what's being provided?
Not that I'm aware of, no.
Has Mr. Musk suggested the appearance and signage and any other items that could make this acceptable to him?
No.
Now, if we just go to the local plan now, please. I did a quick word search on safety and security and lighting issues. I'll take it in stages. The first is to turn up, bear with me, TRA 7. TRA 7 you will find at
Yeah, I'm there.
page 252. You got that?
Yeah.
Sorry, no, 288. PDF 288 is TRA 7. Now, this is a policy that talks about the road network and development. Can you see that?
Yes.
And then it talks about safety and road safety in particular will not be permitted. Do you know whether this is a reason for refusal? policy that's cited within reason for refusal 2?
I don't believe so. No.
TRA 7, which is not cited in the reason for refusal 2.
No, it's not.
And then next, let's have a look at HOU 5. HOU 5, would going into this car park be categorised as a traffic movement?
Yes.
Okay. Beyond that which local roads could reasonably accommodate in terms of capacity and road safety will not be permitted. Applicants must demonstrate that traffic movements to and from the development can be accommodated and so on. If there were any safety issues on our access road, would you expect to see a policy that deals with safety?
See a policy.
Would you be able to, a reason for refusal?
Reason for refusal, yes. I
That
would.
deals with that?
Yeah.
And the fact that none was put on this case, how do you read that?
That the highway safety issues weren't an issue to justify a reason for refusal.
Let's look at SP6 now. SP6, and that's on PDF 54, SP6.
Yeah.
Promoting high quality design. You see that?
Yes.
You've had a back and forth with my learned friend about SP6A,
Yes.
character, distinctiveness and sense of place. Public safety and crime, have you heard that put to you as an issue for this case?
No, I haven't.
Which is?
And that's criterion E.
Yes.
And I think we agreed that, with the exception of A, we were aligned.
Thank you. And then a couple more policies, please. I promised to go to HOU 5, didn't I? Bear with me. Bear with me. No, S31 is actually the next one I want to go to. S31, please. And S31 you'll find on page 165 of the PDF, please. Are you there?
Yes.
S31 is a site in Hamstreet, and it has.
Sorry, is this something arising out of cross-examination?
Yes,
We didn't go
your
to that.
concerns about the fact that there's a safety issue and the lighting on the access road from the footpath that you spent a great deal of time asking about.
We didn't go to, well, I'll wait and see what the question is, but it's meant to be things that arise out of cross-examination. We haven't looked at this.
I've just
before,
explained
so-
how it rises. Can you see S31E?
Provide vehicle access.
And pedestrian access
From Ashford Road.
Ashford Road.
Yes.
And then the safety point that it raises, bear with me, 9.4, no, that's not that policy, bear with me. Bear with me. Bear with me. 306.
Page 306.
That will take you to 9.49. This is where it says there's an increase in demand of artificial lighting for safety, road schemes, etc., crime prevention, security lighting, etc., linked with the increasing demand has been on the rise of a number of complaints about obtrusive light received by local authorities. I only picked this on in the context of dark skies, but I just wanted to understand one thing. Beyond today and beyond the questions that you were asked today, have you ever come across the position that because of the lighting concerns that were being put to you today, were ever linked to Mr. Musk's case around safety and whether or not this area is considered to be dangerous, contrary to what KCC says?
No, I haven't.
And then 2 questions you were asked. KCC says this is not a high quality route. Do you remember that? That was being put to you.
Yes.
And then the immediate question after that was, the MPPF says that we should be promoting high quality development.
Yes.
Do you consider this development to be high quality?
Yes.
Next is in relation to generally about the policies. Have you ever come across a development that complies with all policies in a development plan?
Not a development such as this, no.
Court Lodge, what was the process of getting that determined?
Appeal against non-determination.
And that was that an allocated site or unallocated?
Allocated site.
Allocated site. And what was the council's position in terms of compliance with policy in Court Lodge? If you remember, in terms of compliance with policies.
By the end of the inquiry, there was a list of common policies that the appeal scheme complied with, and I don't believe there were any policies that were said it didn't comply with.
I could go through each and every one of your passages in your proof, but I'm not going to in terms of the various criterions and what you'd said. But in terms of your view on how the inspector should approach conflict with parts of policy and what that means for compliance with the development as a whole, can you just give us your view on that in one sentence?
Sorry, could you repeat that point?
I could go through all your policies that you were being asked about.
Yeah.
With offending, but your view and your pithy answer to the question to the inspector, non-compliance with parts of a policy and what it means for development as a whole, just your view on that, please.
To the extent that there is narrow conflict with aspects of policy, to my mind, that doesn't offend the principle of being able to accord with the development plan read as a whole.
You'd be pleased to know I'm not going to ask you about the glossary and conservation. Yes, again, there was a series of questions about a promoter, not a developer, or the examples that you'd given in the evidence and all the rest of it. Can you help the inspector understand what cases you've been involved in that were in Ashford for Hallam?
The scheme at Hamstreet, S31, and Court Lodge.
And in both of those cases you've been involved in, have you what has been the process of delivering it in short?
Secure the outline permission, disposal to a developer. Sorry, take a step back. Court Lodge hasn't reached that stage where the appeal is pending. So in terms of Hamstreet, secure the outline permission, disposal to a developer, developer takes on the scheme.
And do you get involved in the discharge of conditions?
I didn't at Hamstreet, but I have been involved and am involved in discharge of conditions elsewhere for Hallam on schemes which have outline permission prior to the disposal.
And you mentioned that Hallam is an owner of this site that we're dealing with here.
Not
the land.
Not the owner. They benefit from an agreement with the landowner.
Okay. And what's the relevance of that in terms of delivery?
There is a willing landowner, and there is a contractual position subject to the grant of outline planning permission to move that forward.
I'm not going to ask you about the letter about Southern Water. I'll make submissions on that. Stodmarsh, very quick question. you said it was temporary constraints since 2020. We're now in 2025, and we've just seen the various material that's been presented. Moving, first of all, is 5 years temporary in your view?
It's a long period of time that's elapsed without there being a complete resolution through a single mitigation strategy. What's come forward has had to come forward on a bespoke basis.
You were asked a series of questions about affordable housing, even though, as you say, I always understood it was agreed. Now, putting aside the point that was, I think the point was being put to you that the need from the SHMA that's contained within the development plan was never realistic to start with because of the various constraints. But just taking that point at its highest, the fact that this development is ready and willing to deliver, what weight do you think that should carry in an inspector's mind, notwithstanding the position on the SHMA and those questions?
Substantial weight, because it's a scheme that delivers towards that requirement.
And are you in agreement in that regard with Mr. Musk? In terms of his weighting?
You'll have to remind me where Mr. Musk arrived at yesterday.
I can't.
Prior to yesterday, no, we were not in agreement.
Okay, we'll leave it at that. Thank you very much, Mr. Jones. Those are my questions. Thank you, Ma'am, for your patience.
Thank you, Mr. Hammond. Thank you, Mr. Jones. I've got no questions.
No questions. Thank you, ma'am.
Okay, so we have the conditions. Can we just have a quick 5-minute break? Is that long enough? Yeah. Okay, shall we resume with the conditions then? Hopefully I can get through it reasonably swiftly, but I have a few questions. Right, so mainly I think some of them are unnecessary. If we start with number 1 and number 1 and 2, I think the planning inspectorate model conditions, we have some of our own conditions, we usually combine those two. So but on condition 1, details of access, and I know you put internal circulation routes only, and I'm probably being fussy, but I'd say that's layout. It's not the access, it's the access off.
I think the definition of it, I haven't got it in front of me, I think the definition of it does say something about within the development as well.
Does it?
Although
Okay.
obviously there is a massive overlap.
Yeah, I've had others take a different view, but anyway.
If it's any assistance, Farmer, I'm inclined to agree with your interpretation. Routes within the development are a layout matter, and this is one of the reasons why the description of development got amended, because access within the site is in relation to the highway network beyond the site. Ultimately, I don't think anything turns on it.
No. Okay. Well, if the standard pins condition doesn't say that, if access is approved, you just leave that out. But anyway, we can. Right. Condition 5 is the next one. I just had to read it again to remind myself what I said, because I prepared this quite some time ago. I just don't know whether it's necessary for it to be accompanied by a design statement. What do you think?
You'll recall Mr. Williams's evidence,
Yes.
where he was keen to secure, for the proper planning of the area, that there was a line of sight between the design principles that were in the design and access statement, which Mr. Withicombe recognised the value of those, and the reserve matters application. What he was concerned about is, without any linking mechanism, that someone is left to their own devices.
Linking mechanism, sorry.
So that the design statement is the link between the design and access statement and the reserve matters statement, in order to demonstrate how those principles have been taken into account.
Right.
I think if it helps, Madam, I don't think it's not something that we actively sought, but it's probably a matter for you to decide whether you think that's necessary or not. Really, you've seen Mr. Williams's evidence on it.
Well, yeah. I mean, you should keep conditions to a minimum as a matter of principle, and they should all be necessary and only imposed if the development would be unacceptable without it. And I'm struggling to see how the development would be unacceptable without all of these reports. It just seems like a lot of red tape.
I suppose it depends on your view of the landscape evidence, and if you think that the measures, or various of the measures that are set out, albeit it's illustrative,
Yeah.
but if you thought that those were very important, and it was only because of those things that you were to find, the effects to be acceptable, then maybe that's something that you would think you need to make sure that those things actually happen. Equally, you might think, well, there's enough control when it comes to discharging, doing the reserve matters. So I think you just probably have to form a view on whether you think is necessary.
Yeah, I just think if something's necessary during the course of the application, additional information can be required at that point. Councils can go back to the applicant and say, can you provide us with some more information? I'm not convinced it's necessary to have a actual condition, but I'll consider the points that you both make.
To assist you, I think the intention originally, and Mr. Musk will correct me, was to see whether we could give more assurance about the quality of the development that would come forward. That was
Okay.
really fundamentally what it came to. But
Yeah.
if it's not necessary, then it's not necessary.
That wouldn't stop the council, if the condition wasn't on, it wouldn't stop the council asking for further information. I'll think about it. Okay, let's see the next one. So condition 7 as well, those are all things that you'd naturally expect to come in with the reserve matters application.
Yeah, I wouldn't expect necessarily all of it would be.
Okay.
Things like the provision of level thresholds for all principal entrances. I think that's very important that that is included. I'm just looking through the list. And from my point of view, I think it would be important to be clear that we would expect details of things like the parking, the covered cycle storage, refuse storage and collection points. Those are all points that we will need to be provided, so I think it's helpful to clarify that those should be provided with the reserve matters submission to enable that application to be determined swiftly when it's submitted.
Right, I hear what you're saying. I mean, things like the refuse storage, wouldn't that just be the bin men?
I mean, it would depend on the layout. So some developments you have streets where the refuse vehicles won't go down, so it's useful to have the collection
Okay,
points
yeah,
there.
right.
So it does depend on the layout that comes forward.
All right.
Can I offer an observation?
Yeah.
Because we're in a situation where we can't have informatives, unfortunately. But what I'm keen to ensure is that when the reserve matters application is submitted, it has the right information that the council are going to require to determine it. I understand they could ask for that further information,
Yeah.
but that then causes a delay. So
Yeah.
by being clear and precise as to what information is going to be required for the reserve matters approval, I think it helps all parties. And I've certainly
Okay.
got experience of a similar condition, which specifies the expectation in terms of reserve matters.
Yeah, I hear what you're both saying. I mean, I think this is more informative territory, to be
Unfortunately,
honest.
yeah.
But I hear what you're saying.
We can have a gentleman's agreement, Mr. Musk and I.
Right, okay. Where am I up to now? Yeah, okay, I'll go to number 8. Again, it's the same thing, so I won't discuss that again. It's like they're not really requirements. They're just telling you what we want to see in the application. Do you know what I mean?
I understand the
it's
point,
the same
yeah,
condition. It's the
yeah.
same point. So I'll skip through that. Right. So number 9. Yeah, again, I think it's the same thing. Reserve matters have got to come in for landscaping anyway. But you're kind of saying what you want to see. It's kind of more of informative, but yeah. Right. Okay, the affordable homes one. Right. So that's connected to the section 106. Yeah, I don't have a big problem with that. I'm not sure, is it necessary if it's in the section 106?
It's not just
Is it?
affordable, is it?
No, it's got the, right, okay. The location of, yeah, the M4 and 2, yeah. But it's a bit like the previous discussions about the information that's coming in. Right, I can skip through that, if that's all right. It's probably the same discussion we had before about information.
Sorry, Madam, just checking that it is actually the same point and that there is not some other reason to have that.
Yeah.
We think it probably is the same point of things that would be covered in reserve matters.
Yeah, okay.
Just wanted to be checking because we don't want to kind of inadvertently scrub something
Sure.
out the conditions and then it's not actually somehow needed as reserve matters.
Yes. I think there's an overlap as well with the section 106.
So probably in relation to affordable and the tenures and so on, yes, but not
Yeah.
not for the others probably.
Yes, okay.
Yes, I think the Section 106 agreement would deal with the number, mix and tenure of affordable homes proposed as what we class the affordable housing scheme.
Yes,
And the layout of those would be on the affordable housing plan, which is also secured in the 106.
yeah.
The 106 would also deal with any building regulation M43, I think it's M43A actually, which is the wheelchair compliant build, because those would be identified pursuant to the Section 106. But the accessible, is it, can I remember if they're the accessible or the adaptable, what's classed as M42 building regs, that's 20% across all of the development. That isn't just restricted to within any of the affordable units.
Yes.
And so that wouldn't necessarily be captured on
No.
a plan or in a scheme.
Yeah. Okay. Right. Condition 11, construction and transport management plan. Okay. Right, so, yeah, no, that's fine. All right, now I'm on to number 17. I'm just trying to work out what what I mean in my notes. It was something about, I thought something didn't quite make sense. I just want to check what it means. Oh, right, I think I know what that means. I think it was just the bit, the car park and the highway. I think what you mean by that, you want the details of the stepped access and the other access through the car park. That's basically what it's asking.
Exactly that,
Yes.
yes.
Right.
And obviously we need to be mindful that PO7 of the pedestrian route to Fairfield Terrace, that may well become PO8.
Oh, right, yes. You have, right. So it probably will become PO8, then,
Yeah.
will it?
Yeah, we'd need to cross-refer that to the 106 as well, because I believe that was an appended plan to the section 106 in respect of the
yes.
improvements. So we'll need to make an amendment. I think my colleague, Mr. Humphrey, was contacting your solicitor this morning.
Right. Okay. Yes. Thank you. Yeah. Right. I'm on to 19 now. Yeah, the surface water drainage system, and you're asking for a verification report to say that it's all been done properly. I haven't seen such thing before. I've never seen that condition before. Would it not be building regulations that deal with that?
Sorry, I'm just checking the origin of that, whether that was the flood authority that requested that. Sorry, I didn't hear your question. Sorry.
Oh, right. So, yeah, well, I've not seen a condition asking for a verification report that the surface water drainage system has been installed. It's usually, the condition is normally the surface water drainage system shall be installed and retained. So I haven't seen the verification report, and I'm just wondering whether that's normally a building regs matter, and if they didn't but if they didn't install it, it would be an enforcement job, wouldn't it?
Yeah, potentially. I mean, it would be an enforcement matter if they didn't do it. It was requested by the flood authority.
Okay.
It is something I've seen multiple times.
Is it? Okay. Maybe it's in this part of the world.
Maybe so.
I was just about to say, I've seen it previously in
Have you?
Ashford, yeah.
Okay. All right.
It's also something you see across other parts of Kent.
Yeah.
Yes, Kent being the LLFA, yes, yeah.
Right. Okay. Well, I've not done any work in Kent before, so.
I think it's probably partly because obviously some of that's going to be pretty hard to check potentially. So I think it's sort of that extra layer of
Right.
assurance that it has actually been done, because it's not something you can necessarily go on site and easily see what drainage has been put in and so on.
Okay. That's a reasonable explanation. I mean, you get that with contamination verification reports. Right, on to number 20 about the foul water sewage disposal strategy. I'm just not clear what this quite means. I'm just wondering whether it could be made more simple, like something like no development shall commence until the developer has provided confirmation from Southern Water that there is sufficient capacity in the network, and no dwelling shall be occupied until it has been connected to the foul sewage system, something like that. I just don't know what the strategy, what this means about foul water sewage disposal strategy, and how much the appellant, how much a developer has input into that, if it's Southern Water that deal with it.
There will be an element of on-site sewer infrastructure, including the pumping station.
Yes.
And then there are the off-site reinforcements.
Right.
The strategy, as I understand it, is intended to tie all of those things together
Okay.
in the context of the hydraulic modelling and the flow analysis that Miss Dring and I were talking about. And critically, it sets the implementation period associated with it, and that's important then in terms of the occupation of the development.
Okay, so I didn't understand how the occupation of the development will align with the delivery by the Southern Water, so that just means the timescales.
Yes.
Right.
Yeah, and I think, do you
we can
remember
perhaps work on the language.
Mr Jones referred to in the letter, sort of suggests that it might be possible for some dwellings, once they've kind of gone
Yes.
through everything.
Yeah.
So there might be a kind of phasing of delivery depending on what's done when, so I think
Yeah.
it's to cater for that.
Okay, right. I'll just make a note there. I was confused by the align with the occupation. I was wondering, do the residents have to do something? I wasn't quite thinking that, but, you know. Okay. And then you want a verification report in condition 21, so that presumably that's like the same thing as the...
Yeah, it's the assurance, and
Yes,
we've heard lots of concerns about the adequacy of the network.
yeah,
So it's that level of assurance that what was intended to be provided has been provided and is working.
right, yeah, okay. So the next one, 22, is quite a long condition about tree protection. I couldn't find a tree protection plan anywhere, so I don't think one's
there's no
been
trees.
submitted.
If I was being facetious, I said there's no trees. I'd
There's
take
some on
the,
the edge.
yeah. I take the point about the length of the condition.
Pins have got a standard one, just ask for a tree protection plan.
I was going to suggest that, yeah.
It's short,
Yeah,
it's
yeah.
quite short,
Yeah.
yeah. Right, just look at the archaeological one now. Oh, that's okay. 24. Oh, I didn't understand this one. Heritage interpretation. So conditions got to be precise, so I don't know what this is asking for.
This was requested by KCC's archaeologist.
Right.
I can find the consultation response and try and give you some more information.
Do you know what they wanted?
Yeah, essentially it's interpretation boards. This is the archaeological value. This is what you can see.
Yeah.
I can understand, and I have raised this point with Mr. Musk. I can understand why it's needed on other sites where there is below ground archaeology, where it is important to have interpretation of what is in the ground. But we're not in that situation here. But the
No.
answer is it's Kent County Council's standard response.
So this presumably relates to the Royal Military Canal? Or is there other archaeological... There isn't...
No, it would relate to the canal, yeah.
Yeah, I think it's the Second World War pillboxes
Oh, the
as well,
pillboxes.
and important archaeological landscape features.
Okay, well perhaps it's some rewording, but a scheme of heritage interpretation. It's just a bit of a weird phrase that it's just not really that. I like things to be in plain English.
I think it's one of those things that kind of people know sort of what it means.
I think the
but-
archaeologists know what
Yeah.
it means. Perhaps less so us.
Again, only in Kent.
Yeah. I have seen them, and I have seen the condition in York, which is very
yeah, right.
but that was it was a sign basically.
The same.
Yeah.
Yeah, that's what it is here.
Okay.
So I've just
Yeah.
pulled up the relevant bits. So they say in their consultation response, in recognition of the local significance of the World War II military foci on Hamstreet, I recommend a programme of heritage interpretation, measures such as artwork, landscape design and/or information boards would contribute to raising awareness, appreciation and enjoyment of Hamstreet's heritage.
Okay. Right. Right, okay. I mean, where I've seen it before, it was a very different situation. I'm not sure whether it's necessary to make the development acceptable.
No, I agree.
Yeah,
I can appreciate that, yes.
okay. Yeah, lighting, that's all right. Contamination. Yeah, that's all right. So you've got the contamination as 2, because then you've got the unexpected contamination, which is fine to require both things. The PINS condition just rolls it into 1, but I mean that looks all right.
No, sorry, so you're lucky to only have 2, I think, because it seems to always be one of those ones that's got tons of different conditions all kind of doing the same.
Yeah, they can be very long as well. Yeah. Okay. Oh yeah, this is one I really don't understand. It's the soil management plan. What's that all about? I'm not saying there's anything wrong with it. I just don't know what it's about.
It originates from the agricultural soils report, because clearly there's going to be an element of earth moving across the site. Some of it is BMV 3A. In those instances, the recommendation from the consultant is that there's a soil management plan that adopts husbandry techniques in order to retain the ecological value of the soils.
Okay. All right, I understand. And so if you moved it to another place,
It's how you move it to another place.
so, but is this within the site? Move it to another.
Within the site, yeah.
Yes, and so it might be used for a particular part of the open space.
The green infrastructure,
Yes.
yeah.
Okay.
So that you're retaining the forget what the ecosystem. That's the ecosystem value of the soils. The husbandry techniques, when you move the soil, retains that. So it's not being trampled, it's not being condensed. It's those types of things, I understand.
Right, and so what would it be used for ultimately?
It's retaining, wherever possible, the soil value on the site. So it's not harming the soil, but it's being reused.
Right.
I can tell you're not persuaded, Mum.
Sorry?
I can tell you're not persuaded.
Well,
Well, I don't understand it.
No.
So I don't know if anyone else finding it.
I can understand it if you're going to use this land for agricultural purposes again,
Yeah.
but I don't think that's the intention.
That's not the intention now.
Were you proposing some allotments in the open space?
Orchard,
Okay, orchard. Maybe it could be used there.
maybe.
Right. I'll go along with it.
Husbandry is the new word for me.
Have you not heard that?
Okay, we're on to 29. We're getting there. Oh, I think this is another one which the wording perhaps confused me. Right. I think I'm just a bit confused as to what's been required by this condition. So there's a an energy and sustainability strategy report to reduce energy consumption, which has been submitted. And then this condition is asking for the provision of various measures, but I'm not sure it's quite precise in terms of what measures. I'm just a bit confused by what they're actually asking for here. Does anybody know?
It's your policy. The council has the council has supplementary planning guidance relating to climate change.
Yeah.
And it requires new developments to provide, in essence, 3 elements of infrastructure. Photovoltaics, EV charging points within associated with the dwellings, and water butts.
Yeah.
So the details of those elements of infrastructure ultimately can only come through the reserve matters.
Yes.
It's the condition is essentially requiring and ensuring that those details are provided at the reserve matters stage. Now there is a question about whether it's photovoltaics or whether it's air source heat pumps, because the Brookbanks report that's referenced, when it calculates how it gets the carbon emission reductions to equate to the building regulations, the future home standard and the reductions in the building regulations, it suggests that it can be achieved by either of those means. So whereas the SPD is focused solely on one element, photovoltaics, it's possible to achieve it by air source heat pumps or a combination of the two. So that's why you see the reference to and or. But ultimately it's a condition that's requiring those details to be provided because the SPD effectively requires those as part of a reserve matters application.
Right. Okay. I mean, I understand that. It's just that.
Sorry.
No. Thank you for that. I mean, I understand that now you've said
Right.
it. I don't mean to be, but what you said was wasted. But what my concern is, it's not really sort of. It doesn't say. Does it include it for every dwelling, or it's kind of it's not precise. Do you know what I mean?
I do, yes. I think it wasn't possible based on the document to be more precise.
No. What about a general condition asking for details of energy saving measures outlined in the report, to be submitted and approved in writing by the local planning authority? So we're still cross-referencing back to the Brookbanks report, but it's just more, I don't know, it's...
Yes, I think if we could link it to the climate change guidance document that we have, that would be helpful as well.
Okay, is that in here?
Yeah.
Is that, where's it? That's in the reason, it's not in the condition.
Yes, so if we could make it clear that the expectation is it includes those measures, that was the difficulty I had, just trying to ensure those were incorporated in the submission.
Right.
I imagine the Borough Council's concern is if there isn't a condition requiring the provision of those things, then there is no requirement for the reserve matters to provide them.
Exactly that, yes.
Yeah, I agree, yeah.
We can suggest a simplified version that essentially achieves the same, i.e. there is a requirement in due course, if you feel that would assist.
Maybe. I mean, but it does say this shall include, so I guess it's kind of general. It's probably all right.
I think we felt it was a compromise position to get in there what we needed, but I do appreciate it could be more precise, but given what we have, I don't see it's possible to be more precise.
Well, it requires a strategy to be approved, doesn't it? So yeah, then it's up to you. It would be up to the council then.
Can I just stop you there? I don't think
Yeah.
it requires a strategy to be approved. I think it requires the plans and particulars
Yes.
submitted with the reserve matters to include measures.
Yes. Sorry, that I would kind of call that kind of strategy.
Okay.
But I know, yeah, I know what you mean. It's yeah.
It's been a long day.
Yes, it's the details.
Yes,
That's what
yeah.
I mean. The details.
If you prefer details to plans and particulars, that it achieves the same thing.
Okay. Yeah, the again, number 30 about the details measured, about the minimise the risk of crime. I'm not sure that's necessary. Not that I'm saying that crime is not an important thing that you would consider, but you would consider that anyway when you get a layout. And that, again, it's a bit more like the informative thing. Yeah,
Yeah.
okay. Right. Oh, number 31. I liked the the wholesome one. What's wholesome? Has it got fluoride in it? Sorry.
That's a standard condition. It's not my wording.
Yeah.
I'm glad you said that.
Okay, I have seen that before. It might need some rewording slightly to get rid of the wholesome, because that's a bit weird. But the principle of it, okay. It's just basically to save. It's water saving measures. That's quite a standard thing. Yeah. 32. So you particularly want it to be high speed, wholly fibre broadband. Is there a connection? Do we know that that's available in the area? Because some areas don't have fibre. I'm just wondering whether it should just be broadband, a broadband connection.
Yeah, unfortunately, I don't know whether there is that connection available around this area. Again, we have the policy relating to this. I think it would be good to have its fibre broadband if possible.
Yeah.
Yes, but I
Just
don't
without
know.
knowing if it's actually provided, it's
Yes,
just.
I can look into that if that's
The
helpful.
get out to solve the conundrum.
Okay.
Not in. Let's not do it. It comes later on in it's the third line up of of that first paragraph. Unless sufficient information is provided to demonstrate that it's not feasible. So if it wasn't present, it wouldn't be feasible.
All right.
Yeah.
Okay.
Sorry, I hadn't seen that
That's
bit, but
all
yes,
right.
that in my mind that would cover that point off.
Fair enough. Thank you. Right, the services plan. I think, is this trying to avoid these polls that are very controversial? I can see your concerns there, but you know that you're not supposed to remove PD rights unless there's good reason. So if you can just give me a reason why a good reason, like a landscape reason maybe.
Yes, well, I think we would like to see these. So I'm just reading again the condition. Yeah, we would like to see these provided underground during the construction of the development. That means there's no requirement for them to be at a later stage. So,
Yes.
And the removal of the permitted development rights would be, as you say, landscape and visual reasons
Yeah.
for doing so. So if we can incorporate that at the construction of the development,
Okay,
that's best. So that's the intention of the policy, of the condition.
right, thank you. Okay. All right, the 34 is okay. Oh, right, there's actually 30. I thought there were 36, but there were 34. Right, that's the end of that. Right, not too bad. Timing, I mean.
Ma'am,
Right.
on the opening day, you asked about a condition identifying approved plans,
Oh, yes, yes.
and you were going to think about it.
Well, I was, and I kind of thought about it throughout. And I think the plans, I should have asked now, but I think the plans are referred to throughout.
They are.
So I don't think it's 100% necessary to have a specific one. Happy to add one in, but
That's the view that we arrived at.
Yes.
Is because they were specified in individual conditions, having a condition identifying them as approved plans would simply be duplicating that.
yes.
But if you felt it was necessary, there is no difficulty drafting one.
No, it's fine,
No,
thanks.
fine.
That obviously went out of my head, so that's fine, thank you. Right, okay, we've not made too bad time, actually. So only 8 minutes past 5. I've got to get my hire car back before 6, but that's okay. I'll be able to do that. Right, okay, so thank you everybody who's been involved, and thank you to the person who's been live streaming it as well. So the next, it was Thursday at 11 o'clock. Friday, sorry, I have written it down, I wasn't going to turn up, but right, Friday at 11 o'clock online for the closings. And so until then, we shall adjourn.
I'm sorry, just
Yeah.
to ask the council, they'll be arranging the link. And you'll be sending that across, and then it might be worth also sharing with the local community as well.
Yes, so what the plan will be, rather than using the gentleman who's been helping us out here, we'll be using Microsoft Teams. We'll set it up that way. I'll send an invite round. Mr Jones is, I can see, grinning because I've asked him already to provide me email addresses of participants, and he very kindly acknowledged he had forgotten this morning, but then was reminded. So I'll get that set up. Ma'am, I'll provide an invite to your case officer along with some instructions as to how that invitation can then be passed to you so that you're anonymised in that process. And that's what we did previously, and it worked very well with one of your other colleagues from the inspectorate. So that will be the plan. I'll get that set up
Thank you.
hopefully tomorrow afternoon.
Okay,
And that should come through to you.
right. Thank you very much. Right, thank you.
And apologies, because Mr Mohammed did say as well about the public. So we've been keeping a note on the council's website of proceedings and access to the core documents, etc.
Yes.
So we'll put a note up explaining that the closing sessions will be live streamed remotely on Friday from 11 a.m, and we'll provide a link where they can then watch that as well.
Yes, thank you. And I did see that you put the site visit arrangements up on the website as well, so that was all very good, well organised. Thank you. Is there anything else from anybody? No? Okay, all right. Thank you. So see you, was it Thursday? Friday. That's so late. Right, thanks. Right.